Good morning, folks. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, August 7th. It is 9 a.m. We will start with the roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Robbins.
Here.
Mr. Chair, you have 4 commissioners present.
Great. And 4 is a quorum. Our agenda today starts with the final work on the Lowry Comprehensive Area Plan 221-000-282. I would note for the record that Commissioner Oath is excused from participation in this because we undertook this before she became a sitting commissioner. And so the 4 of us will deal with that, and then we'll bring in Commissioner Oath for the remainder of the agenda a little bit later on this morning. So we start again with this agenda of 221-000-282. Before we get to that, we do have one member of the public that signed up for public comment. And we also have commissioner comments. Does any commissioner have comments for the good of the cause? And while we're doing comments, Mr. Thomas, if you could see if you could find Vinya Malik as a public commenter. Go ahead, Commissioner Messner.
Thank you, Mr. Chair. Just wanted to announce that there is a Colorado Produced Water Consortium meeting this Friday starting at 9 a.m. It's a virtual meeting. We'll be taking public comment at that meeting as well as reviewing some draft deliverables that are upcoming. And so encourage folks to go to the Colorado Produced Water Consortium website if you're interested in participating, sign up for public comment, and join us on Friday.
Great. Thanks, Commissioner Messner, for the continued efforts on the Produced Water Consortium. Others with comments? All right, seeing none, were we able to find our public commenter?
Currently, we were not able to find Vinay Malik. If you are in the attendee list, please raise your hand and we can elevate you, but no sign at this time.
All right, let's go ahead and raise the attorneys for the Lowry CAP. That's Ms. Jost and Mr. Foote. And if we could, I'd like to go ahead and also raise Crystal Corenda, the Minerals Director for the State Land Board. Good morning, Council. I've got a few questions for Ms. Corenda here in a second, but before we do that, let's acknowledge your existence. If you could indicate who you are and who you represent for the record. Ms. Jost?
Yes, thank you. Good morning, Chair. Good morning, everyone. Jamie Jost, along with Kelsey Wazzalinki for Crestone Peak Resources Operating LLC.
Mr. Foote?
Good morning, Commissioners. Michael Foote on behalf of STAR.
All right. All right. The order of play this morning, if I've got it right, and I want to confirm this with you, is that you each have closing argument followed by deliberation. I have a few, having gone through my notes, I have a few questions for the State Land Board witness just to sort of supplement the record. So I'm going to go there first. And if you guys have any follow-up following these questions, or if commissioners have questions, that's fine. And then we'll procedurally speak about closings and then deliberations. Does that work, Ms. Jost?
Yes, sounds great. Thank you, Chair.
Mr. Foote?
That's fine. Thank you.
All right. Thanks, Ms. Corenda, for being with us again this morning. Appreciate it. You spoke sort of at length about the lease that is at issue in this Lowry CAP. I wanted to kind of refine the questions away from the lease and just get some information about the State Land Board and its ownership of state lands and its trust obligations to the state in terms of what it is required to do. I think it's via the Constitution relative to its ownership of lands and the generation of money for schools, et cetera. Is that something that you could speak to?
Yes, I can, but I think I'm more of an expert on the lease, and just in an effort to not misspeak and say anything wrong, I think I'm gonna punt that to our director. I know that he's listening, and our director, Bill Ryan, can definitely speak to those questions.
Okay, is he with us?
He should be, yeah.
Mr.
And if
Thomas,
not,
can you-
then I'm happy to try.
We're promoting
Thomas?
Mr. Ryan right now.
Okay, thanks. You're muted, Mr. Ryan. Good morning.
Good morning, Commissioners. I'm Bill Ryan. I'm the Director of the State Land Board.
Okay, did you hear my question to Ms. Corrinda? Or
If you
not-
wouldn't mind re-asking, that'd be great.
Sure.
Thank you.
Ms. Corrinda did a great job of providing us information and perspective around the lease that is at issue on the Lowry Ranch for the minerals. And we understand it was entered into some time ago, before the homes near there were developed. I wanted to have a different line of inquiry to State Land Board relative to who it is, how it is that it owns state school lands, what its obligations, and I believe the constitutional, are with regard to utilization of the lands, what it can and cannot do. Can it allow lands to remain sort of fallow? Does it have obligation? Sort of that kind of whole thing of it, like, what is the State Land Board and what are your obligations via the either statute or constitution relative to the lands that are entrusted to the State Land Board?
Thank you, Commissioner Robbins. I appreciate the question. The Land Board was created at statehood. In the Enabling Act, lands were set aside to support the common schools, and the duties of the Land Board were laid out in the Constitution, Article 9, I think. Basically, the commissioners are fiduciaries for a trust that was endowed with land and charged to manage that land to earn income to support the common schools. So you should think of us like a giant leasing company. We own a lot of land and minerals, and we lease it to operators to generate money that supports the common schools. The way that support gets directed is statutory, not constitutional. The legislature directs that our dollars go to education purposes. And the way that's worked for the last 15 years or so is that 50% of our operating revenues go to support what's called the BEST program. It's Building Excellent Schools Today. That's basically the capital construction fund for the State Department of Education. Additionally, there is a financial component to our trust, the financial assets that are held by the treasurer. That's called the permanent fund. And all of the income from the permanent fund every year, it's invested in stocks and bonds and things. All of that income is also distributed per statute to support the schools. Some of it goes to BEST, some of it goes to the School Finance Act. So that have I answered your question there? It's a constitutional and statutory obligation to be fiduciaries for a trust. The beneficiaries of that trust are the common schools, and the distribution formulas to the schools are set by the legislature.
Okay, and you entered into a mineral lease a decade or two ago. I can't remember exactly when it was, but it was a while, for the production of minerals, which will result in royalties to you, I assume. And then that money is distributed to schools vis-a-vis what you just indicated. Is that right?
That's correct. This lease was auctioned back in 2012. We received a bonus and royalties from the winning bidder And all of those dollars go into our operating income that are distributed in accordance with the formula I just described.
I don't know if you know this, this may be speculative, but another utilization of the Lowry Ranch would be to, I don't know, put in 18,000 homes on the ranch. It's a beautiful big piece of vacant land. Is that contemplated by the school board?
Not at this time, no. There are lots of uses of the Lowry Ranch. There's, of course, this oil and gas lease. The surface is managed by a rancher, so there's cattle and ranching operation on the surface. There's a model airplane club. There's a small quarry. There's solar gardens. There are transmission lines. There are all sorts of uses. I mean, this ranch is 26,000 acres and 40 square miles. But some of it is presently still constrained by unexploded ordnance. I don't know if Ms. Coranda was able to explain its history, but at one point it was a bombing and target range for the Air Force, and so there's still there's unexploded munitions out there as well. That's only on portions of it, but we don't have any plans today to use it for residential purposes, but that doesn't mean that couldn't happen a generation from now. Again, we're an intergenerational trust. We've existed since 1876, and we need to continue to find ways to generate revenue for future generations of school children. So perhaps that could happen someday.
But at this point in time, and I assume the State Land Board is a board with appointed folks that are the decision makers, is that right?
That's correct, Commissioner Robbins. We are a commission with 5 board members, 5 commissioners. Each has a different experiential background. That's all spelled out in the Constitution. The 5 commissioners are appointed by the governor and confirmed by the Senate. They serve 4-year terms, no more than 3 from any political party, and there's an attempt to achieve geographic diversity around the state. So that's the governance construct.
Okay, similar to our governance construct. Okay, I think that's helpful for the record. Now, we now have kind of an understanding of the mission of the State Land Board with regard to its properties, as well as the particulars of the lease for this. First, I'll recognize any other commissioners that may have questions for either of the witnesses. Commissioner Ackerman.
Thank you, Mr. Chair, and thanks for being here, Director Ryan and Ms. Coranda. I'm grateful that you've joined us this morning. And Commissioner Robbins, Chair Robbins' questions were focused on the financial part of your mission. I also understand that you have a dual mission and that land stewardship is part of your mission as well. Could you elaborate just a little bit on what the State Land Board does with regard to land stewardship on the Lowry Ranch, but also on its other properties?
Yes. Thank you, Commissioner Ackerman. The Land Board does have a dual mission. It's to generate income for the schools, but it's also to take good care of those assets so that they can support future generations of beneficiaries. It's captioned under the heading of stewardship. So our constitutional mission also requires us to be good stewards of the land and take care of it so it can produce income for future generations.
And I know on that lease specifically, the board in 2011, when they were creating this lease with all of the different parties that I originally discussed, like the Nature Conservancy, CNHP, Colorado Natural Heritage Program, CPW, Arapahoe County, when we brought all those parties together, it was under the thought because they wanted a stewardship strategy. So this lease in particular, they did go above and beyond having all of these parties collaborate to create the lease. And then the parties at the time created a lot of stipulations and different methods that were really new and novel at the time. Some of those have now been adopted in your current ECMC regulations, but they were kind of ahead of the game back in that time. And then in general, stewardship wise for oil and gas, we do a really robust evaluation process prior to leasing any property. And we try to identify any sort of biologic concerns ahead of time and then write special stipulations to ensure that things are being protected. Again, to protect the land. And as Bill said, it's a working definition of stewardship, just so we can be able to earn revenue for future generations. Did that answer what you needed?
Thank you. I appreciate the response. Yes.
Yeah, thank you very much. Other questions from commissioners? Ms. Jost, any questions for the witness that we brought back to the table?
Thank you, Chair. No questions.
Mr. Foote?
Yes, thank you, Mr. Chair. I have a couple questions for Mr. Ryan, if that's okay.
Yeah, that's fine.
Thank you, Mr. Ryan. Thanks for joining us. My name is Michael Foote. I'm representing the Save the Aurora Reservoir community group in and around the Aurora Reservoir, and that's a party in this proceeding. I just wanted to clarify something with you about the State Land Board's mission. You talked about the mission, but that doesn't mean that you can use the land in any way the board thinks appropriate, right? Like it's subject to other state laws and to be consistent with state laws. Is that correct?
That is correct, Mr. Foote. The land board has an obligation to follow all local land use regulations and any other regulations. So anyone who gets a lease with us still has to go get whatever permits are necessary from the local municipality, from the ECMC. Yes, you're correct.
Right. Okay. And so if the local government or the whatever agency that the permit's in front of ends up denying that permit, that's not a violation of the State Land Board's mission or rules or anything like that, is it?
You're correct. That is
Okay.
not. We are subject to local land use control.
All right. Thank you. That's all I have.
Great. Okay, thank you both for being present. I think that's helpful. We'll let you go about your regular duties, and I will turn back to Ms. Jost and Mr. Foote for next steps. All right. Somewhere I've got an itemization of time, and this has to do with closing arguments, which I think are up next. Ms. Jost, you have a ton of time, like an hour and 50 minutes, and Mr. Foote, you've got like 12 minutes or something like that. I would encourage both attorneys to try to undertake their closing argument in about 15 minutes. I think that should be sufficient to get the points across. Obviously, Mr. Foote, that gives you an additional 2.5-ish minutes. And Ms. Jost, that constrains your time. I'm not gonna put a clock on anybody. I'm just suggesting that good lawyers can make their points across within that period of time, generally speaking. So that's just a friendly suggestion. Mr. Foote, that suggestion gives you a few more minutes, so I assume you're okay with that suggestion. Ms. Jost, I'm sure if I ask you, you're going to want to have more time, but I'm not going to ask you. So with that, I would recognize Ms. Jost first for closing argument, and then we'll recognize Mr. Foote, and then we'll proceed. Mr. Thomas, did you have something?
Yes, Mr. Chair, pursuant to the pre-hearing order, Star is slated to go first, so that Crestone, as the applicant, has the last word.
That makes sense. Thank you for the correction. Mr. Foote, you are recognized.
And Mr. Chair, just to clarify, I believe that we were slated more like 19 minutes, but of course, we appreciate the chair being not timing that to the exact minute so that we can make our case. We really appreciate that.
Yeah, again, I'm not turning a clock on. We want to hear you guys out.
All right, give me a moment. I'd just like to share my screen. Is
Yep.
that coming up?
It is. It's not in presentation mode just yet.
How about that?
Now it is.
Okay. Great. Well, first of all, thank you very much, commissioners, for your attention throughout this process and your diligence and your informed questioning throughout this hearing. The picture in front of you is a picture of what STAR wants to protect. That's their mission. It's to protect their community. And in fact, it's not all that different than your mission to protect public health, safety, welfare, the environment, and wildlife. Yet Crestone, unfortunately, has been trying to marginalize STAR and misstate its focus, excuse me, and mission throughout this proceeding, claiming STAR is some kind of fringe activist group made up of a small number of vocal people who are just merely fear-mongering and nothing more. This is just an attempt by Crestone to distract from the fact that it is proposing a large-scale industrial development around the Aurora Reservoir and surrounding neighborhoods that simply isn't protective of the area. STAR has formed as a natural reaction to that, and Crestone has made the decision to try to plow forward and attempt to marginalize its opposition in response. Unlike what Crestone's public health contractor testified to on Friday, it's common knowledge that this kind of development will have adverse impacts on the surrounding area, including adverse air pollution impacts. And let's face it, the company that wants to put in this large-scale industrial development doesn't have the best track record. It picks up emissions violation after violation with the APCD. Some of its developments in other communities have seen large amount of blowback, health issues, complaints, and broken promises. We can see Crestone has not turned over a new leaf with this proposed development, as it's following the very same pattern with its site-specific applications in Arapahoe County. So when members of the surrounding community have educated themselves about Crestone's plans, they have good reason to be concerned. What they see is a cap that, if approved by this commission, will lead to immense negative impacts throughout the area, and it's not protective. It isn't protective when it comes to noise, the landfill, water, emissions, emergency response, and wildlife, among other things. It also has a proposed location in Sunlight Long that is particularly problematic. First, you heard right at the beginning of this hearing, and even a little bit about it today, the history of the Lowry lease. Some commissioner questioning of the State Land Board representative touched upon the fact things are a lot different in the area now than they were when the lease was signed in 2011. This picture in front of you shows the large amount of residential development that has occurred since the 2011 lease was signed, especially in the southern part. And here's a closer look at the newer neighborhoods around the southwestern end of the reservoir. Now, as opposed to when the lease was signed, we have over 10,000 people living in this area, and many of them use the Aurora Reservoir on a regular basis. They will all be impacted, regardless of whether they live within 2,000 feet of the location or not. These impacts will be compounded because of the cumulative impacts of multiple facilities, something a cap is supposed to reduce, but in this case, it does not. Let's step back and remember 2011 for just a minute. The ECMC was called the COGCC then, and the Oil and Gas Act and the COGCC rules were much different, much less protective. Since then, Colorado experienced a considerable amount of conflicts with oil and gas drilling being located in or around heavily populated areas. Since then, ECMC has gone through a name change, a comprehensive mission change when it comes to oil and gas protections, and even an expansion of its mission into different subject matter areas. The rules for oil and gas operations were much different in 2011. Now, as you know very well, the ECMC's mission is to protect public health, safety, welfare, the environment, and wildlife when it comes to oil and gas operations, not to foster or balance as it was before. And that could mean not drilling in certain areas if it can't be done in a protective way, given current technology and current techniques. Again, as you know, this cap is one of those circumstances where the operator hasn't proven it can operate in certain areas in a protective way. And unlike in 2011, when frankly, it wasn't even within the discussion to say no to a particular development, the circumstances, the law, and rules allow you to do that here. Let's take a little closer look at the 2011 lease from the State Land Board. There was some discussion during the Land Board's testimony about whether the cap is consistent with the terms of the lease. They say it's consistent. Well, when you review the lease, you have probably already seen that it wouldn't be too difficult to be consistent with the lease. That's because other than the land use restrictions in the land board's tier system, there's very little that requires Crestone to go above and beyond current ECMC and AQCC regulations. Here on attachment C of the lease, it clearly says the current regulations of the ECMC would apply. Later on in the lease, it says all emissions must comply with AQCC Regulation 7. And then looking at other specific provisions, they are at most of the same level as current ECMC regulations, but not more protective. So the lease doesn't give us much of anything additional to the ECMC rules. It's important to point this out to avoid any perception that the 2011 lease has another layer of public protections built into it. They're relying on the ECMC. You're the protections. There's a lot of this kind of language in the state land board lease, like if feasible, or minimize impacts wherever reasonably practicable, or reasonable discretion, and so on. And we've seen if there's one thing that is consistent between 2011 and 2024, it's the use of these types of qualifiers by the industry. Just like the 2011 state land board lease, the cap incorporates a lot of wiggle room for the operator. Your questioning has touched on this during the hearing. And as it was pointed out in one point, saying things like if feasible or to the maximum extent feasible or to the extent reasonably practicable and so on, from a legal perspective really means nothing at all. Now, what about electrification? If it is feasible or if available, as Crestone has said. The main issue here isn't whether they are in the process of contacting with Excel or contracting with Excel to get power, but whether they would be willing to adjust their timetable to take advantage of that electric power when it comes online. There are questions about whether and when Crestone would receive that power, but Crestone's made clear if they want to start pre-production activities in, say, June of 2025, but the electric power won't be available until November of 2025, that's too bad. They're going to go ahead with their operations and produce a lot more emissions if the lack of electrical power interferes with their timetable. In the meantime, all of their talk about electrifying operations kind of goes by the wayside, and that's what, if feasible, can and often does lead to. And the same thing applies to wildlife. Again, if the timing restrictions would interfere with their timetable, it's the timing restrictions that go, not their timetable. What's really striking about the wildlife aspect is that Crestone was given a pretty obvious opportunity to change their answer on this during the hearing. They were encouraged, for a lack of a better term, to commit to adhering to the timing restrictions. Despite that encouragement, they've declined to do so, and that's not protective. So backing up and going back to the emissions for a minute. What you heard at the very end of the Crestone rebuttal was them calling their public health contractor, who said in her opinion, the Crestone cap is protective. But she also said during cross-examination that not just is a 2,000-foot buffer or setback protective, but that locating an oil and gas facility within 500 feet, or even in some cases just 100 feet away from someone, is not expected to create negative health impacts. You know, this was kind of one of those record-scratching moments that makes you stop in your tracks and pause. Like, did she just say it's safe from an emission standpoint to be within 500 feet or even closer of a well pad? I even had to go back to the recording and review that she actually did say that. As the commissioners know very well, that conclusion goes against the hundreds of on-point peer-reviewed studies out there, the ECMC's setback decision after a long debate in the emission change rulemaking, and even Arapahoe County's setback decision in what was the most recent iteration of the debate occurring just a few months ago. What I put in front of you is a quote you'll recognize from the Commission's 200 to 600 series rulemaking SPP. Even though the Commission adopted a setback that was less than some of the parties in the rulemaking wanted, the Commission adopted its 2,000-foot setback because the information, even back in 2020, was clear that something a lot more than a 500-foot setback was necessary to protect public health. Claiming otherwise, as Crestone's contractor did, is so far beyond today's standard and conventional wisdom that it has to cast immense doubt on all of her testimony. And frankly, Crestone's entire presentation to you as well. Because if this is the assumption Crestone is working from, that living 500 feet or less from an oil and gas pad does not cause any health issues from emissions, then that in and of itself calls their entire plan into question. Noise. This is one of the biggest threats to public welfare from oil and gas operations, and not just confined to 2,000 feet away, regardless of how Crestone tries to frame it. We've seen this in other areas Civitas operates in using similar technology and sound walls, like Broomfield, for example. In my opening statement, I referenced the good enough type of submissions we saw from Crestone, or at least what Crestone thinks is good enough and checks the box. But what Crestone submitted to the commission about their ambient noise study and noise mitigation measures aren't even good enough. They are just out and out wrong. They are overestimating ambient noise in the area and understating what is necessary to mitigate noise from their operations. And Crestone more or less previously admitted they did overestimate their ambient noise measurements, although they tried to back away from that admission on Friday by blaming traffic and airplanes. Like, we only see traffic and planes around the Lowry Cap area, apparently. But never fear, because Crestone says they'll do a better job when it comes to the ambient noise measurements in their OGDPs. But since prior actions are usually a pretty good indicator of future actions, we can safely assume they won't correct their errors in their OGDP filings because, again, as you heard on Friday, they haven't bothered to do so for their Arapahoe County individual location filings. We keep seeing the same problems, and it adds up to the noise mitigation not being protective at all. I'd like to focus on Rule 314A1 for a minute, and specifically talk about how Crestone's noise submissions in this CAP violate the rule. First, does the Crestone noise information in the CAP facilitate evaluating and addressing cumulative impacts? The quick answer to that question is no. Crestone's cumulative impacts plan assumes noise is only a problem for those living within 2,000 feet of an oil and gas location. And since only one person lives within a 2,000 feet of an oil and gas location in this CAP, and they've given informed consent to Crestone, well, suddenly there's no problem and there's no cumulative impacts to address. We know that's not the case because you heard from undisputed expert testimony from STAR that noise from oil and gas operations goes far beyond 2,000 feet from the location. Not to mention the quote from the Broomfield letter highlighted on the previous slide. Not to mention the commission's common knowledge. Second, the CAP must demonstrate how it avoids, minimizes, or mitigates impacts. Well, the Crestone noise information actually does the opposite because it lays the groundwork for increasing noise impacts within the CAP area. You heard on Friday that an overestimation of ambient noise can lead to the operator asking to exceed noise levels in the rules because if ambient noise is high, then they can't be expected to be less noisy than the ambient noise levels. That leads to more ambient noise, then a higher exceedance, then the snowball keeps rolling. The whole point of a CAP is to reduce cumulative impacts, not increase them. But that's what Crestone is laying the groundwork to do with its noise measurements. Third, BMP should be part of a CAP, and the examination of the BMPs Crestone is committing to when it comes to noise are weak at best. When their vehicles are idling, they promise to the lowest frequency possible. They promise not to honk their horns or bang on stuff unnecessarily. They'll use a quiet completions fleet. Then during production, they'll use utility power, but here's that qualifier again, whenever possible. And keep in mind, even a few decibels make a really big difference in the perception of noise. So this fudging of ambient noise that Crestone did in its CAP submission and lack of cumulative impacts planning or using the mitigation hierarchy ultimately leads to a real threat to public welfare. Okay, this number represents the percentage of produced water Crestone has indicated it will reuse or recycle over the lifetime of the CAP. Well, actually, let me back up a little. Crestone has indicated it will, quote, in the future, evaluate whether the water produced during all phases of operations can be recycled and reused to support future operations, end quote. Which, when translated into reality on the ground, still means zero. Crestone has estimated it will use 105 million barrels of fresh water for their operations within the CAP. Approximately 40% of that will turn into produced water. So give or take 40 million barrels of produced water will be transported by trucks producing emissions out of Arapahoe County into Weld County. There will be zero reuse. Now, there are no doubt challenges in recycling or reusing produced water. First of all, it can be more costly than just disposing of it. That is surely an important consideration for Crestone. But second, there can be logistical issues. Transportation of the water to be recycled and then back for reuse can be an issue. But here, Crestone has already indicated they'll be piping produced water from its individual locations to a collection point for a truck to pick it up and transport it into Weld County. A CAP, of all things, given its focus on reducing cumulative impacts, should be an ideal vehicle to create a produced water recycling or reuse operation. But Crestone will create the infrastructure to transport it out, but is unwilling to use that infrastructure for recycling or reuse. That's hardly protective of water resources. The Lowry landfill. We've discussed this a lot, so I'll not recite the details, but suffice it to say, Crestone did ultimately make one good decision here to not drill under the Superfund site. But the rationale for them not drilling under the Superfund site remains relevant to the area around the Superfund site. Crestone says there's nothing to worry about because it has what it equates to a 7,000-foot vertical setback. But that's not what the EPA thinks, and it's asking the ECMC to create a buffer around the Superfund site. Not a vertical buffer, but a real one. This is another example of Crestone doing the minimum of what it believes is necessary. Crestone concedes that it shouldn't be drilling under the Superfund site, and that's good. But then it draws the line right at the border of the Superfund site, insisting on getting to the minerals right up to the border. But the question is that truly protective? The EPA doesn't think so, that's clear, but it's relying upon the ECMC to establish an appropriate buffer around the site, just like the residents in the area and the rest of us for that matter. Something that would be protective. Okay, next slide. This is the tier map made available by the State Land Board during the hearing last Tuesday. And I want to focus on a couple of things related to this map. First, I want to talk about Sunlight Lawn. For the purposes of this cap, it's still a proposed location. But what we know from Crestone's Arapahoe County filing and what we heard from Crestone during this hearing is they know exactly where they want the Sunlight Lawn location to be. They're done moving it around. Of course, since they aren't asking for preliminary siting as part of this cap, they get to avoid filing information related to an alternative location analysis. But this site, more than any other in the cap, is in need of an alternative location analysis process in order to be protective. It is closest to the densely populated neighborhood. It could be located to be farther away, but Crestone won't do it, or they won't release the results of the ALA that they've already done. They've moved the location around a few times and they say they're done at this point. They know where they want Sunlight Lawn to be, and that's the end of the story. But when looking at this tier map that's in front of you, there's all kinds of area that is not tier 1 available in that part of the ranch. The proposed location is down towards the bottom in the blue of section 27. That's the Sunlight Lawn location that's proposed. We see a lot of blue space, which is okay to drill in, and a lot of gray space, which is even better to drill in, according to the land board around that area. Crestone testified to how they're really limited in where they can drill and where they can locate Sunlight Lawn because of the tier 1 land around there. Looking at this map does indeed show tier 1, but it also shows a lot of tier 2 and tier 3 around it. Indeed, Crestone found space for their proposed beaver location in that area and found space to allow another operator to put the secret stash location in that area. So there's space, just not space they want to consider. Crestone has denied that cost considerations factor into their decision not to move Sunlight Lawn farther away, but they've not hesitated to speak about their technological ability to drill laterals 4 to 5 miles in other forums, even though they denied but then had to backtrack on that assertion during this hearing. And let's be real, of course, cost is a consideration. To deny that they aren't thinking about cost like any normal business would is just not credible. They've been a lot more forthcoming in other forums about that than they have been here, frankly. Crestone acts as if the decision point here is where exactly they'll be able to locate Sunlight Lawn, but that's not where the analysis starts at all. It starts at whether the applicant can operate in a protective manner in its proposed location. If it can't, given current technology and techniques, then the minerals stay to possibly be extracted another day. Obviously, you know this already, but the way Crestone assumes it should be able to drill even in problematic locations makes it worthwhile to highlight. This isn't about yes, where, as Crestone would like it to be. It is about yes or no, depending on whether it's protective. And Crestone is insisting Sunlight Lawn be part of this cap. So if that location isn't protective, then the cap isn't protective. Wildlife. Wildlife is a good example of the contradictory nature of the Crestone cap filing. They go into great detail about the site-specific measures they say they'll take to mitigate impacts to wildlife. They're fine going into site-specific details with wildlife, but not with other areas that are under the ECMC's purview. But even more importantly, they don't commit to cap-wide measures like timing restrictions for wildlife protection. This is the kind of thing tailor-made for the landscape level planning of the cap. But Crestone's determination of whether it will disturb a sensitive area is based on whether its rig will be available at a certain time, not whether timing restrictions designed to protect wildlife are in place. I want to turn to emergency response, including wildfire response, for a couple of minutes. If there's anything that should lend itself to landscape level planning in the CAP, as opposed to site-specific planning, it would be emergency response and wildfire response. Emergencies aren't limited to a well site. For example, a truck with hazardous materials crashing in between the well sites. But wildfire is Exhibit A when it comes to the need for landscape level planning. Wildfires always take the deployment and coordination of many first responder agencies. It took a lot more than one fire department to fight the Marshall Fire, which is the picture on this slide. It took an entire region, and even then there wasn't a lot they could do before 1,000 houses burned down. Like the area around the Marshall Fire, the area around some of these proposed oil and gas locations is heavily populated. The grasses are highly flammable when dry, and in the summer, the winds are often blowing right towards the neighborhoods around the reservoir. But we have next to nothing from Crestone related to CAP-wide planning for emergencies like wildfire. What we have is assurances they'll work with the local agency. They will work with the local agency, Bennett Watkins. You heard from a former fire chief during STAR's testimony that he would expect to see information about who's responding, who's responsible for what, evacuation plans, and other evidence of planning, and full chemical disclosure with names and chemical ID numbers would be very helpful, so the first responders would know what they're dealing with. But we've seen none of this. We've seen vague assurances from an operator who hasn't always lived up to those assurances. Now, Ms. Jost on Friday, she asked Chief Caggiano whether he knew that, quote, Rule 314 doesn't require Crestone to address wildfire in the CAP, end quote. There's a couple of things that should stick out from that particular question. First, it nicely summarizes Crestone's approach to this CAP, which is, if we don't think the rule specifically requires it, we're not going to do it. But second, the commission rules may in fact require Crestone to address wildfire in this CAP. Rule 314E is not an exclusive list of the types of plans the applicant needs to turn in. It clearly says, at a minimum, there are 11 types of disclosures that must be part of the CAP application. There is no reason to put at a minimum in that rule unless it is for keeping the door open for additional disclosures consistent with other ECMC rules. And also, I'll keep mentioning this because it informs everything else. The oil and gas operation must be protective. That is the foundation for ECMC rules, including Rule 314E. In order to be protective, you bet Crestone needs to come up with a CAP-wide plan to address wildfire and other emergencies. This very type of issue is what requires landscape level types of planning, not relying on one that none of us knows, including Crestone, whether it exists with one particular fire department at this point. You know, Chief Caggiano put it well when he said, quote, you can't just check the boxes and hope everything is going to turn out okay. It's clear on this issue and many others, Crestone is doing just that. They are employing a drill and hope strategy, especially on this emergency response issue. Its work on the issue and disclosures are so minimal and not compliant with the rules. This is what Crestone has to prove in order to gain your approval for this CAP. As I said in my opening statement, the three separate clauses in Rule 314H3 are not just three separate ways of saying the same thing. The CAP must comply with the Commission's rules and protect and minimize adverse cumulative impacts. Crestone has not met its burden to show the CAP does these things. The CAP is not protective. It's not protective when it comes to emissions, noise, wildlife, water, locations, and emergency response. It doesn't minimize adverse cumulative impacts. In some cases, it only minimizes impacts if feasible or if available. In others, like noise, it is actually increasing cumulative impacts. In other cases, it ignores cumulative impacts, like the secret stash location it allowed to be within the CAP, but we're able to keep those cumulative impacts off the books. Outsourcing drilling does nothing to minimize cumulative impacts on the ground. In fact, this CAP is merely a combination of 8 separate OGDPs with the label of a CAP. There's very little Crestone is doing in this CAP that it wouldn't do for 8 individual OGDPs in the area. They would normally consider electrification in the facilities if feasible. They would normally have a pipeline for oil takeaway, as Crestone conceded last Tuesday during Cross. They would normally put in some wildlife PMPs. This application is merely 8 separate OGDPs dressed up as a cap, and it doesn't minimize anything. Instead, STAR asks that you follow Rule 314H4 and deny this cap because it doesn't follow the rules, it doesn't protect, and it doesn't minimize adverse impacts. Maybe a stay under 314H5 to allow Crestone to actually do it right the next time would get them there. Maybe an alternative location analysis for Sunlight Lawn. Maybe a compliant ambient noise study or noise mitigation. Maybe commitments to adhere to wildlife timing restrictions or electrification. Maybe real water protections. But Crestone at this point seems unwilling to do those things. So I want to conclude and go back to what I said at the very beginning of this. This is what STAR is trying to protect. People from all walks of life, professions, and varying levels of knowledge about the oil and gas industry have studied this cap. They've come to the same conclusion. It is not protective. It may have been submitted some time ago. It may have gone through several iterations since then, but it's not ready. We hope that you agree, and we ask that you deny the application. Thank you, Mr. Chair. I appreciate a little extra time on this as well.
Thank you, Mr. Foote, for the closing. We appreciate the synopsis from you and your client's perspective. At this point, we will recognize Ms. Jost for a closing argument.
Wonderful. Thank you, Chair. Well, good morning, Chair, Commissioners, Council, and members of the public. Crestone greatly appreciates the time and work put in by this commission and ECMC staff, multiple federal and state agencies, local governments, and a variety of stakeholders, including STAR. At this point, after 645 days from filing the CAP application, Crestone is ready for the opportunity to place the Lowry Ranch Rule 314 Comprehensive Area Plan application in your hands for a decision today. You've been provided a substantial amount of information during hearing, during the public comment period, during the Rule 511 local public hearing or in writing by Crestone, the Colorado State Land Board, CDPHE, CPW, EPA, BLM, Arapahoe County, City of Aurora, oil and gas operators, mineral owners, and multitudes of Arapahoe County and City of Aurora community stakeholders in support of the Lowry Ranch CAP. Out of the 5,940 interested parties, each of which have a legally protected interest in the outcome of this hearing, this commission has heard from one activist group without true standing, whose sole mission is to prohibit oil and gas development on Lowry Ranch. This one activist group has admitted that it's financially supported by the Environmental Integrity Project, a national activist organization that has created toolkits and guides on how to oppose oil and gas drilling and permitting in the United States, and whose mission is to fund organizations like STAR in their opposition of much needed energy development. It is this commission's role to absorb the detailed and voluminous record built in the past 645 days that this application has been pending, to account for and consider CDPHE, CPW, Colorado State Land Board, EPA, BLM, relevant local government and proximate local government consultations that occurred for the Lowry Ranch CAP, to account for the director's recommendation for approval of the CAP, and to analyze and weigh the evidence provided at hearing by Crestone and the petitioner as you decide the fate of this critically important Rule 314 Comprehensive Area Plan for the state of Colorado, its local governments, the Colorado State Land Board, and its fiduciary responsibility to the public trust for our school children and Colorado citizens as a whole. This is no small task. However, when reviewing the weight of the evidence, it is clear that Crestone's Comprehensive Area Plan application meets each and every requirement of Rule 314. It has met every ECMC requirement and restriction about drilling near homes. It's an approvable application, and it's protective of public health, safety, welfare, and environment and wildlife resources. This is especially true in light of STAR's lay witness factually inaccurate statements and the non-reliability of STAR's nationally activist-funded purported expert witnesses. In an effort to confirm why this commission should approve the Lowry Ranch CAP, I will take a few minutes to reestablish what the Lowry Ranch CAP is and is not. First, the Lowry Ranch CAP application is an application that's compliant with Rule 314 A through G and all other applicable commission rules as found by the director's recommendation. It's an approvable application because it is compliant with Rule 314 and all other applicable commission rules, again, as found in the director's recommendation. It's a comprehensive area plan that's the result of thousands of hours of consultation, cooperation, and collaboration with multiple federal, state, and local governmental stakeholders, oil and gas operators, mineral owners, community groups, and citizens. It's a comprehensive area plan that's the result of thousands of hours of internal operator development, analysis, and evaluation to continue in the efforts of proving the value of comprehensive area plans in Colorado. It's a comprehensive area plan that has evolved for the better over the past 367 days as a result of consultation, cooperation, and collaboration that I just mentioned, including input and influence from STAR. It's a comprehensive area plan that facilitates evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans to develop oil and gas locations within a region while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, and wildlife resources in that geographic area through systematic planning of infrastructure location, best management practices, and consolidated and centralized facilities. It's a 32,000-acre comprehensive area plan that includes the entirety of the state land board surface of Lowry Ranch. It's a 32,000-acre comprehensive area plan that includes the entirety of the Colorado State Land Board minerals governed by the Lowry Ranch oil and gas lease held exclusively by Crestone that allows the development of oil and gas on the Lowry Ranch to the benefit and betterment of Colorado school children, as you heard from Ms. Crandall last Tuesday, as well as this morning from Mr. Ryan. The Colorado State Land Board receives royalties both at the surface and subsurface under this oil and gas lease as well, and those benefits continue for the life of the lease. This oil and gas lease also requires wildlife monitoring, well beyond the requirements of the ECMC regulations. The CAP is a 32,000-acre comprehensive area plan that will financially contribute to local governments, public safety, and first responders. And starting in 2025, these dollars will help fund public transportation projects and wildlife habitat under Governor Polis's brokered legislative compromise this past session. The hundreds of millions of dollars in royalties received by the Colorado State Land Board from Crestone's oil and gas development on Lowry Ranch not only serve Arapahoe County and Colorado school children, but they provide much needed resources to Colorado schools all over that are in desperate need of improving the lives and learnings of their students. The CAP is a mineral development plan utilizing only 7 new oil and gas locations for 32,000 acres of mineral development and 2 existing locations per the ECMC's preference to drill and develop up to 166 horizontal wells. It's a comprehensive area plan, whereas you heard from Ms. Caranda's follow-up email to this commission last week that the Colorado State Land Board has approved each of the 8 conceptual oil and gas locations within the Lowry Ranch CAP, and that siting is in compliance with the Colorado State Land Board's oil and gas lease and tiering structure. The CAP is a plan with only 1 residential building unit owner, with the owner providing informed consent within 2,000 feet of the working pad surface of an oil and gas location, and only 2 residential building unit owners within 3,000 feet of a working pad surface at any of the 9 oil and gas locations within the CAP lands. The CAP is a plan that does not have any oil and gas location proposed in a disproportionately impacted community or cumulatively impacted community with a residential building unit within 2,000 feet of the working pad surface. The comprehensive area plan is supported by a 500-page cumulative impacts analysis of the Lowry Ranch CAP application lands, as well as 1-mile buffer lands that address and evaluated each and every resource provided in Rule 314E10. The Lowry Ranch CAP is a comprehensive area plan that is supported by the leading public health expert in Colorado, CDPHE studies, and thousands of data points collected by CDPHE and Civitas that illustrate the benefit of tried and true facility design, equipment specifications of the highest caliber, best management practices, and mitigation measures, and the use of those items to reduce adverse cumulative impacts in the surrounding areas. The CAP application is a plan that includes commitments to over 100 best management practices, as detailed by Mr. Nathan Bennett during his testimony. And these have resulted from Creststone's extensive cumulative impacts analysis, from detailed consultations with CDPHE, CPW, EPA, Arapahoe County, and the City of Aurora, as well as from hundreds of public comments provided by STAR and the community. The Lowry Ranch CAP application now includes a condition of approval in response to commissioner concerns regarding produced water takeaway in high priority habitat area for the eastern portion of the Lowry Ranch CAP, where Creststone commits to, and I quote, a condition of approval for the conceptual Harvard Yell and Wetterhorn Handy's oil and gas locations that limits the initiation of oil and gas production to a period between May 1st and October 31st. The Lowry Ranch CAP is a comprehensive area plan that routes all trucks away from the Aurora Reservoir and the surrounding communities to the west of the reservoir. It's a plan that details Creststone's commitment to continue its outreach and efforts with Excel to gain electrical capacity to utilize grid power for drilling rigs, and the current full commitment to use grid power on at least 3 of the oil and gas locations, notwithstanding the fact that the ECMC rules do not require electrification of drilling rigs. The Lowry Ranch CAP is a plan that commits to using Tier 4 or equivalent engines, such as natural gas Tier 2, Tier 4 with battery assist or better for drilling rigs, should electrification be unavailable despite Creststone's best efforts to obtain grid power. It's a CAP that commits to electrifications of production facilities on each oil and gas location within the Lowry Ranch CAP area. It is a CAP that commits to oil and gas pipeline takeaway as of the date of first production, notwithstanding the fact that the ECMC rules do not require pipeline takeaway. It's a CAP that does account for public health impacts and the reduction and or lack of such impacts in areas 2,000 feet or more from residential building units, as you heard from the public health expert testimony on Friday. The Lowry Ranch CAP is a comprehensive area plan outlining the development of the first location, the State La Plata South, to be developed within the Lowry Ranch with a preliminary siting approval request. The Lowry Ranch CAP is a plan that voluntarily agrees to sound walls on each oil and gas location within the Lowry Ranch CAP for additional noise protections, despite only 1 residential building unit within 2,000 feet of an oil and gas location and 2 residential building units within 3,000 feet of location, none of which are STAR members or residents of the areas STAR purports to represent. The CAP is a comprehensive data-supported data-supported seismic evaluation due to the proximity of development near the Lowry Landfill Superfund site and the Aurora Reservoir. Again, notwithstanding the fact that ECMC rules don't require a seismic analysis under Rule 314. The comprehensive area plan is supported by credible, reliable, and relevant testimony and evidence from Colorado oil and gas workers and experts with years of experience in the DJ Basin and Arapahoe County, Colorado. The CAP is the first step in a multi-year permitting plan for the drilling and development of the Lowry Ranch. If approved, Creststone plans to submit the additional oil and gas development plan applications, Form 2As, drilling and spacing unit application, and Form 2s for this commission's review under an approved CAP order and applicable commission rules. And finally, the CAP application is a commission application undertaken voluntarily by Creststone, adding significant time and complexity to the ECMC permitting process for these sites in order to realize the benefits of comprehensive landscape level planning beyond individual OGDPs. Now, what the Lowry Ranch 314 Comprehensive Area Plan is not. It's not an application that is seeking formal and full approval of oil and gas development plans, Form 2As, drilling and spacing unit application, Form 2s, or pooling applications. Each of these follow a separate permitting process under ECMC regulations. It is not an application that bars the evolution of technology or equipment modifications over the 6-year life of the CAP, and that evolution will be monitored by both Creststone and the Commission on subsequent OGDP applications. This is not an application that bars the addition of additional best management practices and mitigation measures during the review of each subsequent OGDP Form 2A and Form 2 submitted under a cap order as confirmed by the Commission's own rules in Rule 314. This is not an application that confirms or determines the drilling and spacing unit size, orientation, reduced subsurface setbacks, as all of those are determined in subsequent drilling and spacing unit application filings. This is not an application that's devoid of cumulative impacts analysis, as STAR would have this commission believe through its purported expert testimony. Experts that on all occasions on cross-examination admitted they were not Colorado experienced, did not conduct their own independent analysis or evaluation of the Lowry Ranch CAP project, and effectively admitted that they only addressed the information placed in front of them by the STAR activist group. This is not an application that's devoid of protections of public health, safety, welfare, and environment and wildlife, as STAR would have this commission believe, as evidenced time and time again during the 16 hours of testimony in this case by credible, experienced, and reliable Crestone witnesses, experts, and testimony. This is not an application devoid of public comment, input, and outreach, as STAR would like this commission to believe. This is evidenced by the hundreds of public comments received by the ECMC and Crestone's response directly to each one of those. For purposes of preserving the issue on the record, Crestone respectfully and fundamentally disagrees with the commission's determination of STAR as an affected person. By incorporating the entirety of Crestone's position on the record during last Tuesday's hearing for purposes of brevity on this issue, Crestone maintains that STAR and its members did not provide substantial evidence to support a finding of affected person status under Commission Rule 507A3 or 507A4, or under applicable governing individual standing or association standing laws of the state of Colorado. The commission positioned that it erred on the side of leniency to allow STAR to become a party to the proceedings, but that such allowance would not and did not determine the credibility, reliability, or relevancy of STAR's claims, positions, or testimony. This leniency was in contravention of the commission's own rules and applicable Colorado standing law. The commission must recognize the impact of STAR's affected person status in this docket, as well as future dockets where activist anti-oil and gas associations seek standing with zero basis to support their claims. Adopting the commission's own statement that STAR's affected person status did not result in a determination of STAR meeting its burden of proof as a petitioner or the credibility of STAR's argument, STAR repeatedly failed to provide credible, reliable, or relevant experts in its attempt to support its claims. Claims that in reality reflect general oil and gas development concerns from members of the general public. Each of STAR's witnesses, both lay and expert, presenting nothing more but conjecture, speculation, and unsupported opinions on perceived or what-if impacts. More importantly, not one of STAR's purported experts engaged in 1 ounce of their own independent research, analysis, or data acquisition in the state of Colorado, and more specifically, the DJ Basin in Arapahoe County, as you heard repeatedly on Crestone's cross-examination of each nationally funded expert. Not one of the 3 experts offered any credible scientific technical evidence, seismic data, or noise analysis that served to support their concerns. The use of the terms what if, likely, possibly, or maybe, when used by admitted experts, provides zero confidence in the expertise of the expert, nor does it provide a modicum of reliance on the opinion they're providing to the commission. Each of the lay and expert witness testimony presented by STAR was discredited during Crestone's cross-examination, as well as Crestone's technical, scientifically based subject matter expert and public health expert testimony. Each of the expert and lay witnesses' testimony presented by STAR were biased, speculative, and in many instances, as admitted on cross-examination, to be wrong or incomplete. For example, Mr. O'Mara opined on many issues outside of his cited expertise that were not credible, and what you did hear is unreliable and in many instances irrelevant, both factors in weighing expert testimony under the Colorado Rule of Evidence 702 and the Colorado Supreme Court case of People v. Schreck. All Mr. O'Mara provided was a series of general concerns and misinformation intended to incite fear rather than expertise. It's important to note that the vast majority of these general concerns For example, seismic, surface contamination, facility design, pipeline design, secondary containment, and thermogenic methane are both speculative and equally pertinent to every well proposed in the DJ Basin and not unique to the Lowry Ranch CAP. So he is telling this commission that he questions every single ECMC rule and every single well in the DJ Basin. You heard direct testimony from Mr. Amaro that he does not understand the ECMC groundwater monitoring and sampling rules, which is questionable as a purported expert in this area. You also heard testimony that the EPA did not specify that it was looking for a horizontal setback, despite Mr. Foote's misrepresentation this morning. Mr. O'Mara also attempted to tarnish Civitas by a reference to its culture and compliance history. However, this attempt fails, given this commission's knowledge of Civitas's history of compliance, as well as Civitas's dedication to protections of the community. His testimony should not be relied upon, given his clearly biased position on drilling and development in Colorado as a whole, and again, is funded by a national activist group. Additionally, you heard him agree with Crestone as to many of the inaccuracies in his report and his noticeable cherry picking of information from his cited reference. Mr. Amaro was clearly retained in an attempt to portray an activist as an expert on STAR's quest to deny the CAP. His testimony is unreliable and should not be the basis of this commission's decision. Additionally, you heard from Mr. Caggiano, and you heard him admit, among other things, that he did not have conversations with the Bennett Watkins Fire and Rescue Group to verify any of his fear-mongering examples, and he did not conduct an independent analysis on the ECMC process or Crestone's emergency response plans on its approximate 30 existing oil and gas locations under Bennett Watkins Fire District jurisdiction. His testimony is also tied to Appalachian gas operations, which significantly differ from oil and gas operations in Colorado, yet he assumed that they're identical in scope and regulation until his admission on cross-examination that they were not. Mr. Caggiano's testimony is unreliable, irrelevant, and should not be the basis of this commission's decision. Further, you heard from Mr. Thornton, and you heard him testify, among other things, that he effectively ignored and discounted the commission's rules relating to noise levels, as well as Crestone's use of sound walls on every location within the CAP. You heard that he ignored the fact that the noise modeling software utilized by Crestone is still commercially available and was last updated in February 2024. You heard that he ignored Rule 314 E10F and the fact that it does not require location-specific noise studies, plans, and noise modeling. And you also heard him testify that in compliance with Rule 303 and 304, a site-specific noise mitigation plan that will include noise studies, plans, and noise modeling will be submitted with each oil and gas development plan application for locations within the CAP. You also heard that out of the 500 complaints submitted on Civitas's operations in Broomfield, that the ECMC did not find one instance of a violation. You also heard Mr. Thornton misrepresent that Crestone sought a variance to the ECMC noise levels as part of this CAP, which is false. Mr. Thornton's testimony is unreliable and should not be the basis of this commission's decision. Crestone appreciates Ms. Kammen's time, efforts, and testimony, but they do not rise to the level of meeting STAR's burden of proof of their claims requesting denial of the Lowry Ranch CAP. Crestone commends STAR's influence on the Arapahoe County oil and gas regulation amendments regarding reservoir setbacks and continued influence on the ongoing revisions to other portions of the Arapahoe County oil and gas regulations. STAR's leadership also engaged with Crestone subject matter experts at an Arapahoe County public open house in February and subsequent other meetings to ask questions and seek to inform other residents in the South Shore neighborhood. We find that commendable, as well as STAR's attempts to influence the commission through this process, either through testimony today or public comment of their members in writing or at the Rule 511 local public hearing, or even in violation of the commission rule at the July 15th public comment portion of this hearing. Crestone does, however, have significant concerns with the misinformation and embellishment that STAR's lay witness testified to and how much information has played a role in creating fear and concern about the Lowry Ranch CAP and the community STAR purports to represent. These examples of spreading fear were evidenced by testimony regarding Starr and Ms. Kamen's complaints about flaring from a purported Crestone location that was actually a properly permitted gas plant owned by a third party 10 miles away from the South Shore neighborhood, among other examples you heard. It's also important to note that while Ms. Kamen represented herself as a voice of the community, the Starr Group represents a small minority of the households in this area, a vast majority of which are not Starr members and did not protest this application. Taking all of the examples just provided into account and many more in the record, the commission should not give any weight to Starr's lay or failed expert testimony because they were representative sentiments of the general public. The testimony was not applicable to every resident in the neighborhoods near the Aurora Reservoir, as noted by Mr. Harrington in testimony, where at least a third of the interested parties had reached out to Crestone, asking Crestone to lease their minerals for development. This is not the only time Starr or its members are able to participate in the development aspects of the Lowry Ranch CAP. Their personal testimony does not change the fact that Crestone's Rule 314 Comprehensive Area Plan is compliant with every Rule 314 criteria and requirement, as well as all other applicable ECMC rules. Their purported expert testimony was anything but independent, reliable, or relevant, and Crestone has made a substantial record in support of its approvable Rule 314 Comprehensive Area Plan application. This commission must recognize the content, context, and applicability of Rule 314, and such recognition cannot be degraded in favor of Starr's unreliable and speculative opinions. As you weigh the evidence presented by Starr against the evidence presented by Crestone during your deliberations, Crestone advises this commission to rely on the substantial evidence in the entire CAP application record to find that Starr did not meet its burden of proof as petitioner and has failed to provide any credible, reliable, and relevant evidence to support its requested relief. Based on the entirety of the record and the evidence heard during the hearings last week and this week, Crestone's CAP is approvable, protective, and Crestone has met each and every requirement of Rule 314 and other applicable rules. Based on this, Crestone respectfully requests that this commission approve this critically important application and establish an approximate 32,000 acre Rule 314 Lowry Ranch Comprehensive Area Plan for the application lands that serve to protect and minimize adverse impact to public health, safety, welfare, the environment, and wildlife resources, and that plan will protect against adverse environmental impacts on any air, water, soil, or biological resource in compliance with Statute 3460-106 2.5a, and that also allows for the production of oil and gas and associated hydrocarbons from the Codell, Niobrara, Greenhorn, and J-Sam formations. Crestone requests that this commission find that the Lowry Ranch CAP proposed will facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for Crestone to develop oil and gas locations within the application lands while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, and environment, and wildlife resources in the region through systematic planning of infrastructure location, best management practices, and centralized facilities. Crestone requests that this commission find that the Lowry Ranch CAP proposed will result in development that will protect and minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. We would request that this commission find that Crestone is entitled to the rights to be conveyed in Commission Rule 314B1 through B4 for the development and operation of the Lowry Ranch CAP. We would request that this commission grant and convey to Crestone the rights set forth in Commission Rule 314B1, B2, and B4 for the development and operation of the CAP. Crestone requests that this commission grant and convey to Crestone the rights set forth in Commission Rule 314B5 for the development and operation of the State La Plata oil and gas location within the CAP. Crestone requests that this commission grant Crestone a 6-year duration for the Lowry Ranch CAP to start on the date the commission approves this application and confirm Crestone's reservations of right to seek an extension under Rule 314C2. and for any other findings or orders that the commission may deem proper or advisable in this matter. Thank you very much for your time last week, today, and we look forward to your decision.
All right. Thank you, Ms. Jost. Commissioners, we've now had closing arguments. I suggest we take a short break before we move to deliberations. Let's return at 10:25. All right, this is the Colorado Energy and Carbon Management Commission. It is August 7th. It is 10:25. We are taking up docket 221-000-282. We now turn to deliberations of commissioners. Who would like to begin? Commissioner Cross.
Thank you, Mr. Chair. I do have quite a bit of comments here, so I just want to make sure everyone's aware of that. At the outset, I first of all want to take the time to express my appreciation to everyone for the work put into this hearing. For staff, from the location assessment specialist to engineers, environmental unit members, and communications group, staff has worked on reviewing this CAP for years, working on the public hearings to get this to this point. So thank you for that work. To our sister agencies such as CPW and CDPHE, they've been engaged in consultations, worked with the operator to ensure our legislative mandate is being fulfilled. Similarly, I appreciate the work done by the State Land Board and the time taken to elucidate your processes, procedures, and ongoing work on the Lowry Ranch, be it oil and gas, grazing, or solar. To the local governments, thank you for providing your input and helping with the regulatory processes. Federal agencies for providing input. The operator, I know this has been years and years of planning, resources, and effort. And finally, to the public. This has been a unique application because of the care and determination that you have put into this process. We had our first 511 hearing. We had a local group of people fight to participate in this process and provide your lived experiences. Given the political divisiveness and fatigue we face today, it's reassuring to see the involvement in this public process. And I want to say that we do hear you. There were comments at the July 15th hearing that expressed that nothing had happened after our 511 hearing. I just want to make sure that people understand that is not true. I, for one, crafted questions and guided my review around the concerns that were raised. It is important to understand that no decisions were made after the 511 hearing because that is part of the process that we go through. Similarly, many commenters, whether written at the 511 hearing and on July 15th, indicated that we should wait until the cumulative impacts rulemaking is complete before hearing this application. It's important to know that the rules that apply are those that are in place at the time the application is filed. So staying the decision here would not change the applicable rules. That said, should this CAP be approved, I anticipate that the cumulative impact rulemaking will be complete prior to the filing of OGDPs related to this CAP, except for the one request for preliminary siting and OGDP. Consequently, the cumulative impact rules will apply to the site-specific analyses as requested if the CAP is approved. Finally, many commenters indicated that we should note we should not authorize any oil and gas development in Colorado and instead focus on renewables. I think it's important that the public know that we don't control what form of energy exploration, such as instructing solar instead of oil and gas, should be used. Moreover, decisions to not allow any oil and gas exploration is a policy decision that's left with the legislature, not this commission. Instead, exploration is permitted in Colorado, and our mandate is to make sure that we regulate that development to ensure that it is protective of public health, safety, welfare, environment, and wildlife resources. Moving to the specifics of this CAP, I want to start by discussing my impressions of the non-operator witnesses and their testimony before moving to the testimony and CAP proposal brought by the operator. I'll begin with Ms. Goldsmith-Common. I want to thank Ms. Goldsmith-Common for her testimony and her leadership with STAR. I appreciate her sharing her viewpoints and concerns with the proposed project and found her testimony to be credible. I do want to touch on a few points from her testimony, however. First, Ms. Goldsmith-Common raised concerns about light impacts given the complaints that arose from Crowstone State Bierstadt location. Critically, there were no sound walls around the Bierstadt location. Rather, there were only bales present around the site to help with sound mitigation. Here, proposed sites would have sound walls and a hill separates the RBUs from the proposed pads described by the operator. These features will help minimize noise and light impacts, especially compared to the Bierstadt location. The second issue I want to touch on is the idea of the 6+ mile long laterals. I do have some concern over the difference with the operator statements regarding the laterals not only being used because of cost, as was raised by Ms. Goldsmith comment. Notably, such a statement is inconsistent with what we have been told, not only by Civitas in past operations, but all other operators in the state. I do recognize that operators in the world have done longer laterals in different parts of the country and the world, but we have not seen laterals of this length in Colorado, although even since I have started, operators have used longer and longer laterals with success, a trend that I hope to see continue. I do want to highlight some confusion related to this issue. Most notably, Ms. Goldsmith Common and the vast majority of other members of STAR and the public stakeholders that oppose the cap indicated that the concern with the project is the air quality emissions due to the proximity to RBUs and the potential health impacts attendant to that proximity. Due to this concern, Ms. Goldsmith Common and members of the public have suggested that the well pads should be located farther away from the houses. Without addressing the proximity issue, as I will do so later in my comments, I do think it's worth noting that this concern is in stark contrast with other concerns and testimony raised by STAR, namely potential seismic issues. In other words, at times we have heard concerns would be alleviated by moving drilling further away, but at other times we have heard that drilling is problematic regardless. I do not think this apparent contradiction discounts the concern over either issue, but it does seem to frame the air quality issue as the primary concern for STAR members. That said, I do not rank their concerns, but take both into consideration, and I just want to highlight these issues for future consideration. Additionally, the concern I have with the argument that the drilling should be moved is that the lengthening the laterals, as suggested, would interfere with the state land board's siting parameters. In particular, the proximity to planned reservoirs, which Ms. Goldsmith Common identified as another concern for STAR members. Another point that was raised was that the cap violates the state land board sub-area plans. Now, as was brought out in cross-examination, it's important to note that this was merely an opinion, not any kind of legal conclusion. I did want to make one note here that the fact that agricultural zoning is present in this area is not something that's determinative, as agriculture is often used for oil and gas development. And one final note that arose is that in cross-examination, it was raised that the reservoir was closed over the July 4th holiday due to contamination. I'm not going to be honest, I was not aware of this fact, and it did surprise me as it stands in contrast to the descriptions of the pristine water that were raised in public comments and direct testimony. To be clear, I don't raise this to suggest that the reservoir should not be protected. Quite the contrary. I think the reservoir should have a full slate of protections. But I did want to point out that did arise in cross-examination and was noteworthy to me. Next, moving on to Mr. Thornton. Again, I found the testimony of Mr. Thornton credible, but wanted to touch on a few of the points that he raised. First, as was pointed out by Chair Robbins, the noise survey required by ECMC will occur at the site-specific OGDP stage. Thus, I do not find his testimony that the ambient noise test done for the Arapahoe County as controlling on the determination as to whether the proposed cap is protective of public health, welfare, safety, the environment, and wildlife resources. Consistent with the questions asked by Commissioner Ackerman and answered by Mr. Thornton, I believe that the greater than 3,000 foot distance, and in many instances more than 5,000 feet from RBUs, will minimize noise impacts, as well as the sound barriers, or as the sound walls. Of note, the ambient noise due to the proximity to DIA, Buckley Air Force Base, and Space Force Base, and nearby traffic do strike me as just as concerning for noise impacts as the proposed oil and gas development here, especially when considered in conjunction with the development. Consequently, should this cap be approved, I do expect the operator to have more detailed noise analyses prepared and the most stringent protections available and in place. Finally, I do want to highlight that some of Mr. Thornton's concerns were more pointed towards the scope and impact of our rules rather than the proposed project. While I acknowledge those concerns, this hearing is not an assessment of those rules, and my focus will be on compliance with the rules we presently have. Next, Mr. Caggiano. Similar to Mr. Thornton, it appears that some of Mr. Caggiano's concerns are directed at the scope of ECMC rules. Again, my focus as an adjudicator is compliance with our present rules, not potential changes to the rules. Also similar to Mr. Thornton, I believe that Mr. Caggiano's concerns are premature, as the emergency response plans will apply at the site-specific OGDP stage. Therefore, I do not find that his testimony that the lack of an emergency response plan here controlling on the determination as to whether the proposed cap is protective of public health, welfare, safety, the environment, and wildlife resources. Mr. Caggiano also expressed concern over the secondary containment for the proposed cap. Again, these issues will be addressed in additional detail at the site-specific stage. And we do have significant rules governing sites secondary containment in our rules. Moreover, in probing his testimony, Mr. Caggiano indicated that part of his worry was the flow lines, but it did not appear that Mr. Caggiano had reviewed our flow line or wellbore integrity regulations, which are more restrictive than in other states. Finally, I wanted to highlight 3 overarching points with respect to his testimony. First, Mr. Caggiano opined that the emergency responders were not prepared to appropriately respond to an emergency here. However, by his own admission, Mr. Caggiano had not spoken with the responders to assess their capabilities or their response preparedness. Second, Mr. Caggiano suggested that spills might go undetected or take extended periods of time to respond, perhaps even days. However, this does not take into account that Civitas, as with most operators in Colorado, have automatic remote monitoring and shut-in capabilities. Finally, Mr. Caggiano expressed the need for emergency responders to have access to CAS numbers rather than just chemicals. Aside from our existing regulations requiring operators to provide specific identity and concentration of chemicals details to emergency responders and healthcare professionals, the Colorado legislature passed HB 22-1348 in 2022. This requires disclosure beyond that done to frac focused, including CAS numbers. Chemical manufacturers and operators have begun providing this information to the Commission, and the Office of Information and Technology is currently creating the website that will allow such information to be searchable and available publicly. I do recognize that that website is not available at present time. However, we are working on that, and that is something that should also alleviate some of the concerns raised. Next, I'll talk about Mr. Amar. I want to first touch on an issue concerning the questioning of witnesses by commissioners. Some stakeholders have indicated that questioning of Mr. Amara was meant to discredit him as an expert. I assure everyone that this is simply not the case. However, as an adjudicator, it is my obligation to assess the credibility of witnesses, including probing the extent and basis of their professed expertise and conclusions. Here, I did not find Mr. Amara to be a credible expert witness. This is not to say that I do not believe that the content of his testimony was based on sufficient facts or data, or the product of reliable. I do not believe that he is qualified. It's not to say that I don't believe he is qualified or knowledgeable in the areas for which he was designated, but I do not believe the content of his testimony was based on sufficient facts or data, or the product of reliable principles and methods, factors critical to the reliance of an expert opinion under the Colorado Rules of Evidence. Let me go into more detail on this assessment. First, Mr. Amara talked about induced seismicity. I acknowledge that induced seismicity can be a concern for both underground injection and, to a lesser extent, hydraulic fracturing. Indeed, the studies cited by Mr. Amara indicate that this is a fact. However, when you look at Mr. Amara's testimony, his specialized knowledge and expertise was not necessary to understand the evidence at issue. Rather, he merely reiterated the conclusions of what the studies say. For example, he indicated that an EPA-funded study suspects there is a fault at the Lowry landfill. He also references USGS induced seismicity strategic vision circular to conclude that induced seismicity has occurred as a result of deep well injection and, to a lesser extent, hydraulic fracturing. However, Mr. Amara does not conduct any analysis of this information in those studies, or existing mapping that references to indicate that a particular or acute risk of induced seismicity is present at this site. To the contrary, the contents of those studies and publications suggest that there is not an increased or acute risk of induced seismicity at the Lowry Ranch. The EPA-funded study actually notes that potential normal faults were identified in the area in 1987 in a geotechnical investigation, but further investigation exposed no faulting, and any potential faults were determined to have, quote, little impact on design and operation of the dam because they had limited lateral extent, minor displacement, and did not offset overlying soils. Additionally, no other faults were found were or identified during the work at the Aurora Dam and Reservoir. This is found in Mr. Amara's Exhibit D. The study also noted that fault mapping in the area has been occurring for 125 years with respect to the Boulder Well fault zone for which he expressed concern. The report on which the study is based also indicates that no connection to deeper formations. There are no connections to deeper formations in the potential fault at the Lowry Ranch site, a fact ignored by Mr. Amara but highlighted in Aurora's presentation. In cross-examination, Mr. Amara also agreed that the presence of the fault has since been called into question. The USGS publication referenced by Mr. Amara also does not suggest an exaggerated risk here. As brought out in cross-examination, the paper highlights that the major concern is deep well injection. Mr. Amara's Exhibit E, which were prior comments to the commission based on the cumulative impacts rulemaking, notes that induced seismicity has been studied in Colorado for over 50 years, and an increase in earthquakes began in conjunction with, quote, disposal of large amounts of produced water into the subsurface, end quote. A National Research Council study cited by Mr. Amara in that exhibit also shows that the induced seismicity in Colorado is a result of wastewater injection, not extractive practices. The information relied upon by Mr. Amara is thus only partially discussed in his testimony and demonstrates that seismic analysis has been done in this area. More importantly, for my assessment of his testimony, he does not conduct any independent analyses or specialized interpretation of the data, but merely summarizes those papers. Instead, Mr. Amara's conclusions are what-ifs, absent specific application of his expertise to the evidence. Two of the most notable instances of this are his statements that, quote, absence of evidence is not evidence of the absence, and, quote, maybe the EPA knows something that ECMC, Colorado Geological Survey, Arapahoe County, or Civitas don't with respect to drilling under the Superfund site. And as he said, probably a lot. Indeed, Mr. Amara repeatedly stated that he isn't, quote, saying that something will happen, just that it could. And also, we don't know what we don't know. And finally, just because something bad has not happened in the past doesn't mean it won't happen in the future. Finally, I think the most concerning statement that Mr. Amara made in his testimony was that Civitas can do more studies, but those studies can very likely be inconclusive. So we won't know the hazards of fracking until you frack, and then it's too late. Therefore, you shouldn't frack. In other words, Mr. Amara is saying, I want more to be done, but even if more is done, we'll never know, so just don't do it. Now, I'm not saying that Mr. Amara's concerns or testimony are wrong, but these pontifications are not expert assessments based on facts, data, or specialized expertise. Second, we'll look at his conclusions on migration through the Pierre Shale. Here again, there's no specific expertise used to create conclusions, but instead, more possibilities. Mr. Amara simply notes that faults could cause a pathway to the surface through the Pierre Shale, and that if a well leaks, it could allow the release of oil, gas, or produced water from the production zone into aquifers. His testimony beyond this statement of a possibility is showing examples of wells that have leaked. He doesn't explain that anything specific to this project increases the possibility of such an occurrence, or that BMPs and regulations are not sufficient to minimize the risk of such an occurrence. Third, Mr. Amara opined that there was insufficient water monitoring. Rather than providing any expert analysis to analyze the sufficiency of water monitoring, he simply thinks that the centralized E&P waste facility rules that EMC has are better and what he would expect. And as he said, quote, there's room for improvement in the ECMC rules. It's important to note that the increased monitoring for centralized E&P waste facilities is increased due to the presence of large pits and storage capacity held for years. For example, the Harrison Creek Treatment Facility in Colorado is designed to treat 60,000 barrels of produced water per day, with on-site storage capacity comprising 300,000 barrel pits and almost 15,000 barrels of on-site storage in tanks and process vessels. This is far in excess of the storage and production of a well pad, despite Mr. Amara's comments that really the equipment there is the same. Finally, Mr. Amara's expert report discussed inadequate setbacks. While the report discussed wetland setbacks, his testimony before the commission only mentioned the lack of wellbore setbacks, specifically that there are no ECMC setbacks of wellbores and no processes to avoid existing wells. ECMC engineer Diane McCoy was brought in to clarify that ECMC does have an extensive evaluation process and wellbore setbacks, including vertical separation, exist to avoid communication between wells. Again, there was no specialized analysis by Mr. Amara here, just a conclusion that setbacks are missing, which they are not. His testimony similarly at other times seemed to ignore existing and updated regulations about flow lines and wellbore integrity, as mentioned before. Finally, a concern I have with Mr. Amara's opinions is the prejudice language used in his comments in Exhibit F. He states, quote, "Civitas are accomplished at greenwashing and marketing that they are carbon neutral leaders in EHS compliance and protection of natural resources." He goes on to say, quote, "If Civitas put a fraction of the efforts they have in expended greenwashing, downplaying, ignoring, or denying providing misleading or non-factual rebuttals to legitimate scientific and technical concerns related to risks this project presents to human health and the environment, then perhaps this application wouldn't be so problematic." Without judging the accuracy of these statements, these comments do not support the depiction of Mr. Amara as an unbiased expert focused on using technical or otherwise specialized knowledge to help the trier of fact to understand the evidence or to determine a fact and issue in this case. Nor is he applying scientific principles and methods to the facts of this case, factors critical to qualifying an expert witness. Given the concerns I had with Mr. Amara's testimony, I thought it was important to look at other evidence presented concerning induced seismicity in this case. First, the presentation provided by the city of Aurora. Mr. Amara expressed concern about this presentation because, one, it contains old data, and two, Mr. Moore, the creator of the presentation, indicated that Aurora is not the relevant local government regulating these wells. With respect to age, the presentation also includes newer data and conclusions, and even Mr. Amara indicated that some of the best geology work was conducted 150 years ago. I'm not sure I understand the second concern, as the city of Aurora is an unbiased third party, which does have an interest in ensuring that its residents are safe. Moving on to the specifics of the presentation. The Aurora presentation indicates that prior work was done to evaluate potential faults in this area, specifically around Lowry Ranch, the Superfund site, and the Aurora Reservoir, none of which indicate any geological concerns, i.e. faults. And perhaps the two most important citations in the report concerning faulting are, one, a USGS report from 2011 that indicates no shallow faults are found in the Denver Basin near the Aurora Reservoir, and any faulting would have no substantial effect on aquifers. And two, a 2011 Colorado Geological Survey prepared cross-sections that go through the Denver Basin and specifically the area of the Aurora Reservoir, showing no evidence of any faults or other discontinuities between wells. Again, I do not presume this means that there might not be faults, as I do believe that Mr. Amara is correct that even the additional information he seeks may be inconclusive. However, I do view this as evidence in addition to the testimony provided by the operator, suggesting that no faults are present, which would increase the risk of induced seismic events. Notably, the Aurora presentation includes additional information that I believe further supports the minimized risk, including a list of historic earthquakes in Colorado, none of which are in Arapahoe County or close to the reservoir. Studies performed when the dam was built showing, quote, low earthquake potential. A summary of a 2012 seismic survey conducted near the dam that showed no concerns. The presence of existing hydraulically fracked wells underneath Aurora without concern, and the presence of 11 wells that have been drilled and fracked under the plume of the Superfund site that have not caused any damage. Similarly, the EPA provided correspondence which is telling. Despite Mr. Amara suggesting that the EPA must know something that Civitas, ECMC, CGS, and Arapahoe County do not, the EPA letters and correspondence instead indicate that it will look to ECMC's expertise and will continue to work with ECMC staff to assess site-specific proposals to ensure any risk that may exist is minimized. This is a far cry from what Mr. O'Mara requested, that we avoid the western 4 miles of the projected cap boundary. Again, a conclusion for which I could not find any support or expert analysis. Ultimately, I believe Mr. O'Mara's testimony drills down to the opinion he suggested to me in the questioning, that we will never know if a risk exists, even with additional testing, due to the possibility that it will be inconclusive. Therefore, since we don't know the risk, we shouldn't take the risk. This request for a 100% guarantee is not consistent with our legislative mandate, nor is it possible to accomplish in any situation. For example, cars are built with increasingly improving safety standards, but it doesn't eliminate the risk that accidents happen or people will get hurt. While the absence of evidence is not evidence of absence, the existing seismic data, lack of any earthquakes near Lowry Ranch, lack of any evidence of induced seismicity from hydraulic fracturing, recognizing there is evidence of induced seismicity from wastewater disposal, which is not proposed in this area, and the existing evaluation done by our knowledgeable and experienced staff, I believe the risk of seismic dangers is appropriately minimized under the CAP proposal consistent with our rules. Next, I'd like to address Dr. McMullen's testimony. At the outset, there were public comments suggesting that this testimony was a surprise and therefore improper. It's again important for the public to know that Dr. McMullen was identified as a witness ahead of time for the hearing consistent with our procedural requirements. So I do not find anything improper with using her testimony. I want to note that there are many public health studies, each suggesting different distances for which impacts may be impactful. Dr. McMullen pointed out some of the concerns with studies referenced by the STAR members, and I do take those into account. Dr. McMullen also suggested that there are causal links to health impacts even closer to the well. Now, I think it's important to note this is different than what Mr. Foote indicated in his closing, that she claimed it's safe. That's not what Dr. McMullen said. She rather said there are no causal links to health impacts, which is an important distinction. Regardless, I'm not sold on her argument there and contend it is still critical to avoid and minimize impacts to public health, the primary method of which is making sure that sufficient distance exists between the oil and gas operations and residential business units. Given the different points of view, I do look to the consultation provided by our sister agency, CDPHE. They have expertise in this issue and identified numerous BMPs that Civitas has agreed to, which would protect public health and air and water resources. Given the distance from the RBUs, I do believe that these BMPs minimize adverse impacts and can and should be expanded upon the site-specific OGDP stage should this CAP be approved. Next, I'd like to address some points from the State Land Board. I think there are several things that are critical with what we heard from the State Land Board. Most notably, the State Land Board also required surface disturbance in limited areas, particularly where prior existing development has occurred. And I think the fact that both the State Land Board and the operator took such great lengths to try and make sure that they avoided areas that were meant to be avoided, they minimized anything in areas that should be avoided, and they worked repeatedly on making sure that it matched what the State Land Board sought is an important factor to consider here. Additionally, as was testified to, outside groups, including the Nature Conservancy, CPW, and others were involved in developing BMPs for the State Land Board that will be applied to the lease. And as we have heard, the State Land Board does an internal and external review, including permits from outside groups and local governments and regulators. And thus far, all of the BMPs and all of the lease provisions have been adhered to by Civitas. Finally, I think another important point that was raised in the State Land Board testimony is that there is existing development and other industrial uses in this area. Now, this is not to say that because there's other industrial uses that it's fine to have oil and gas, but I do think the fact that there's, again, testimony that suggests that everything is fine right now and would only be destroyed by oil and gas operations in this area is a far cry from what's actually happening here. We do see oil and gas operations in this area. We have not seen impacts from oil and gas operations in this area. Similarly, we do have a lot of other operations, including, as was mentioned, a quarry in this area, which has not caused the purported problems that STARS seeks to prevent. Next, I'd like to talk about some issues with the Bureau of Land Management. There are several concerns here. First is a concern over outstanding mineral issues. As requested, in response to questioning, the operator here indicated that they have sent title information to BLM and they're awaiting a response. I recognize that, but do want to note that there are outstanding mineral issues. Additionally, there are concern over minerals that will not be developed pursuant to BLM regulations, specifically in areas with housing. And finally, there's the fact that some minerals are not currently leased. Thus, if this cap were to be passed, Civitas could face a situation whereby the minerals are not leased at all, or where a different entity is successful in bidding on the lease. I do recognize that subsurface issues such as these can and will be resolved with respect to drilling and spacing units at a more site-specific level, but I do want to highlight the lack of certainty in potential operations. This also segues into my next point, which is overall concerns with the comprehensive nature of this cap. Consistent with Rule 314E, Crestone has submitted all required information necessary for a cap. Of particular note is his landscape level planning to consolidate wells and infrastructure in an effort to minimize adverse impacts. I quickly want to touch on the produced recycling here. I know Mr. Foote indicated in his closing that they should be required to recycle, but there are recycling difficulties in the DJ Basin that are not present in other areas such as the Piceance Basin, where recycling is abundant. Additional work on recycling is being done on this issue, and we as a commission will be working on rules moving forward based on recommendations from the Produced Water Consortium. Commissioner Messner is far more knowledgeable in this area and can provide more information on this than I can. However, there are certain aspects of a cap that can be included here, despite the fact that they have submitted the necessary information, that are not detailed or included here. These include the use of preliminary siting and additional site-specific information that is required with preliminary siting. To be clear, preliminary siting is not required in a cap, and the previously approved Bronco cap did not utilize preliminary siting. However, like the Bronco cap, the proposed locations here are unlikely to move significantly at all, given the approval of siting from the State Land Board. Additionally, I applaud the efforts to electrify well pads, but as Mr. Foote explained, this is based on feasibility. Additional uncertainty also exists with respect to the BLM minerals and whether they can and will be drilled if the project is approved. Ultimately, there are many aspects of the proposed cap that are slated to be analyzed at a future point. I do not think that comprehensive planning I do think that comprehensive planning should make every effort to finalize these factors ahead of time, rather than pushing the cap forward with outstanding issues to be determined. While far from perfect, I do believe that the requirements of Rule 314 are met here, and the proposal provides necessary and reasonable protections for, or minimizes adverse impacts to, public health, safety, welfare, the environment, and wildlife resources. Of particular note of this conclusion is the fact that the proposed locations in the cap have been continually moved at the behest of the State Land Board and Arapahoe County, which now has setbacks that far exceed those of ECMC, which are based on scientific studies to minimize adverse impacts to public health. I do want to say that I appreciate STAR's concerns and their continued involvement in this process, and if approved, I do hope that the group continues to push for strict protections as development reaches the OGDP stage. And those are the remarks I have now, and I'll be happy to answer questions and deliberations too.
Thank you, Commissioner Cross, for the extensive comments to start the deliberation stage. Commissioner Messner.
Thank you, Mr. Chair. Thank you, Commissioner Cross, for starting us out here. I also have, I think, relatively extensive comments on this comprehensive area plan application. so apologize for the time that this might take. But first, I do want to explain the review process and decision-making criteria I utilized for the comprehensive area plan application. When reviewing the application, I first looked to ensure that all the required elements of the application have been submitted, then review the contents of the submittals, paying attention to the detail provided into each submission to ensure that it meets the requirements of the rules and the act, understanding that the applicant has the burden of proof to make a showing that their submittals, that they have met it within their submittals, that they have met this burden, whether I can make a determination based on their submittals and the detail that is within their application, that it is protective of public health, safety, welfare, the environment, wildlife resources. I think it's important to note that the purpose of the comprehensive area plans, which is indicated in Rule 314A, the Commission intends for comprehensive area plans or CAPs to facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for one or more operators to develop oil and gas locations within a region while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, and wildlife resources in the region through systematic planning of infrastructure location, best management practices, and centralizing facilities. This is also further clarified in the Statement of Basis and Purpose on page 108 and 109. Quote, the Commission decided to substantially revise the CDP process, both to create better incentives for operators to conduct broader landscape level planning and to implement Senate Bill 19-181's requirement that the Commission evaluate and address the potential cumulative impacts of oil and gas development. In Rule 314A, the Commission articulated the purpose of CAPs. First, CAPs are intended to facilitate the evaluation of the cumulative impacts of oil and gas development over a broad geographic area, and to address those cumulative impacts by developing infrastructure and other planning tools throughout the area in a way that minimizes surface disturbance and other adverse impacts. Second, because CAPs are voluntary, they are intended to provide incentives for operators to conduct broad landscape level planning by awarding exclusive operatorship rights over a large area to the operator or operators who propose the CAP. End quote. In addition to the above references, the intent of comprehensive area plans was also highlighted by the ECMC Director's Report published on July 2nd, 2024, evaluating air quality permit modeling and cumulative impacts in response to a July 12, 2022 letter from Governor Polis to CDPHE, DNR, and COGCC. Quote, CAPs provide operators with unique permitting solutions, including extended 6-year expirations, efficiencies in OGDP permitting, and an opportunity to demonstrate avoidance, minimization, and mitigation of adverse cumulative impacts and increased beneficial impacts through regional planning, consolidation of facilities on fewer locations, and efficient development of utilities and other infrastructures such as access road and pipeline corridors, end quote. The decision criteria for determining whether or not to approve a comprehensive area plan also lies within the rules, specifically in Rule 314H. For approval, the Commission may approve a CAP that complies with all the requirements of the Commission rules and protects and minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. For denial, if the Commission determines that a CAP does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, or fails to meet the requirement of the Commission rules, the Commission may deny the CAP. And for staying the application, if the Commission determines that additional information or analysis is necessary for it to make a decision to approve or deny a CAP, it will issue an order staying consideration of the CAP for further consideration until the director or operator can provide the Commission with additional information or analysis necessary to consider the CAP. I read the above rules as indicating that first, the Commission must determine that the application complies with all requirements of the Commission rules. Second, it must determine that the application protects and minimizes adverse cumulative impacts to public health, safety, welfare, and the environment and wildlife resources by providing necessary and reasonable protections for or minimizing adverse impacts. This is in line with the purpose and intent of comprehensive area plans to evaluate and address cumulative impacts from proposed oil and gas operations over a broad geographic area through systematic and comprehensive planning of infrastructure, development of landscape level best management practices, regional planning, centralizing facilities, and developing evidence through submittals of how the application addresses avoidance, minimization, and mitigation of cumulative impacts. I think this last piece is an important element of my decision-making process. We have clearly determined that up until this point, the utilization of comprehensive area plans is one of this agency's primary tools to evaluate and address cumulative impacts. While it is possible that an operator may submit all of the necessary plans, maps, narratives, and studies to satisfy the submittal requirements of Rule 314, what is contained within those submissions when evaluated independently and collectively must clearly show that the operator has adequately evaluated and, most importantly, addressed the cumulative impacts of the proposed development. I am not sure that the applicant has met this burden of proof in this application, and I'll share a number of reasons why I feel that this is the case. First, I do not believe the application meets the purpose of the cap in Rule 314A nor the requirements of Rule 301A. As indicated before, the purpose of comprehensive area plans are to facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for one or more operators to develop oil and gas locations within a region while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, and wildlife resources through systematic planning of infrastructure location, best management practices, and centralizing facilities. On many fronts, this application lacks the commitments and evidence within their Rule 314 required submittals and showings to make a determination that what is being proposed avoids, mitigates, and minimizes potential cumulative impacts to public health, safety, welfare, the environment, and wildlife resources, and therefore is protective. It is possible that the applicant would like the benefits associated with the cap without adequately evaluating and addressing cumulative impacts by using the time allotted within the cap approval process allotted within the cap approval to plan and develop the necessary infrastructure to address cumulative impacts as is intended for cap applications. A few examples are as follows. Number one, throughout the application and testimony, much of the detail necessary to comprehensively evaluate potential cumulative impacts of this development have been deferred to the OGDP process. And while it is true that there are separate OGDP processes for any location contemplated within a cap, by deferring this detail to the OGDP processes, rather than evaluating and addressing it at the cap application stage, I find the applicant does not meet its burden of proof to show how it is evaluating and, most importantly, addressing cumulative impacts of the cap as a whole, and is therefore protective of the public, the environment, and wildlife resources. Number two, in Rule 314E8, which is regarding infrastructure planning, the applicant is required to provide a narrative proposal with appropriate supporting documentation demonstrating the operator's plan to consolidate infrastructure within the cap, the timeline for installing any new infrastructure relative to the planned construction dates for the proposed wells, and a discussion of any approvals necessary for the infrastructure to be built. The applicant has provided a short narrative without any supporting evidence or documentation on a number of infrastructure items, and again is deferred to the OGDP process for details, but without a level of detail and evidence at the cap application level, it is impossible to determine whether or not the applicant has adequately addressed the cumulative impacts associated with the proposal. For example, when the applicant has indicated they will try to electrify drilling and production operations, there's no firm commitment for either and little evidence provided as to the efforts made towards these, and that was only presented after being requested at hearing. And again, that evidence provided was only anecdotal. No documentation provided to any barriers or communication between the electrical provider and the applicant. So I'm left to only believe the applicant's word, which does not comport with the supporting documentation requirements of the rule. Another example is any attempts to minimize fresh water use and operation, which has been clearly indicated as a significant concern to both the residents and relevant local government. The operator has indicated it is exploring efforts for reuse and recycling of produced water, but provided no detail, no supporting documentation as to these efforts and any infrastructure planning necessary to facilitate these efforts. So it is impossible for me to determine whether or not the applicant has evaluated and addressed cumulative impacts and minimized impacts associated with water use. It is possible to have a level of reuse and recycling of produced water in operations in the DJ Basin. A third concern is the lack of information regarding transportation infrastructure planning and traffic impacts in coordination with the relevant local government and any other applicable agencies. Truck traffic associated with oil and gas activities is a significant cumulative impact to area residences and is not addressed adequately in this application. Emissions, noise, water availability, and traffic are all identified cumulative impacts that have the potential to affect public health, safety, welfare, and the environment, and have not adequately been addressed in the submittals of this CAP application. Number 3, there are a number of submittal requirements located within Rule 314E10 with the intent indicated on page 114 of the Statement of Basis and Purpose. Quote, other informational requirements of Rule 314E10 are different than the informational requirements of Rule 303A5 because the cumulative impacts of a CAP occur at a broader landscape level scale, while the cumulative impacts of oil and gas development plan are more likely to occur at a narrow, more localized scale, end quote. Another reference to the submittal expectations is explained in guidance documents developed for operators regarding Rule 314E10, which states, quote, the cumulative impacts documentation should satisfy all components required by Rule 314E10 and should include appropriate references to each rule section, include all quantitative and qualitative data used to evaluate incremental adverse impacts and beneficial contributions to each resource listed before that are likely to be caused by oil and gas operations associated with the proposed CAP. Data will include summary of best management practice or other measures the operator has employed or plans to implement to avoid, minimize, and mitigate impacts to the following resources: air resources, public health and safety, water resources, terrestrial and aquatic wildlife and ecosystem resources, soil resources, public welfare, and disproportionately impacted communities. While it appears that the applicant has submitted the framework for each of the required elements, the information provided in some of the submittals do not clearly indicate to a reasonable and necessary level how the applicant is addressing the potential cumulative impacts identified within those submittals. Some examples include, for public health, the applicant has submitted a study provided by CTEH on different locations with different infrastructure and characteristics than the operations being proposed in the application. Specifically, the CTEH study evaluates facilities connected to grid power for drilling and production, which is not committed to in this application. While I do think that the study provides insight on the potential adverse direct cumulative impacts to health associated with 3 well pads, 2 in drilling phase and 1 in flowback phase, I struggle to see where in the application it ties the operational timeline and technologies committed to within the CAP application to the findings determined within the study. The witness testimony from CTEH, Dr. McMullins, regarding oil and gas operations as close as 100 feet, does call into question bias and contradicts this commission's determination during the mission change rulemaking that based on a number of studies and literature reviews, there is a potential health impacts associated with oil and gas activities in proximity to people, as indicated on page 222 of the Statement of Basis and Purpose. A second item is that there is a lack of a comprehensive wildlife plan that makes a showing of how potential cumulative impacts to wildlife will be addressed. Much of the information that has been provided has indicated that the details of this information would be determined at the OGDP stage, but by doing so does not adequately address the potential landscape level cumulative impacts of this development. One specific example of this is the lack of commitment to landscape level timing stipulations, which have been indicated by CPW, our agency's wildlife expert, as an essential BMP for addressing cumulative impacts. It is also clear based on testimony and evidence in the record that the noise analysis that was developed as part of Rule 314E10 submissions was not performed utilizing US standards, overestimate the true ambient noise environment, and this was admitted to in Crestone as not adequate to the point that they, again, will want to deal with this at the OGDP level, but it is necessary and reasonable to include this quantitative and qualitative information at the CAP review level as it goes to whether or not the applicant is adequately evaluating and addressing potential cumulative noise impacts based on sound mitigation and equipment chosen for oil and gas operations and is protective of public health, safety, welfare, the environment, and wildlife resources as required by Rule 314.10F Romanet 2, and so the submittal needs to be accurate at this stage. The relevant local government and its residents have concerns about wildfire risk associated with the operations in tall Piedmont prairie grass locations, which was not addressed in any submittals at the CAP level. It was a known potential cumulative impact, which would be important for addressing the potential cumulative impacts of the proposed development, particularly on public health, safety, and welfare, but rather details were deferred to the OGDP level, which does not adequately address the potential cumulative impacts associated with wildfire risk and CAP plans for minimizing and mitigating this risk. The same goes for overarching emergency management planning, supporting documentation that would speak to whether the applicant has evaluated and addressed potential cumulative impacts. This landscape level master planning is a reasonable and necessary for this CAP application based on the potential risks present and identified and indicated by the local government as residents, and is necessary and reasonable to evaluate and address cumulative impacts. The relevant local government and its residents have expressed concerns regarding water use and as indicated previously, no planning or considerations for addressing the cumulative impacts associated with water use from a CAP-wide perspective were included in the CAP application. So I cannot determine if the application addresses the concerns around the potential cumulative impacts. There are also issues with the potential proximity of proposed pipelines to water bodies used for drinking waters that have not adequately been addressed, so I'm struggling to make a determination that the potential impacts have been avoided. I do not believe that the information provided in the submittals regarding disproportionately impacted communities make a clear enough commitment to how the applicant will address potential cumulative impacts to identify disproportionately impacted communities as required by our rules and House Bill 21-1266. Many of the commitments have non-committal language, such as strive to comply with environmental and regulatory laws, regulations, and requirements applicable to our activities. It's currently evaluating its stakeholder process. It plans to develop economically practicable strategies to mitigate risks and avoid negative environmental impacts. It will strive to reduce business impact on the environment. It will work with industry groups and regulators to develop sound, fair, and realistic laws and regulations. These vague and non-committal efforts do not meet the burden of proof to address potential cumulative impacts to disproportionately impacted communities. Moving on from the submittal requirements in 314E10, there are a number of other outstanding issues that make it hard for me to determine if this application evaluates and addresses potential cumulative impacts associated. There seems to be a lack of comprehensive planning associated with the relevant local government in this review process. As CAPs are large landscape level planning efforts, inclusion, consultation, and communication with the relevant local government is essential An incorporation of the local government's comments, considerations of their concerns is necessary to ensure the comprehensive planning associated with CAPS is supported by the local government. In this case, the communication and consultation between the applicant, the state, and the relevant local government has been just disjointed. The timing with the local government process is awkward, and lack of clarity as to the evolving concerns and expectations makes it hard to determine whether or not this proposal complies with local government land use requirements and regulations. It appears this CAP application is being pushed too far ahead of local government planning efforts, which does not allow me to determine if potential cumulative impacts associated with this application have been adequately addressed. Number 5, there are unresolved issues associated with federal mineral ownership, securing of leases, and other federal requirements associated with this CAP application that, in my opinion, need to be resolved before I can determine whether or not this application meets all the requirements of our rules. Should certain leases not get obtained or permission to drill through unleasable minerals not be granted, it would constitute a significant change to this application and require additional administrative and hearing processes by the agency and the commission, and could change the evaluation and addressing of cumulative impacts associated with the application. So it makes me unable to determine that this application meets all of the rules. Number 6, and finally, there seems to be unresolved issues regarding setback distances associated with the Lowry landfill, which is designated as a federal Superfund site. The EPA has determined that a protective setback need be developed to ensure protection of public health, safety, welfare, the environment, and wildlife resources, but they have not provided a prescription to this. A second letter from EPA seems to indicate that ECMC staff has the expertise to determine what that setback may need to be. However, the applicant has the burden of proof to propose operations that meet our rules, evaluate and address cumulative impacts, and is protective of public health, safety, welfare, the environment, and wildlife resources. The applicant has not provided clear evidence that it has proposed an adequate setback to ensure operations will not affect the Superfund site. And while staff has commented on the record after given a short amount of time to respond, I am uncomfortable about the level of review that actually occurred to make any determination on the setback consideration without an independent third-party review and recommendation on what a protective setback may be. So I can't make a determination that what is being proposed is protective of public health, safety, welfare, the environment, and wildlife resources. It is for these reasons, based on evidence and testimony submitted in the application and at hearing, that I disagree with the director in her recommendation for approval and do not believe that the applicant has met their burden of proof to show that they have met all of the requirements of our rules, nor have shown that the application protects and minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. It is possible that the applicant has missed the point of comprehensive area planning, its intent to evaluate and address cumulative impacts on a landscape level and provide reasonable and necessary information, planning, consultation, outreach, and coordination to develop a CAP that analyzes and addresses cumulative impacts within the rules provided in order to gain the benefits the rules provide. It is possible that the operational timing of the operator has taken precedence over the necessary and reasonable efforts to avoid, minimize, and mitigate these adverse cumulative impacts of the application. It is also possible that one or more of the locations proposed could meet the rule requirements for individual OGDB submittals outside of a CAP application process, which is where the applicant has indicated it will provide sufficient evidence to determine the protectiveness of their proposal. However, I find that the CAP application as a whole, as presented, does not meet the intent and requirement of our rules and is not shown that it is protective and does not show that it minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources, and in my opinion is not approvable. Thank you, Mr. Chair.
All right, thank you. Commissioner Ackerman.
Thank you, Mr. Chair, and I appreciate the comments of my fellow commissioners and appreciate them leading off and My comments may be a little lengthy as well and contain some of the same information that we've heard so far. That said, I do want to go through them and give the those who are listening kind of my thoughts on these hearings and meetings and extensive CAP process that we've been through. I first, like the others, want to also thank every person associated with this application, with its processes, with its public meetings and hearings, for your considerable time, talents, resources, and personal and professional efforts. Over the course of these CAP hearings, we've heard a diversity of opinions, pleadings, thoughts, and counsel for our consideration in evaluating this application. And as Commissioner Cross stated, I also sought out and considered significant further information regarding questions and concerns raised at the May 16th public meeting. Despite seeking additional information, I made no pre-hearing decision as to whether or not to approve this CAP application. However, like Commissioner Messner, I reviewed provided materials prior to these hearings to determine whether or not, in my judgment, the applicant met the burden of proof that the application is compliant with our rules and their associated mandate to protect public health, safety, welfare, the environment, wildlife resources pursuant to rule number 314H. As has been stated in deliberations, a part of these proceedings included a witness for Star testifying on a couple of occasions that absence of proof is not proof of absence. In absolute terms, this specific statement is accurate, but does that mean that the implied inverse is true in substantiating an expert assessment that this application is not protective of health, safety, welfare, the environment, and wildlife resources? I.e., does it then follow that there must be 100% assurance and complete preemptive coverage for 100% of all potential conceivable contingencies in order for an application to be approvable? My contention is this is not the case. This is a concept that commissioners are left to grapple with in determining whether this CAP application meets the standards of our rules and is within the established framework of those rules regarding protection of public health, safety, welfare, the environment, wildlife resources. As a biologist myself, I'm very aware that 100% scientific statistical certainty is rare and often unattainable. As is often the case in scientific discussions, a key point of further exploration or decision-making then rests on the concept of confidence intervals, which is a valid and often used scientific determination mechanism. And simply put, a confidence interval is a measurement of the frequency with which a given parameter appears within the given study. And we talked a lot about things that could be in this meeting. We also talked a lot about things that have been so far. General confidence level analysis based thinking on all points of this CAP, along with ensuing detailed analysis and verification by expert entities, and understanding that much more detailed analysis and scrutiny of the individual pad permitting stage lead me to believe that the scientific methods employed in this application are sound. While numerous concerns have been raised by STAR, the substance of each of those concerns, in my opinion, has been appropriately addressed. Commissioner Cross cited several examples of this. In furthering the same point that issues have been raised and appropriately considered and addressed, I'll cite the issue of wildlife protection, as STAR and its witnesses have asserted from their point of view that this CAP is not protective of wildlife. CPW, the state's wildlife expert, had multiple consultations and site visits with the applicant. In CPW's words, quote, "Between HWA's studies and CPW's wildlife knowledge, this is one of the most extensive wildlife data sets of any oil and gas consult in CPW's Northeast region. CPW has also been consulting on these locations since 2022. CPW has reviewed Civitas's consultants' resource management recommendations in Exhibit OD, HWA report, Civitas's best management practices summary in Exhibit OA, and the wildlife portions of the cumulative impacts analysis in Exhibit O1. Therefore, CPW approves these BMPs with slight modifications, which they pointed out in their communications. And CPW has no objections to the wildlife components of this CAP application. Subsequent oil and gas development plans under the Lowry Ranch CAP will use the most current HPH occurrences at the time of submittal, as well as site-specific and species-specific avoidance, minimization, and mitigation measures. CPW further cites the Mission Change Rulemaking BMP, and it states, "The subset of habitats listed in Rule 1202D, while sensitive, are frequently managed by land managers and state wildlife agencies using impact minimization strategies, like co-locating facilities, and limiting the density of surface facilities or implementing surface disturbance caps. Evidence in the administrative record demonstrates that when properly regulated, development can occur within these areas in a manner protective of wildlife populations and their habitat. Compensatory mitigation is often utilized to offset unavoidable adverse impacts that occur in these habitats when impact minimization strategies are not successful. End quote. While CPW approves the general BMPs for this cap, CPW also discusses specific site-specific avoidance, minimization, and mitigation measures with Civitas before those OGDPs under the Lowry Ranch cap are submitted to ECMC and during the formal consultation process. This is one example to illustrate how I feel the resource-based concerns that have been raised have been addressed in this cap. However, does it then also follow that Civitas has met its burden with regard to comprehensive wildlife planning? As noted by Commissioner Messner, I think that lies somewhere in the middle. I think what I've stated so far implies that that's the case. I do not feel, as Commissioner Messner stated, that a comprehensive wildlife strategy has been put together specifically for the intents and purposes of this cap, at least not one that's presented in a cohesive rather than piecemeal fashion. In addition, I've stated in the past, though, that lack of significant public comment in ECMC processes generally denotes to me, and I take that usually as a lack of significant public consternation. And I believe the implication of that assumption is also true in inverse. If there's significant public comment in opposition to an issue before ECMC, I must then conclude that there is significant public consternation. So to me, while scientific means and discussions have been the focus of these hearings, the issue of whether to ultimately approve extraction processes on Lowry Ranch through approval of this cap and subsequent OGDPs relies significantly on community acceptance and social acceptance. As such, I considered three associated broad questions. First, is this an appropriate use of Lowry Ranch? As we heard today, Lowry Ranch is managed in stewardship by the Colorado State Land Board. They have a dual mission to produce reasonable and consistent income over time and to provide sound stewardship of the state trust assets. Those state trust assets are land they manage on behalf of the people of Colorado, specifically to benefit the education system with a land stewardship ethos in mind. The State Land Board is the entity tasked with appropriate management of Colorado state trust lands. And as such is the state's expert on management of those lands for the benefit of Colorado's public schools under the principles set forth in their strategic plan. The Colorado State Land Board are the conceivers and promoters of this project, and they have designed and issued a lease specifically to realize this project after a public process that they have deemed appropriate. At the time of State Land Board approval of the plan, as we've heard a number of times, there was no nearby community to speak of. While I believe personally a community update and more recent public State Land Board process associated with an issue of this magnitude near residents of this size would have been very helpful and appropriate in moving this issue forward, that is the State Land Board's purview and process decision. Nonetheless, this was a pre-existing publicly noticed planned use on the Lowry Ranch property in place significantly in advance of the encroachment of development of communities right up to the border of the Lowry Ranch property. That all said to say, I do not feel it is appropriate for this commission, as was stated, I believe, by Commissioner Cross, to determine whether or not this proposed project is an appropriate land use for this property. That decision is squarely within the stewardship of the State Land Board. Second, should this development take place in Arapahoe County? Once again, as I believe Commissioner Cross noted, there were many general statements in opposition, many of which are echoed in opposition and concerns in the general development of oil and gas. From the Arapahoe County guiding principles on their website, those include, among other things, enhancing its residents' quality of life, remaining responsive to community interests, promoting thriving communities, supporting communities for physical and mental health, protecting community quality and well-being, and understanding and responding to community values. The Arapahoe County Commission staff and various community leaders have reviewed this project in detail, and they've passed county-specific oil and gas rules, some of which are more stringent than commission rules, during which time this project was placed on hold until completion of that rulemaking process. The county and various community leaders have testified in support of this cap and have specifically requested its approval by this commission. A key focus of a county's mission is to enact the collective will of its people. I, as one commissioner, recognize and expect that the county and community leaders have strongly considered all aspects of their mission in formulating their determinations and recommendations, and consequently, I give significant deference to those leaders regarding the implementation of the desires of its residents. It is important to note that ECMC is not given jurisdiction over the way its citizens or organizations choose to use their lands, nor is it tasked with formulating and enacting the development goals or general desires and will of any given community. As such, my default perspective as a commissioner is to not overrule entities on those issues over which they have primary jurisdiction and stewardship. Finally, and the key question for me is this cap approvable under commission rules and the Oil and Gas Act? As has been stated a number of times in this and other hearings, the ECMC mission is to regulate the development and production of oil and gas, deep geothermal resources, the capture and sequestration of carbon, and the underground storage of natural gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources. In other words, to restate a point I believe made by Commissioner Cross, if a project is to be developed, ECMC must ensure that it is done so in a manner that prioritizes protection of these aspects. There has been significant administrative process by ECMC staff specifically associated with these protections. On one hand, we have a number of concerned citizens in an organized group citing public health, safety, welfare, environment, and wildlife concerns with some degree of specificity, but most often, as I noted, have voiced simple opposition to oil and gas development into the project in broad terms and less specific citing of impacts. On the other hand, we have the operator and numerous consulted entities specifically addressing the concerns that they considered and providing data studies and compelling evidence that impacts to public health, safety, welfare, the environment, and wildlife resources are appropriately addressed in this application. After significant administrative work to ensure proper protections are in place, the director confirms that the CAP complies with all applicable requirements of the Commission's rules, including all aspects of the regulations pertaining to health, safety, welfare, the environment, wildlife resources. In its opening statement, STAR asked the Commission to consider if the CAP protects public health, safety, welfare, the environment, and wildlife resources, and my focus as a commissioner is exactly that. Prioritizing public health, safety, welfare, the environment, and wildlife resources as this Commission considers whether applications are within the scope of its existing regulations, while also implementing best practices in developing oil and gas. For me, with significant focus on protection of the environment and wildlife as I sit in the Environment and Wildlife seat. To that point, the stewardship mission of the State Land Board is a significant portion of the sustaining of the land held in their trust, and wildlife conservation is a significant component of that mission. On one hand, from a wildlife perspective, the wildlife approach of this application is preferable to me over suggestions to move pads east, as current siting maintains more habitat continuity in the center of the Lowry Ranch property, in areas farther from the existing residential development, thus offering more protection to higher priority habitat areas. In other words, the residential development that has encroached right up to the property boundary has already, make no mistake about it, significantly and severely displaced and disturbed the wildlife that used to occupy the area where the houses now are, and to a lesser extent, the border areas of the Lowry Ranch where most pads are planned to be located. Ergo, keeping oil and gas development close to the even more impactful existing residential development disturbance is preferable to me from a wildlife perspective. We have heard expert input and public comment. We've heard witnesses from Crestone, Civitas, and STAR. We've heard proximate local government analysis and support. We've heard multiple public comments against the CAP and multiple public comments in favor of the CAP. And it's not lost on me that while STAR is adamantly opposed to this application, there's significant support from Arapahoe County and from various Arapahoe County community leaders. As has been pointed out, the CAP is intended to be a master planning process specifically designed to attempt to enhance the protection of public health, safety, welfare, the environment, and wildlife resources, after which significant continued stipulations can still be discussed at the permitting level for each pad. Arapahoe County has recently passed new oil and gas regulations, and we've heard during this hearing that in some ways, including setbacks, these regulations are more restrictive than ECMC regulations, the current form of which was significantly examined, debated, and established in accordance with Senate Bill 19-181, the legislation which included the mission change language frequently cited during these hearings. All that said, I also have some key concerns that remain related to this CAP, many of which were detailed by Commissioner Messner. And the primary one being that cumulative impacts planning I found to be lacking firm cohesive commitments on some issues and hedging on a number of BMPs, including electrification and comprehensive efforts towards transportation and plan-wide commitment to emissions reduction. All of these issues were discussed as part of this CAP, but largely commitments eluded us. And you heard from the operator, and this claim of the operator, in my opinion, has legitimacy. These commitments are reliant upon, in some cases, third-party efforts and ongoing efforts that aren't yet realized, but that they hope to realize. Therefore, this approach is one that's an honest approach from the operator, as opposed to one that promises and may not deliver. Probably the primary significant concern for me remains that the primary line of pad development remains closely adjacent to the line of significant residential development. Despite that development having developed up to the Lowry Ranch property, I believe it still is impactful, even if I personally feel that the uses of Lowry Ranch should be considered as a homeowner continues to purchase a property up and associated with its borders. That said, I agree with Commissioner Messner that I believe that this Lowry Ranch development, particularly with well pads very close to the residential line, will have some degree of impact on the nearby residents. From a human perspective, we've heard significant testimony that proximity of the proposed well sites, communities and schools is a key concern of STAR. And as demonstrated in the presentation and the provided materials, there is room to move the primary line of pads east without infringing upon the higher priority wildlife habitat towards the center of the property. Keeping in mind STAR's reminder that it is not mandatory to drill wells to the farthest extent of a DSU, as leaving some minerals in the ground does not constitute waste and may be preferable in some instances. I believe drilling and fracking underneath a heavily populated area in which significant numbers of residents of that specific area express significant opposition may make it appropriate to consider this approach. If this CAP is approved, I would expect there to be significant continued and ongoing efforts to work with county leaders and the community regarding practices that are found to be acceptable to the county and to the community as a whole during its future consideration of oil and gas specific sites. Specifically, I'd be looking for continued best efforts to minimize impacts on residents, especially on the State Sunlight Long pad, but also on the State Beaver, State Blanca West, State Sneffels, and State Wilson pads, which closely follow the Lowry Ranch west property line. So in summary, Mr. Chair, I feel that this CAP contains a lot of the components that are necessary for its approval. I believe it's been through significant process. I believe it's received significant support. Like Commissioner Cross, I do not believe it's perfect. Like Commissioner Messner, I do have some concerns that it can more closely comply with the intent and specificity of our regulations with a little more work. And so while this CAP has been in process for much time, my preference would be to continue the hearing and to continue to work on some of the issues that we've raised here in deliberative statements, and particularly focused on the cumulative impacts planning assessments raised by Commissioner Messner. Thank you, Mr. Chair.
Thank you very much, Commissioner Ackerman. I am not as equipped to be as elegant as my fellow commissioners. I appreciate all of the time and effort put in on your deliberations. I think where I start my analysis is looking at 314 as my fellow commissioners have done, and whether the elements of 314 have been met. I look at the director's recommendation. I look to the information received from the state land board and whether they find it consistent. I look to quite a bit to Arapahoe County and their take on this. I would note that they've recently developed regulations that I believe was in large part with Lowry in mind. And that they are supportive of that. And I believe that is something that we should take into account. I look to the discussions on CDPHE and their general comfort level with this at this stage. As we noted at the outset, commissioners, each of us did an on-site visit to the location. And I note that my on-site visit established to me that there are no homes. This is vacant land. This is ag land. The concerns that I think I have consistent with you, Commissioner Ackerman, and a little bit consistent with you, Commissioner Messner, are from a comprehensive perspective, some of the things that I think are important.
Mr. Chair, you've gone on mute for me. Is it just me?
Hello, can you hear me?
Got you now.
Oh, can everybody else hear me? Okay. I have some of the same concerns about the cumulative impacts and the fact that a comprehensive area plan is to provide to the operator a large-scale general master plan approval that should facilitate abilities to address cumulative impacts better. And the two areas of concern that I have are electrification. And I guess that's kind of my biggest area of concern. Transportation, Commissioner Ackerman, you brought that up. I believe that a lot of that is for local government consideration because they're in charge of roads and transportation aspects. But I believe if there was a firm commitment on electrification as to all sites, as opposed to just the first three, then I get to a place where I believe that approach provides me, at least, with a comfort level that at the comprehensive area plan stage, this is approvable. I also note for the record and for everyone as a whole, that the electrification issue, I get it, and I appreciate you realizing that too, Commissioner Ackerman. It's a little bit of a chicken or egg perspective, because while they have got commitments and paid the money for electrification for, I think, the first three sites, they're still in the evaluation stage for the other sites. I wonder whether the commission could feel and comfortable with an approval that requires electrification to be used for all sites. And I indicate that because electrification for the other sites is years out before they are in a place to actually start construction. I think that makes this much more approvable from a comprehensive cumulative impacts perspective. And I would note that a few years down the road, if electrification is not going to be available, they can always come back to commission for a relook at the comprehensive area plan, followed by a relook at the OGDP stage. I would also note that I think that it's important for us to understand that the comprehensive area plan stage is not the Form 2A stage. It's not the OGDP stage. It's not the right to drill stage that some of the folks had concerns about. Finally, I thoroughly appreciate STAR's involvement and STAR's concerns that are raised. I do come away with the perspective that a lot of STAR's concerns are in the more general oppositional phase as opposed to specific phase. And I note that when it comes to setbacks and residential dwelling, this application, I think, meets all of our protective standards, with only one home being within 2,000 feet and informed consent being there, and all the remainder of the homes being much further away. So I'm kind of on the fence here, but those are my initial stabs at deliberative thoughts. Apologies that I'm not as eloquent as my three other commissioners. Commissioner Cross?
Thank you, Mr. Chair, and thank you to my fellow commissioners for your comments. I fully understand where you're coming on this. As I said during my deliberative comments, I am troubled by the cap not including as much information as I think it could or probably should. Be that the electrification issue, which, as I noted, and as Mr. Foote noted, is based on feasibility. I do think that we did hear some information on it, payments being made to date, but still trying to understand whether it's going to be in time. And you compare that to, for example, the Guanella cap, where the operator made sure that they had the infrastructure in place already before the cap was brought before us. Again, I'm not sure that that's required under the rules, but I absolutely do see the concern with many of those issues as well. Ideally, preliminary siting would be done. Ideally, infrastructure would be finalized and set up so we could look at this all at the same time. I still maintain that I believe that the rules are met here. But I would be interested to hear my fellow commissioners' thoughts on, as Commissioner Ackerman noted, perhaps additional time to look at what else could be included. And as Chair Robbins, as you mentioned, perhaps getting a better understanding of when we might have an idea on electrification, kind of what that would look like moving forward in terms of the process.
Just in response to that last piece, Commissioner Cross, the only concern I've got about that is I don't know that we're going to be able to obtain from the applicant a firmer understanding of electrical commitments anytime in the near future. And so that chicken and egg thing sort of if we do that, that precludes approval of a cap and precludes the ability to continue to try to move forward. So that's my point on electrification, which is why I was kind of thinking out of the box in terms of making electrification mandatory and then hoping that that allows them the opportunity to go actually obtain it. But just wanted to segue off of that thought from you, Commissioner Cross. Commissioner Messner had raised his hand.
Thank you, Mr. Chair. Always appreciate your attempts to come to solutions. And I think that's a great aspect of how you approach your job. And so I do want to say I do appreciate that very much. I think I've said this before, but I think the quality of application materials received is the primary element determining timing of application review and ultimately determination of the outcome of the application. I think, as I indicated in my comments, my biggest concern is the quality of some of the submittal requirements and the detail that's provided within. And then putting that through a lens of that we review this different than we review an OGDP. We review this through the lens of whether it evaluates and addresses the cumulative impacts of the cap itself on a landscape level versus looking at the direct impacts of the OGDP review process. And so that's why I think you heard in my testimony continued emphasis on the cumulative aspect of it, because I do think, as indicated in the statement of basis and purpose and the discussions we had through the whole rulemaking process, that we did want this to be our tool, primary tool for evaluating and addressing cumulative impacts. I think the electrification piece is an important one. I think that, but I think, again, the operator has the burden of proof to show not just electrification, but if they're committing to something different, that they've evaluated and addressed cumulative impacts. I'm not sure that they've met that burden with what they've committed to. If they want to submit additional information to either show that they're intend to that they will electrify everything and then make a showing on how that addresses cumulative impacts. I review that independently. I'm afraid, at least from my opinion, though, that that's not the only thing that I have concerns with as far as application detail that's provided and how it addresses cumulative impacts. And so I couldn't just determine that that one thing would be enough. I mean, I've got in my testimony, information around, issues associated with wildfire, issues associated with water, and issues associated with disproportionately impacted communities. I have a little different, I guess, perception, and I think this is tough, right? Perception. My take on the local government process is that they were neutral on the application and not in support of the application, as they need to be neutral because they're going through a review process independent of the state. So, I do think this is a little ahead of that review process of the state and evaluating and addressing cumulative impacts, having that marry a little closer together and not being so far ahead certainly would aid the applicant in being able to meet their burden to show that they've evaluated and addressed cumulative impacts. So I think that there's a number of things is what I'm ultimately saying that, and so I don't know as I can refine it down to just electrification. So although again, I really appreciate your attempts at solutions.
No, I appreciate that. At least from this commissioner's perspective, some of those other things I don't have as much of a concern about. Emergency preparedness and wildfire associated with that is not something that 314 or our comprehensive area plan analysis requires at that stage. That particularly is at the OGDP stage. Similar, I thought that my notes reflected that there were not DIC concerns in this situation. So I don't have a concern there unless I'm completely missing that. And even like noise is to be done more particular. So there's still a lot to go here at the OGDP stage. And I, at least as for one, believe that it's a two or three or four pronged process for our consideration of this. Commissioner Ackerman, Commissioner Cross, any further?
Yes, thank you, Mr. Chair. I appreciate that. And and make no mistake about it, I do think there is an approvable cap, if not immediately before us nearby. Far be it from me to prolong the difficulty and pain and expense that people have gone through on all sides of this issue to continue to move forward on this issue. I do think there's a lot of responsible planning that has taken place here. I do think that this is an approved use of this piece of property managed by the Colorado State Land Board, as I mentioned. I do understand that people in proximity to other people's developments all often have concerns about those types of developments, and even more so with oil and gas. I do understand that there, as was mentioned by the STARS witnesses on a few different occasions, and well put by Commissioner Cross in a more esoteric way, there's a lot of things that could be. There are some risks associated with oil and gas development. And as I was pondering this driving the other day, I thought, as I was on a crowded roadway, I thought I'd be a lot safer on the road by myself, right? But in the end, that's not reality. That's not how we operate. My neighbor has the right to use that road, much as the Lowry Ranch property has the right to develop minerals, oil and gas. And we have the responsibility of ensuring that it's within our established regulations. And so I circle back to that point of this one felt close. It was complex, and so it's a difficult project to propose. My primary concerns did remain around the cumulative planning associated with the cap. And I think part of that was because Civitas was trying to be responsive to concerns as they came up throughout the process. And so there was shifting and some changes, and I think some kind of adaptations by Civitas to try to do so. In going back to what I think is one of the primary purposes of CAP planning, again, I wasn't on the commission at the time, but how I envision it is coming forward with a plan that clearly and specifically illustrates, hey, we have planned for wildlife on a global level here within these acres. We've planned for emissions in these global acres, and here's a demonstration of how we've reduced emissions associated with this cap over which would be presented on an OGDP by OGDP basis, and extrapolate that to the other instances of a cap. I do feel like all of these points were touched on, I think some more comprehensively than others. I just believe that there can be a more careful and concise and accurate demonstration of compliance with the regulations. And therein lies the difficulty of this decision for me. Does it meet the minimum standard of compliance with the regulations, or does it fall below that standard? And that's a very tough call for me at this point.
I would suggest to my fellow commissioners, and then I'll recognize you, Commissioner Cross, that, we've got, the option of deny, the option to stay. If there is, and that's where you kind of landed, I think, Commissioner Ackerman. If we exercise the option to stay, I think we have to be honest to our staff and honest to the applicant as well as the other stakeholders. What are we staying it for? What are the specific areas of additional consideration that need to be looked at in a closer vein? And I don't know, I don't know that I've got as many areas of concern, but if we're going to do that, I think we need to be very clear. Commissioner Cross?
Thank you, Mr. Chair, and I would agree with that sentiment as well. And I also think I fall into the boat of, I do have concerns, but I think I have less concerns than my fellow commissioners as well. I'm curious to hear others' thoughts. I know, Commissioner Messner, you obviously have talked a lot about not feeling that enough cumulative impact analysis has been done. And I'm curious to know your thoughts of future cumulative impact analysis that might be done under our future rules at an OGDP stage, and if that would sway you at all versus kind of the close call that we're at with what's presented in the cap.
And that may not even be a fair question, to be honestly, because I think Commissioner Messner would vote to deny.
Well, no, not necessarily. So again, I'm reviewing this and applying the cap rules. And so, the cap rules for the cap, have certain requirements associated with them. And, while a specific plan, isn't cited regarding wildfire or emergency management, if it's identified as a potential adverse cumulative impact through the process, then the rule states that the plans that are submitted as part of that rule are the minimums. There's not an exhaustive list, and if there's a cumulative impact that's identified, then it would make sense for me that the operator address it within their submittals. And I think that's the case with wildfire, for example. And so as I apply the rules and the intent of those rules, which is to evaluate and address cumulative impacts on the cap as a whole, I don't know as individual cumulative impacts analysis at the OGDP level accomplishes the same thing as a cap cumulative impacts analysis. Now, I may not think that this application meets the rules of the cap, but as I indicated in my testimony, this operator could submit individual OGDPs outside of a cap, and some of those, if not all of those, could potentially be approvable. And so while I don't think that the applicant has met the burden of proof on the cap, and I can certainly cite specifics, as you've indicated, Chair Robbins, as to what would need to be addressed if this commission was interested in staying the cap application. My recommendation, from my perspective, where I believe that the cap rules haven't been met, and to have a more efficient process for the applicant, staff, the local government, and the stakeholders, is that if this applicant wants to submit individual OGDPs outside of a cap process, then I think that's appropriate. But I don't think they've met the burden of proof for a cap application. So that's kind of my perspective.
Commissioner Ackerman?
Thanks, Mr. Chair, and I think your point is a fair one. And I understand that my comments were less citation specific and therefore more ambiguous, making it difficult for an operator to extract from that exactly my concerns. And so I'll try to restate them. Again, I won't have specific regulatory citations in front of me at this point, but could certainly provide those. And if I had to consider this cap in order of the things that cause me the most concern, first and foremost would be the proximity of the primary line of well pads to the line of residential development. I, as an operator, would consider all aspects necessarily that I could consider to move those sites further away while still being protective of wildlife. I believe there's room to do so. That's my primary concern. That said, that's not an argument for an operator not having met the submission for a cap. What I'm afraid that might lead us to, at least lead me to as one commissioner, is continuing forward with site locations under an individual OGDPs that are very near the residential boundary, albeit within the setbacks of our rules. They feel a little deaf to some of the concerns of the nearby residents, as opposed to promoting maybe a couple of opportunities for working together with those residents to minimize impacts, such as I noted, perhaps moving them a little farther away and not necessarily reaching exactly the end of the DSU, which I understand is not financially beneficial and not ideal. That said, that feeling from me is difficult to articulate in a way that they have not met the regulations associated with the cap, so will be frustrating to an operator as they try to address it. Being more specific, the primary concern that I had was akin to Commissioner Messner's, although he articulated it much better than I did, in that I believe the primary purpose of a cap is to consider a very comprehensive development plan. And it was stated by, I think, Starr, that this was, in their closing testimony, that this appeared to be a number of OGDPs put together, which obviously is part of a cap plan. But it did also appear to lack some detail in how we're aggregating the strength of concurrent consideration of these sites to be able to provide, as it states in our regulations, a clear and concise development schedule that minimizes cumulative impacts. I felt that there's an argument that that was lacking, although certainly there are different parts of the cap application that were submitted that could help me potentially dig out and concoct my own argument as to how that might all come together. So the best way that I can describe it, Mr. Chair, is that this cap may contain many of the components, if not all of the components necessary for a cap. I agree with you that significant further discussion will take place with more specificity at the OGDP level. But the way that it was put together and presented made it very difficult for me to cohesively determine that all aspects of comprehensive planning had indeed been met with regard to the cap.
I'll continue in my deliberations in that I'm not sure, and this is no reflection on any of us commissioners, but I'm not sure we have articulated well enough the areas of cumulative impacts that need to be further evaluated in a manner that would provide enough direction for the applicant to sort of know what more it needs to evaluate. And just in responding to your point there, Commissioner Ackerman, you pointed out the one primary area is the, I typed it up, primary line of development being fairly close to residential development. That is something that we're going to evaluate at the OGDP stage when we do alternative location analyses. And so I would throw out, and I know Commissioner Messner won't support this, but I would throw out that we approve the cap with the requirement of electricity and with the caveat that we are going to be looking closely at moving or evaluating at the OGDP analysis the alternative location analysis associated with each one, with this concern having been evident at the cap approval. That allows the applicant to move forward, that allows protections, more protections to be a requirement in terms of the emissions reductions with electrification, the noise with electrification, et cetera. And it puts the onus on actual location at the stage that it needs to be, which is at the OGDP stage. So that's my troubled musings here as we try to figure out what to do with this at this stage. It may be easier just to deny the damn thing. Excuse my language. But I still believe it is approvable with these caveats in place. Commissioner Ackerman?
Thank you, Mr. Chair, and I appreciate that. And as I stated, and you could tell from my testimony that I think significant work has been done and significant good work has been done. And you can tell that I'm very on the fence on this issue. I would be amenable to your suggestion, and I would reiterate that from my perspective, at least as one commissioner, that that conceptual location planning does not have significant standing at the OGDP stage moving forward. I understand that in a cap, those are the locations that were proposed. I would expect Civitas to be clear to consider the OGDP on pads that I have stated during my testimony along that line, are doing everything they can possibly do to be responsive to the concerns of citizens in the area. And I would expect a significant demonstration of that at the OGDP level.
I think that's kind of what I was getting at. Further deliberative thoughts from fellow commissioners? Commissioner Messmer?
And I will defer to Commissioner Cross before I speak if you've got thoughts, Commissioner Cross, because I've spoken a lot.
Commissioner Cross?
I'll just say I think I agree with the approach that you're proposing, Mr. Chair. Again, I feel like I'm in a little bit different boat, particularly with respect to Commissioner Messner, but I think even potentially with Commissioner Ackerman. I do see concerns with the cap, and I do think there's additional work that, again, could have and probably should have been done, but I still do think that it does meet our rules and is approvable. And so I believe I'd be in favor of kind of what you've proposed, Mr. Chair, to make sure that we can kind of take those next steps, and this additional site-specific analysis that is intended to be done at the site-specific stage is intended to be done at that site-specific stage. And I would hope, regardless of outcome, it would be clear to the operator that kind of doing this minimum, kind of just trying to check the boxes, so to say, is not really what we're looking for, especially with comprehensive planning like a CAP procedure. But I would be interested to hear your thoughts, Commissioner Messner.
So appreciate the creative ideas that are being thrown out, and with respect. And I want to make sure that everyone understands. I really do appreciate the creative thoughts that are going that are being shared here. I'm probably going to be more straight to the rules, and if I feel like it doesn't meet the rules, and to ensure that we have a clean record and a clean decision from my perspective, I probably would not support the proposal for the reasons I indicated in my testimony, and that it doesn't ultimately meet the submittal requirements of the rules and the detail within, and the requirement to evaluate and address cumulative impacts at the cap level. And so while I appreciate the creative solutions, and I'm not indicating that it may not be workable, I will not vote in support of it, respectfully.
That's fair. Commissioner Ackerman?
Thank you, Mr. Chair, and I appreciate the open and deliberative process that's taking place here. To the public, you can tell that we do not come into our hearings with preconceived notions of approval or denial, but yet rely upon the record and our study of the record, and certainly upon our discussion and the deliberations of fellow commissioners. We are not privy to the thoughts and discussions of fellow commissioners prior to them presenting them to you. And as we have these discussions, we're doing so also for the first time. I do have some concern with regard to the potential for and in my mind, the probability for individual submittals of OGDPs, as noted by Commissioner Messner, that are not within the boundaries of a cap, and not trying to at least trying to undertake the process for which we expect the cap to be utilized, which is tying those pads together in their comprehensive planning, which we can continue to do at the OGDP stage. For that, Mr. Chair, I do believe that I can be supportive of your proposal of moving forward, and once again reiterate my consternation and concern as each pad is considered. I'll be keeping a close eye on specific best management practices, community outreach, and opportunities to coordinate and cooperate with residents, while not within the boundaries stated through our regulations, are in some proximity to those OGDP locations.
AAG Davenport, could you visualize yourself? I assume you've been listening into the deliberation.
Yes, sure.
Could I get an assist and see if you could help put together my proposal into the form of a motion?
Of course. After listening to the deliberations, I think the primary motion is approval of the as presented with a modification that requires electrification for all facilities for oil and gas development within the cap. I know there was significant discussion about effectively notifying or warning the applicant that the commissioner will be looking closely at these locations. And I think it's clear in our rules that by approval of the cap, the commission's not approving any OGDP or location. So I don't believe that warning or notification to the applicant needs to be included in the motion.
So moved. Commissioner Ackerman?
I'm sorry, can I just ask a clarification on that motion, Mr. Chair? When you talk about electrification, are you talking about mandating electrification for the production of all facilities or throughout the drilling process?
Both.
Thank you.
Do we have a second? Go ahead, Commissioner Cross.
I hate to throw a wrench in things here. There was also a preliminary siting approval request for one of the locations. And so would the motion include that?
What are y'all's thoughts on that? We don't have a second yet, so there's not a pending motion. Commissioner Ackerman?
I am supportive of wrapping that location in. I don't know that that is an appropriate approach at this juncture. I don't think that we have enough information to really understand what the implications of that might be for the plan as a whole and for the applicants moving forward with that pad. That said, conceptually, I support that, particularly since this is the first pad to be developed or expanded, and some of that may take place within priority timing periods.
So what did you just say, Commissioner Ackerman? I'm sorry.
Thanks, Mr. Chair. If push came to shove, I would support inclusion of that pad in the motion that you just proposed.
So inclusion of the preliminary siting of the pad.
Inclusion of the electrification requirements of your motion on the on that pad.
And that it be approved with preliminary siting.
Correct.
Commissioner Cross?
Thank you, Mr. Chair. And I believe I would fall in the same boat there. Again, this would still require the OGDP. I think one of the key differences from this site compared to the others, as we talk about wanting to make sure that additional location analysis is done, is this is an existing pad that would be expanded upon, which I do think responds to some of those concerns about location assessment as well. So I would also be in favor of it.
Okay, so the motion would include the electrification provision as to the preliminary sited pad and approval of the preliminary site for that pad as well. That's our tortured motion. Do we have a second?
Second.
Okay, with that motion and second, I would just further deliberate on this while our AAG, I think, correctly noted that we don't need to provide the caveat that we're going to be looking tightly or closely at alternative locations that move the preliminary, that take the conceptual siting and look closely at moving them further east. I'm just providing that caveat in my discussion on the motion to the applicant. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. All those not in favor of the motion signify by saying aye.
Aye.
Motion carries 3-1. As Commissioner Ackerman noted, we strive to work hard with no pre-thoughts about this. That's why this took a while to move through deliberations. So we thank everyone for their participation, listening in, and we will take a break. We've got 4 other OGDPs to go through today. It is 12:22. Return at 1 o'clock. Had enough time to make a sandwich. All right, we'll see everybody at 1. All right, welcome back. This is the Colorado Energy and Carbon Management Commission business meeting. It is August 7th. It is 1 p.m. We've got a few more dockets to take up. I would note that Commissioner Oath is now with us for the remainder of the day. She was excused from the previous matter because it arrived before her term of office. And so, but we look forward to having you with us for the rest of today and going forward. So welcome. We now will take up docket 2306-00217. This is an oil and gas development plan. It is the applicant, it's Great Plains Energy Operating LLC. And I note for the record that attorney Chris McGowan is with us, and it looks like he's got 2 witnesses. Mr. McGowan, are your witnesses here and are they ready to be sworn in?
I believe so, Your Honor. We should have 2 witnesses, and then I believe the county is also here. They're not presenting, but they're here to be available as well, I believe.
Okay. Mr. Thomas, did you have anything procedurally before we head into this?
Just to note that we are currently looking for either Lincoln County or Ty Stogstill in the attendees list. We haven't found them at this time. So if they are in the attendees list, please raise your hand and we'll elevate you.
Okay, great. AG Mercer, if you want to swear in the witnesses.
Thank you, Mr. Chair, and hello, good afternoon, everyone. So for the witnesses, I'll ask you one at a time to raise your right hand, state your name, and that you swear to tell the truth. And Mr. Harrod, are you here on behalf of Great Plains or on behalf of the county?
Great Plains.
Okay, great. I'll begin with you then. If you could just raise your right hand, state your name, and that you swear to tell the truth.
I, Robert Harrod, state to tell the truth.
Thank you. Ms. Donahue?
Morning. My name is Jessica Donahue, and I swear to tell the truth.
Thank you. Ms. Fanning?
Good afternoon, Tricia Fanning. I swear to tell the truth.
Thank you very much.
All right, I believe we start with the presentation by Great Plains.
Thank you, Mr. Chair. Good afternoon, commissioners. I know it's been a long morning. We'll get to it. I also would like to welcome Ms. Oath. Welcome to your term on the ECMC. We're thrilled to have you. So I hope we start off and make your day great. So thanks for joining us. Good afternoon, Commission. My name is Chris McGowan. I am the attorney who represents Great Plains Energy Operating LLC, operator number 10801. We are here today to respectfully request and submit to you this request for approval for the Great Plains Extension Oil and Gas Development Plan, the Great Plains OGDP. The Great Plains is a registered operator in good standing with the Commission. Today, we seek approval of an approximate 160-acre OGDP for the development and production of 2 total vertical wells, 1 new and 1 reentry from a total of 2 oil and gas locations on the following lands, the application lands as they were: Township 7 South, Range 52 West of the 6 p.m., Section 23, which the Southwest Northwest quarter, and Section 23, the Northeast Northwest quarter. The Marquise 1, the reentry, is in Section 23 at the Southwest Northwest quarter, and the Marquise 2-23 will be in Section 23 in the Northeast Northwest quarter. The nearby public roads are County Road 3U and County Road 46. With this application, we did provide the staff as required an assignment of oil and gas leasehold interest for at least one portion of the mineral tract within the application lands, showing the applicant's status as an owner in accordance with ECMC Rule 303A1. We also we submitted the required Form 2A for the development from the proposed locations pursuant to Rule 303A2 and Rule 304. We have pending Form 2s, and we submitted Form 31 documents and Form 33 documents. Great Plains also submitted a Form 2B cumulative impact data identification pursuant to Rule 303A5, and we submitted a Form 2C OGDP certification pursuant to Rule 303A7. Pursuant to Rule 302E, Great Plains notified Lincoln County as the relevant local government that it planned to submit the OGDP application no less than 30 days prior to submitting this OGDP application. There are no proximate local governments within 2,000 feet of the proposed working pad surfaces of either well, and the Rule 302E 30-day notice letter did comply with the procedural and substantive requirements of Rules 303E2 and 3. As we noted, they are here today, or they will be tuning in at some point, and I believe Ms. Donahue will be addressing the local government permits in our presentation. Copies of the application and notice of hearing were served on each interested party as required by Rule 504A, 504B1, B2, B5, and 303E, and the completeness determination by the director was also served on the interested parties as required by Rule 303E. With the application, Great Plains submitted its required Rule 505 testimony and an application for a 160-acre DSU and covering the northwest quarter, the full northwest quarter of Township 7 South, Range 52 West of the 6 p.m. This application and testimony illustrated that the granting of this application is in accord with the Oil and Gas Conservation Act found at 3460-101 and the Commission rules. I will turn the presentation over to Ms. Jessica Donahue of Ardor Environmental now.
Good afternoon, Commissioners. My name is Jessica Donahue, Compliance and Permitting Specialist with Ardor Environmental, LLC, here today representing Great Plains Energy Operating, LLC. The topics that we'll cover for you today with this OGDP presentation will be an introduction to Great Plains Energy, the project overview, a timeline of the project, the proposed locations and details, anticipated operational timeline for execution of this project, some best management practices that Great Plains has incorporated, a couple statements regarding financial assurance and the applicability under Rule 702, and then finally, of course, a summary for you. Great Plains Energy Operating LLC, while being a new operator in the state of Colorado, does not lack the experience needed to operate oil and gas facilities in a prudent manner that protects public health, safety, welfare, wildlife, and the environment. Great Plains Energy is staffed by oil and gas professionals, each of whom have at least 10 years of experience spread across most of the oil and gas basins in the United States. Specifically, employees have operated in the state of Colorado for the last 10 years for a different operator. The staff is also very active in their communities, such as sitting on the board of the Regional Food Bank of Oklahoma, serving as co-president of the men's group at church, and volunteering at the Send Relief Ministry Center. On August 31st, 2023, the Great Plains Extension OGDP was submitted to the ECMC. On May 30th, 2024, completeness determination was issued by ECMC staff. On June 30th, 2024, the 30-day public comment period ended. No comments were received. July 8th, 2024 was the petition deadline for the OGDP. No petitions were filed. And on July 25th, 2024, ECMC staff issued the director's recommendation for approval. Great Plains has received a director's recommendation for approval of their proposed Great Plains Extension OGDP before you today. The Great Plains Extension OGDP proposes to develop 160 acres in the northwest quarter of Section 23, Township 7 South, Range 52 West. The OGDP proposes 2 oil and gas locations. The Marquee 223 is proposed in the northeast-northwest, and the Marquee number 1 is located in the southwest-northwest. The Marquee number 1 will be where the co-located production facility equipment will be sited. For geographic reference, the Great Plains Extension OGDP is represented on this slide as the purple star. It is approximately 29 miles northeast of Lyman and 11 miles from the closest town of Ariba. The nearby crossroads are County Road 3U and County Road 46. The OGDP project is located on surface zoned for agricultural use and is in non-irrigated cropland. The OGDP is located entirely in Lincoln County. As represented on this slide, the 2 oil and gas locations, the Marquee number 1 and the Marquee 223, are within the green boundary representing the proposed mineral development area. The Marquee 223 is a proposed new vertical oil well. The Marquee number 1 is a proposed re-entry of an existing well. As mentioned previously, the 2 locations will share production facilities at the Marquee number 1 pad. Produced fluids will be transported to the Marquee number 1 location via an off-location flow line. Also represented from the image on this slide, there are no residential building units, school facilities, high occupancy building units, or designated outdoor activity areas within 2,000 feet. The project is approximately 1/2 mile from the nearest RVU. Under Rule 304D1, Great Plains requested a lesser impact exemption from the noise and light mitigation plans. The director approved this request on September 20th, 2023. The census block that the Great Plains Extension OGDP is located in has an overall EnviroScreen score of 23.1. The project is not located within high priority habitat. The Marquee number 1 is a re-entry of an existing vertical well. The well was originally drilled and abandoned in 1985. The location has been fully reclaimed and will require new construction of approximately 7.7 acres of disturbance. After interim reclamation, the location will approximately be 2.5 acres. This location is not within high priority habitat and did not require an alternative location analysis under Rule 304B2B alternative location analysis criteria. The Marquee 223 location proposes 1 new vertical oil well. This location is in non-irrigated cropland and will consist of approximately 7.7 acres of new disturbance. After interim reclamation, the location will be approximately 0.9 acres. Similar to the marquee number 1, this location is also not within high priority habitat and did not require an alternative location analysis under Rule 304B2B. Lincoln County does regulate the siting of oil and gas locations per their land use code. Under Division 2, Section 2-200, oil and gas is a permitted use in agricultural districts. The Lincoln County oil and gas exploration permits for each location were submitted to Lincoln County in January of 2023 and approved February 1st, 2023. Great Plains estimates each location will take approximately 1 week to construct. Each well will require approximately 10 days of drilling activity. Pre-production preparation will be approximately 1 week. Neither well will be hydraulically fractured. Great Plains anticipates commencing the Marquee project fall 2024. Interim reclamation activities will initiate within 3 months of the wells commencing production. Reseeding and planting activities will be coordinated with the surface owner as the land surrounding the oil and gas locations are cropland. On this slide, we would like to highlight a few of the best management practices Great Plains has incorporated into their proposed operations. Lights will only be on location for drilling operations, approximately 1 week. Lights will be downward directed and highlight task areas as necessary for safety. There will be no permanent lighting on location during production. Great Plains currently does not anticipate the wells producing excess natural gas. The nearest gas gathering pipeline is approximately 12 miles away. Additionally, the Great Plains Extension OGDP is targeting the Cherokee Formation. The nearest well producing from the Cherokee Formation is approximately 9 miles to the northwest. This well produces de minimis natural gas, just enough to power some of the equipment on location. Should the wells, however, produce natural gas in quantities beyond what can be used beneficially on site, Great Plains will shut in production and submit a revised gas capture plan outlining the disposition of the excess gas. Great Plains will employ silt fences and straw wattles as stormwater and erosion controls. Great Plains will use fresh water for all dust mitigation. Great Plains will utilize off-location flow lines to consolidate heavy traffic to the shared production facility at the Marquee number 1. This will aid to minimize traffic and reduce long-term surface disturbance at the Marquee 223 location. Great Plains Energy Operating LLC is a new operator in Colorado. Under the current ECMC 700 series rules, there are no additional financial assurance requirements until Great Plains receives approval of their Form 2 APDs. Great Plains will submit a Form 3 initial financial assurance plan to ECMC within 10 business days of becoming an operator of record for 1 or more wells. This is anticipated to occur once the Form 2s have been approved and there are API numbers associated to Great Plains. Rule 702 does not apply to Form 2As and location IDs. Great Plains received the director's recommendation for approval on July 25th, 2024. Great Plains requested 2 lesser impact exemptions for the noise and light mitigation plans. Due to the distance from sensitive receptors, the director granted this request on September 20th, 2023. While no natural gas is anticipated to be found in the target Cherokee Formation, if natural gas is discovered, Great Plains will use any gas for beneficial use on site. And as I stated previously, should the gas be produced in quantities beyond what can be used on site, Great Plains will comply with ECMC Rule 903D. Great Plains has designed the Great Plains Extension OGDP to protect public health, safety, welfare, wildlife, and the environment by utilizing off-location flow lines to minimize traffic and reduce long-term disturbance areas. Additionally, the locations were cited to reduce new road disturbances. And with that, I will turn it back over to Mr. McGowan.
Mr. McGowan, you're muted.
Apologies about that, Your Honor. Thank you, Mr. Chair. Apologies for that. Thanks again for your time today, commissioners. We appreciate your attentiveness and your time. We would again respectfully ask on behalf of Great Plains that the commission therefore approve the following orders. The establishment of a approximate 160 acre drilling and spacing unit for the application lands. Approve 2 vertical wells for the production of oil and gas and associated hydrocarbons from the Cherokee Formation. Approve an approximately 160 acre oil and gas development plan for the application lands for the development of 2 vertical wells from a total of 2 pads located in the southwest quarter of the northwest quarter and the northeast quarter of the northwest quarter of section 23, township 7 south, range 52 west of the 6 p.m. within the proposed 160 acre DSU for the production of oil, gas, and associated hydrocarbons from the Cherokee Formation, the Great Plains Extension OGDP. Provide that the subject wells be located on the 2 locations within the application land unless the director grants an exemption. Find that Great Plains Extension OGDP will protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biological resource in compliance with the Oil and Gas Conservation Act, CRS 3460-106 2.5A, and approval of the lesser impact exemptions as recommended. If there are any other such findings and orders as the commission may deem proper and advisable in this matter. Thank you. We were happy to answer any questions. We appreciate your time.
Thank you for the presentation. If you want to take the screen share down, thank you. Commissioners, the panel is open for questions. Commissioner Messner.
Thank you, Mr. Chair. Thanks for the application and the presentation. As this is a new operator, I guess I want to be clear. Understanding that this is a new operation that is not intending to be tied to natural gas takeaway, that you understand, Mr. Harrod, that Rule 903D indicates that after the commencement of production operations at an oil and gas location, venting and flaring of natural gas produced from any completed well is prohibited. Now, there are certain exceptions there, but as this is a new operation and it's a known situation, at least from this commissioner's perspective, some application for a modified gas capture plan that would allow for venting and flaring of natural gas or a variance request is not going to be looked favorably on by this commissioner, as this is a known situation that you're entering into. So I just wanted to make sure that you understood that, in this application stage.
Yes, we do, and we're not expecting any gas.
Okay. And then there were 2, well, you had BMPs that were associated with the application that you had proposed. There were 2 conditions of approval that were submitted by staff as part of their director's recommendation that go a little further than your proposed BMPs. Are you in support of applying the conditions of approval as suggested by staff?
Commissioner, I will defer that to Mr. Hare, but we had no objection to the director's recommendation.
Yeah, we are in favor of that. No objection.
Okay, thank you.
Further questions of the panel? Seeing no further questions, we move into deliberations. Does anybody want to start deliberation or make a motion? Commissioner Cross?
I'd move for approval of the application with the COA as proposed.
We have a motion. Do we have a second?
Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Motion carries. Thank you very much.
Thank you, Mr. Chairman. Thank you, commissioners. And again, welcome, Commissioner Oath.
Thank you.
Thank you, everyone.
All right, moving through the docket, we now take up 231-200-361, an oil and gas development plan. Larimer Energy is the applicant, and either Kelsey Wozelinski or Jamie Jost is the attorney of record. And it looks like we're also going to have a presentation by, well, that's from Larimer. So let's elevate the folks. Good afternoon, Ms. Wozelinski. Do you have your witnesses with you?
Not quite yet. It looks like they're still being elevated. So we may just need to give it 1 minute as everyone is impaneled. And if everyone from Laramie could please turn their cameras on, we'll be ready to be sworn in. And I think, Chair, we've got everyone from Laramie. I'll double check as we swear in.
I think folks are still visualizing. All right, I see 8 witnesses visualized. Take it away, Ms. Mercer.
Thank you, Mr. Chair, and good afternoon to the panelists. I will just go one by one in the order I see on my screen and ask that you each raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Middleton.
Katie Middleton, I swear to tell the truth.
Thank you. Mr. Cooley.
Duke Cooley, I swear to tell the truth.
Thank you. Mr. Bankert.
Wayne Bankert, I swear to tell the truth.
Thank you. Mr. Lowry.
Jason Lowry, swear to tell the truth.
Thank you. Mr. Peters.
Tyler Peters, I swear to tell the truth.
Thank you. Ms. Wilsey. You're on mute.
Amy Wilsey, I swear to tell the truth.
Thank you. Mr. Knudsen.
Dwayne Knudsen, I swear to tell the truth.
Thank you, and my apologies for mispronouncing your name.
No problem.
Mr. Katzen. Katzen.
Yep, Matt Caston, I swear to tell the truth.
Thank you. I believe that's everyone, Mr. Chair.
Wonderful. Thank you.
Very good. Go ahead, get started.
Thank you. We'll get our PowerPoint up and then I will get started. There we go. Well, good afternoon, commissioners. My name is Kelsey Wozelinski with Jost Energy Law. And with Jamie Jost, we represent Laramie Energy LLC in the 2023 Laramie 0993-29-01 OGDP before you today in docket 2312-00361. We would like to thank Mesa County for its support of the Laramie 2901 OGDP and also ECMC staff and the director for their efforts on this OGDP. And on behalf of Laramie and Jost Energy Law, we would like to welcome Commissioner Oath to the commission. Next slide. I'll take just a few minutes to summarize the Laramie 2901 OGDP and requested relief before I turn it over to Laramie. This OGDP requests that the commission establish an approximate 328.2 acre OGDP for the development of 16 new directional wells in the Williams Fork and Isles formations in Mesa County. The OGDP also requests that the commission approve one Form 2A for the Laramie 0993-29-01 pad for the development of 16 new directional wells. Laramie will drill and develop 8 of the directional wells in federal minerals, which are subject to a communitization agreement, and Laramie will provide an update on the 8 federal APDs in the presentation today. Laramie will drill and develop the remaining 8 directional wells in fee minerals, which are also subject to a communitization agreement. The Laramie 2901 pad is located within Mesa County. Laramie has an approved Mesa County oil and gas site location, approving the siting and related disturbance for this location. At the time of filing, the proposed Laramie 2901 location triggered 2 Rule 304 ALA criteria. First, a portion of the surface disturbance was located within the 2023 elk winter concentration HPH. This HPH has since been removed in the 2024 HPH rulemaking, and CPW does not recommend any timing stipulations associated with this habitat. And second, there are unmapped wetland vegetation and seep within 500 feet of the proposed location, but they are upgradient of the pad. As part of the OGDP, Laramie has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Laramie will describe today. These include using a natural gas or dual fuel rig, freshwater-based drilling mud, and existing and new water gathering lines utilizing recycled produced water. And finally, Laramie has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2A. With that, I will turn it over to Katie Middleton from Laramie to continue the presentation.
Thank you, Ms. Wazzalenki. Next slide. Good afternoon, Chair Robbins and Commissioners. Welcome, Commissioner Oat. My name is Katie Middleton. I am with Building Hill LLC, representing Laramie Energy today. We would like to thank the Commission for the opportunity to present the Laramie 2023 0999 2901 OGDP today. Laramie would like to also thank Mesa County, the BLM, CPW, ECMC staff for their guidance and time with this project. Laramie is an exploration and development company that solely operates in Western Colorado. Laramie's core operating areas are in Cascade Creek and Plateau Valley, both located within the Piceance Basin. Next slide. During this presentation, I'll refer to the location as the Laramie 2901. The proposed Laramie 2901 well pad is a new oil and gas location situated in Plateau Valley within Mesa County. Laramie is proposing to drill 16 directional natural gas wells composed of 8 fee wells and 8 federal wells. Next slide. Before you is an overview of the Laramie 2901 application timeline. Laramie began evaluating development in section 20 and 21 under the new ECMC rules in 2022. During the preparation of this OGDP, Laramie conducted 4 pre-application meetings with regulatory agencies, including 2 virtual meetings and 2 on-site meetings. Other significant milestones worth noting are the submittal of the 8 federal APDs to the BLM, approval of the Mesa County Oil and Gas Site Location Permit, ECMC's adoptions of the 2024 CPW HPH map updates, and CPW's comments on the Form 2A on July 15, 2024. No public comments were received and no formal petitions were filed. Next slide. The Laramie 2901 is situated in a remote mountainous area in eastern Mesa County. The site is located 8.5 miles east of the town of Colburn. The site will be accessed from new access roads and existing private lease roads. The surface lands are privately owned. The working pad surface, buried pipeline right-of-way, temporary surface line, and access road will be constructed on Laramie-owned surface. A small portion of the area disturbance will be located on the adjacent parcel. Laramie has established a surface use agreement with the surface owner for the short-term disturbance on the adjacent parcel. All long-term disturbance and production equipment will be located on Laramie-owned surface. Next slide. There are no residential building units, high occupancy building units, school property or facilities, child care centers, or designated outdoor activity areas located within 1 mile of the proposed location. Next slide. The Laramie 2901 is located near existing infrastructure owned and operated by Laramie. The existing adjacent lease road and pipeline corridor will minimize surface disturbance associated with this project. Nearby facilities include a water treatment facility, salt water disposal wells, and a gas compression facility. By utilizing temporary surface water lines and tying into existing water gathering lines and gas pipelines, these nearby facilities will support proposed operations and reduce truck traffic associated with the development of the Laramie 2901. Of water to be utilized during pre-production activities, approximately 75% will be recycled water. Next slide. The Laramie 2901 was designed to utilize previously disturbed surface and to minimize overall disturbance while providing safe and efficient mobility for equipment and personnel. A portion of the well pad and the entire access road will be constructed on previously disturbed surface. Of the 9.44 acres for the project, 3.7 acres is previously disturbed. This results in 40% of the project utilizing previously disturbed surface. The proposed area of disturbance will be 8.3 acres and 1.1 acre for the access road. The proposed buried gas pipeline and water line will be installed within the access road disturbance. During interim reclamation, 6.1 acres will be reclaimed, leaving 2.1 acres for the production pad surface. The Laramie 2901 OGDP will result in 3.3 acres of long-term disturbance. The design of the well pad incorporates protective stormwater and drainage control measures, in addition to the management and remediation of drill claims. Stormwater control measures were designed and reviewed by a certified stormwater contractor and a professional engineer with extensive stormwater experience on the western slope. Laramie will install several stormwater control measures, including sediment traps and a ditch and berm surrounding the perimeter of the pad. Next slide. Mesa County is the relevant local government of the Laramie 2901, and there is no proximate local government. The Laramie 2901 is within the county's agriculture, forestry, and transitional zone district. Pursuant to ECMC Rule 302E, advance notice was sent to Mesa County's Community Development Department, notifying of Laramie's intentions to submit an OGDP. The notification detailed proposed operations and traffic projections. Mesa County requires an oil and gas location application for the well pads within the subject zone district. Representatives from Mesa County's Community Development Department attended an onsite on June 12, 2023. On September 18, 2023, Laramie submitted an application to Mesa County. As part of Mesa County's permit process, a public notice sign was posted for 15 days at the intersection of the existing lease road and public road, Highway 330. This sign was visible to the public. Mesa County did not receive any comments during this period, and on October 8, 2023, Mesa County issued the oil and gas location permit. Next slide. 8 federal wells will be drilled from the Laramie 2901 and will be targeting and developing federal minerals in Section 21. In 2023, BLM attended a virtual pre-application meeting and 2 on-site meetings at the location. During the virtual meeting and both the on-site visits, Laramie consulted with the BLM regarding the design of the well pad and access road. Both entities discussed construction, stormwater control measures, and surface disturbance. Laramie submitted the 8 federal APDs applications in October of 2023, approximately 41 days prior to submitting the OGDP to ECMC. During the application process, the BLM cited reduced staff was impacting APD timeframes and resulting in delays of review and processing of federal permits. On July 29, 2024, the BLM provided an update stating that the BLM was completing NEPA. The BLM cited that due to project lead staffing shortages, the BLM had not completed the EA yet. The BLM stated, quote, "We have conducted 2 on-sites and do not foresee any delays in approving the APDs once NEPA is completed and signed," end quote. The BLM stated their goal is to have these APDs approved by the end of August. Next slide. At the time of filing, a portion of the area of disturbance and working pad surface was located within mapped elk winter concentration habitat. CPW reviewed and approved the wildlife mitigation plan in November of 2023. I'll provide an in-depth summary of the elk winter concentration habitat in this presentation. Next slide. Aquatic sportfish management waters are mapped within 1 mile radius of the Laramie 2901. The aquatic buffer is located 338 feet from the working pad surface. The OGDP will not result in any mapped aquatic sportfish management waters disturbance. Please note that the 338-foot distance is a mapped distance, and the down gradient distance is well over 1,000 feet. A ridge is situated between the pad and the aquatic HPH, which prevents a direct path from the location to the mapped aquatic buffer. Next slide. Before you is a table of the highlights of Laramie's consultation with CPW. Please note that this is not an exhaustive list of the consultation as provided in the CPW consultation summary attached to the Form 2A. CPW attended 2 pre-application virtual meetings and 2 on-site meetings in 2023. In order to provide a comprehensive and detailed scope of the proposed development and potential sensitive receptors, Laramie has an independent consultant conduct biological and environmental field surveys prior to on-site meetings. This allows Laramie to provide field verified data to CPW and other regulatory agencies during the on-site and throughout the permitting process. The biologist also attended the on-site meetings and was available to answer questions from regulatory agencies. An unmapped seep and wetlands vegetation was identified. During the on-site meetings, attendees confirmed this feature. The seep is approximately 433 feet southeast of the proposed location. The seep is not down gradient of the location. However, it is adjacent to the proposed access road and existing pipeline right-of-way. Laramie discussed physical protections of the seep with CPW and BLM. Laramie volunteered that prior to construction, Laramie will install a wooden split rail fencing. This wildlife-friendly fencing will allow wildlife to access the seep while preventing the disturbance from livestock. CPW and BLM were supportive of this BMP. Laramie submitted a waiver to CPW for Rule 1202A3. The waiver request detailed a list of BMPs, including emergency spill response trailers stationed nearby during pre-production activities, an on-site spill kit during production phase, and remote monitoring and shut-in. CPW approved the waiver request on October 17, 2023. Next slide. Based on the ECMC map layers at the time of filing, the project was located on the fringe of mapped elk winter concentration habitat. The project area is immediately adjacent to existing infrastructure, including pipeline right-of-ways, access roads, support facilities, and several well pads owned and operated by Laramie. CPW and Laramie examined the project area facility density and determined that this area already exceeds 5 active oil and gas locations per square mile. Pursuant to Rule 1203D1, CPW did not recommend indirect impact mitigation due to the cluster development unless Laramie conducted pre-production activities within the winter timing stipulation of December 1st through April 30th. Next slide. On May 22nd, 2024, ECMC adopted the updated CPW HPH map layers, which became effective as of July 15th, 2024. CPW removed the mapped elk winter concentration habitat in the vicinity of the Laramie 2901, as shown before you. These changes to the HPH mapping are based on current and available data. The mapped elk habitat was not just simply reduced, but the entire mapped buffer in the area was completely removed. The OGDP is no longer located within elk winter concentration habitat based on these recent mapping updates. There are no other HPH areas that would be directly impacted by the proposed project. Next slide. On July 15th, 2024, CPW provided a written comment on the Form 2A regarding consultation, the removal of the mapped elk winter concentration habitat, direct impact fees, and BMPs. Originally, indirect impact fees would have been required if Laramie was to conduct pre-production operations in the mapped elk winter concentration habitat. Limitations of December 1st to April 30th. However, CPW is no longer recommending the winter timing limitations due to the change in mapping and states that indirect impact mitigation is no longer warranted. As a good faith gesture, Laramie has agreed to pay the direct impact of $13,750 to CPW's compensatory mitigation program. Next slide. The Laramie 2901 is situated within a disproportionately impacted community. As shown in the map before you, all of Eastern Mesa County is located within this DIC. The rural area is remote and consists of large agricultural parcels and public lands. The Laramie 2901 is located approximately 8.5 miles away from the town of Colburn. The EnviroScreen score is 19.3. A CDPH consultation pursuant to Rule 309F was not required, and CDPG did not request that a consultation occur. Next slide. This slide highlights some of the technology and practices Laramie will implement for this OGDP. During drilling, Laramie will utilize fresh water-based drilling mud. During completions and flowback, the Laramie 2901 will be tied into temporary and existing water gathering lines for the transport of recycled produced water and flowback water. Utilizing water gathering lines will in total remove an estimated 11,200 truck trips. Existing water gathering lines will also reduce truck trips during production. At a minimum, during the first year of production operations, existing water lines will remove 3,200 truck trips from the road. Next slide. Laramie will implement numerous best management practices to minimize and mitigate potential impacts which best protect public health, the environment, safety, and wildlife resources. Next slide. Listed before you is a summary of our proposed air monitoring program. Laramie is currently preparing an air monitoring plan to submit to CDPHE. Next slide. This slide summarizes anticipated duration for operations at the Laramie 2901. Laramie is planning one occupation for drilling activities. In this area with continuous operations, the average length of time to drill a well is 4.5 days and 1.5 days to complete a well. Next slide. Laramie's standard practice is to plan wells with a maximum inclination of 40 degrees or less, as shown on the figure to the right. Based on Laramie's restriction on hole angle, wells cannot exceed a horizontal distance of 3,500 feet from the surface hole location to the bottom hole location. Next slide. The next two slides will cover the alternative location analysis. The Laramie 2901 triggers the following ALA criteria as listed on the slide before you. Please note, as stated earlier in this presentation, the mapped elk habitat was removed during the 2024 CPW mapping updates, and the unmapped seep and wetland vegetation is upgraded of the location, but is adjacent to the proposed access road. Laramie assessed 5 alternative locations in addition to the Laramie 2901 in accordance with ECMC Rule 304B2. Next slide. This table shows an overview of the preferred and alternative locations. I'll address each alternative location over the next few slides. Slide. When Laramie originally assessed developing the minerals in section 20 and 21, 2 well paths were proposed. The Lynn 0993-2011 alternative location 1, which targeted minerals in section 20, and the Laramie 0993-2115 alternative location 2, which targeted minerals in section 21. Alternative location 1 and 2 were Laramie's initial preferred locations during the project's preliminary planning. Next slide. During the preliminary planning and permit preparation, it was determined that the Lynn location, alternative location 1, was proposed within an area with potential stability issues. In accordance with ECMC Rule 304B7, Geologic Hazards Map, and 304C21, Geologic Hazards Plan, a geologic hazards desktop analysis was conducted by a consultant. This analysis indicated potential landslide hazards and unstable soil issues based on data from LIDAR and mapping from the Colorado Geologic Landslide Inventory. Due to the anticipated concerns that even with the most robust stabilization design elements would not yield an acceptable location, Laramie eliminated alternative location 1. In addition to geologic hazard concerns, alternative location 1 is within 500 feet of mapped wetlands, results in significantly more disturbance than the preferred location, and is in close proximity to high voltage transmission lines. Next slide. As mentioned on the previous slides, when Laramie originally pursued alternative location 1, it was in conjunction with alternative location 2. However, when alternative location 1 was eliminated, Laramie reassessed pursuing alternative location 2. Of all the locations assessed, alternative location 2 results in the most surface disturbance due to the significant length of the access road. Therefore, Laramie eliminated this location. Laramie has ultimately decided to pursue 1 location versus 2 locations as originally proposed and focus developing within the main corridor of Groundhog Gulch, where a well pad would be more accessible. Next slide. Alternative location 3 was considered after the mineral development boundary was redefined. While this location is classified as a tier 1, the classification does not reflect the challenges and increased surface disturbance. Although Laramie obtained an SUA for this location when the site was previously permitted in 2015, the site was eliminated since the location was within a mapped landslide hazards area, and a consultant advised Laramie to pursue an alternative location. Due to the varying topography and steep terrain, alternative location 3 would require significant cut and fills. The location would have resulted in 97,000 cubic yards of cut and 90,000 cubic yards of fill. This substantial volume of cut and fill, combined with the potential landslide hazards, poses significant stability risk. The site was eliminated since alternative location 3 would result in greater impacts than the preferred location. Next slide. Alternative location 4 was considered since all the targeted minerals could be reached and the location is outside of mapped HPH. Alternative location 4 is located geographically between the preferred location and alternative location 3. Topography and mapped geologic landslide hazards pose challenges in developing this location. As with the other alternative locations, this would have resulted in greater surface disturbance than the previous location. Next slide. Alternative location 5 was considered since the location was just outside the former mapped elk winter concentration habitat. This location is located directly east of the preferred location. The site was eliminated since all the target minerals could not be reached, and the well pad would have been constructed at the base of a tall mountain ridge. Being situated at the base of a ridge with maximum slope of 60% and an increase in elevation by 300 feet, alternative location 5 would require significant cut and fills to construct on a hillside below this mountain ridge. Laramie was concerned that excavating the hillside with deep cuts may result in destabilization of the hillside. Additionally, the southeast and southwest corners of the well pad would have been directly above a pipeline corridor, which would likely result in the need to reroute these natural gas and produce water pipelines. With these considerations in mind, the site was eliminated. Next slide. While 4 alternative locations were classified as Tier 1, these locations would have required increased surface disturbance associated with the access road and the construction of the well pad. 2 locations could not reach all the targeted minerals in the OGDP. This location analysis reflects on some of the unique challenges that operators face when determining a suitable site location on the western slope. Based on geologic hazards, anticipated surface disturbance, utilization of previously disturbed surface, proximity to adjacent infrastructure, and ability to develop targeted minerals, Laramie concludes that developing the Laramie 2901 with best management practices protects public health, the environment, safety, and wildlife resources while resulting in less overall impacts when compared to the alternative locations. And now I will turn it back to Ms. Wazzalinki to conclude the presentation.
Thank you, Ms. Middleton. To summarize the Laramie 2901 OGDP and request for approval, I'll just quickly note the following highlights. Mesa County supports the development and has approved a siting permit for this location. The 2023 mapped HBH has been removed, and CPW does not anticipate any adverse impacts to habitat as a result of the proposed OGDP development. No petitions or public comments were submitted on the 2A. And finally, the siting and BMPs provide protection of public health, safety, welfare of the environment, and wildlife resources by avoiding, minimizing, and mitigating adverse impacts. With that, we respectfully request approval of the OGDP and associated Form 2A, and this does conclude our presentation, so we can take the PowerPoint down, and our team is now open for questions.
Thank you for the presentation. The panel is open for questions from commissioners. Commissioner Ackerman.
Thank you. Just one question from me. I appreciate your presentation, Ms. Middleton and others. If you can just discuss, I appreciate you going through in detail the discussion associated with high priority habitat. It was a changing situation during your application. You decided to continue to go forth with the direct mitigation payment. Can you talk a little bit about how that developed?
Hi, yes, thank you, Commissioner. Once during the CPW early proposals of their new 2024 map layers, Laramie noticed that the winter elk concentration habitat was going to be removed. And of course, we know that those high priority habitats updates are always subject to rule approval. So we stayed into the discussion with CPW. Once the new mapped buffers were adopted, we reached out to CPW. And they said, you know, obviously the elk are not there, there's not a sensitive receptor, and therefore they didn't support imposing the timing stipulations. Laramie said that, you know, supporting CPW and paying the direct mitigation, we felt was a good gesture, and meeting CPW halfway. Since we did enter, the OGBP was submitted under the 2023 mapped CPW rules.
Thank you. I appreciate that testimony. And can you talk a little bit about the drill rig types? I see powered by diesel engines. If you mentioned that, I missed it. But with regard to the drilling engines and the hydraulic frac fleet, I think is standard. But can you talk about the types of engines you intend to use for drilling?
I know we are proposing a dual fuel drill rig. I don't know if anyone else from Laramie can provide more color on specific engines.
Are we waiting on someone else to weigh in?
I was waiting to see if someone else from Laramie can add more specificity.
Ms. Weslinky?
Commissioner Ackerman, we may need to just get back to you on that once we confirm with the Laramie team.
Thank you. I'd appreciate that.
Other questions for the panel? All right, I'm not seeing further questions. Ms. Weslinky, do you think you can get the question to Mr. Ackerman here shortly? Should I take a 5-minute break?
Maybe a 5-minute break may be helpful. Thank you.
All right, let's return at 1:59. All right, Ms. Weslinky, do you or your client have an answer to Commissioner Ackerman's question?
Yes, thank you for that short break. I'll let Ms. Middleton take the lead on this.
Greetings, yes, thank you. So Laramie is proposing to use a dual fuel rig. This is considered a tier 2, and it burns natural gas and diesel at the same time. We also have Aaron Duncan with us, and he is Laramie's drilling manager to answer any further questions.
And I'll note Mr. Duncan has not been sworn in, so if you do have additional questions, we'll need to swear him in.
Commissioner Ackerman?
Thank you, Mr. Chair. Just stating nothing further. Appreciate the response.
Other questions for the panel? Seeing none, we move to deliberations. Does anyone care to initiate deliberations? Commissioner Ackerman?
Thank you, Mr. Chair. I just wanted to state that I particularly appreciate this operator working in good faith with CPW, as most operators do, and continuing on to ensure that they have addressed all wildlife concerns as identified by CPW, and continuing in a good faith effort to continue to contribute to habitat mitigation work being done in that region. Wanted to state to the general public that we do take a close look at high priority habitat maps, and while we do have operators that sometimes in the midst of an application are dealing with issues of high priority habitat and are asked to make voluntary commitments, this is an operator that it's happened the other way, and they continue to make a voluntary commitment. I wanted to recognize and appreciate that work. And also recognize the upgraded dual fuel rigs that are being used, which are an improved emissions profile over regular tier 2 diesels, and appreciate the work being done there as well. Would move for approval of this application, Mr. Chair.
Commissioner Cross?
Thank you, Mr. Chair. And I'll start by saying I second that motion. I just also wanted to point out, I appreciate the work on the alternative location analysis here. I thought it was helpful to not only look at an overall assessment, kind of qualitative assessment of what the different sites are, but also to see pictures of everything and kind of how they went through the different process and evaluated everything. So I appreciate that. And as I noted, I'll second the motion.
Motion and a second. Is there further discussion on the motion? Commissioner Messner?
Just a quick comment. I think this was a very good application, and so I commend the applicant. I think I indicated this earlier, but the quality of application certainly determines how many questions you get at hearing and how quick the application gets processed. And I think this is an example of a good application so I just commend you for that.
Further discussion? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you to the applicant. Thank you to our staff for the good work on this application.
Thank you.
All right, we now move to the next docket, 231100348, an oil and gas development plan for MDS Energy Development. And I believe we will start this docket by hearing from Jason Maxey with Weld County.
Good afternoon, commissioners. Hope you can hear me okay. I apologize, I'm not joining in my normal environment. Doing a little bit of traveling on the road right now as a passenger, but I wanted to chime in real quick for a few minutes and thank you for the opportunity to speak about the Weld County WOGLA process regarding MDS Energy Development and just giving a few high-level items about the permit that we reviewed. So thank you very much. Weld County's Oil and Gas Energy Department held our usual pre-app for the MDS location on August 16th of 2023, at which several alternative sites were discussed as usual. Attendees not only included Weld County staff and ECMC staff, but also the applicant, MDS, and CPW staff. CDPHE and BLM were invited but did not attend. However, all attendees and invitees to our pre-app meeting received a copy of the official meeting notes. We have assigned a 1041 WOGLA number to this location, which is 23-0061. And we received the initial application on November 2nd of 2023. However, there was some dialogue with the applicant to clarify and potentially enhance some certain items. And the final application version was sent to Weld County on December 11th of 2023. The application included an analysis of 6 alternative sites, which were reviewed and discussed in detail with the Oil and Gas Energy Department staff. And at the 1041 WOGLA hearing, our hearing officer reviewed and discussed these 6 alternative sites with the applicant. And the MDS Energy 859 location was determined to be the best location with the information that was provided to us. I did want to make a quick note that within the application, there appeared to be an illustration of a saltwater disposal well. And we had some discussions with MDS at the time regarding that saltwater disposal well. And at the time of the application, the Oil and Gas Energy Department did not handle that type of a well or that type of a use on location. Our code has now changed and we now would consider that well on location. However, since it was excluded in the original application per our code at the time, we would have to work with MDS to add that well in the future if that is something they would want to do. There is one Weld County defined building unit within the 1041 WOGLA zone. That building unit owner, from our understanding, has signed an informed consent form. And Weld County sent notices of our hearing to 12 parcels, which makes up 10 different property owners. We did not receive any requests to participate in our hearing, and we did not receive any public comments. As per our process, we did send referral requests to multiple agencies in late December of 2023, and we received many back. We did not receive a response back from BLM or the Prairie School District, which is typically normal for certain applications, depending on any type of input those agencies may or may not feel like they need to submit, or that they might not even be involved in the project at all. We did have the hearing on February 15th of this year, 2024. The hearing officer considered testimony at that hearing. However, we continued the case to March 14th due to our preliminary drainage requirement not being approved at that time. However, MDS did rectify that situation, and the preliminary drainage report was accepted by Weld County on March 4th of 2024. And so on the 14th, we had a continuance hearing, and the hearing officer found them compliant with all Weld County code requirements and subsequently approved the permit. At our hearing, no referral parties participated in the public hearing process. We have issued a final order, and it's been recorded with the clerk and recorder, and it was noticed in the Greeley Tribune on May 10th. And that notification creates a vested property right pursuant to Article 68 of Title 24 in Colorado Revised Statutes. As you all know, our permit is good for 3 years, or they can extend that if they have not constructed within 3 years based on a request to us. And they have agreed to multiple best management practices in their application, which Weld County believes will protect the health, safety, and welfare of the residents, as well as protecting the environment and wildlife. We believe from a land use perspective, this is a good location. It is close to certain other oil and gas development in the area, and it's intermixed with agricultural lands and rangeland. We submitted our 2A comments to the ECMC on May 22nd of 2024, and they should be included in the director's recommendation, which we have received a copy of. And to close out, due to the fact that MDS has completed our application process and that we have issued a final order and it's been recorded and published, we have no additional concerns with the pending permit. We have read through the director's recommendation, and we agree and support the recommendation for approval of this permit. So thank you again very much for the quick few minutes to go over that Weld County process, and I'd be happy to answer any questions that I might be able to at this time.
Thank you very much, Mr. Maxey. Does anyone have questions of Jason Maxey with Weld County? Seeing none, Jason, we'll let you go on your way. Appreciate it.
Thank you all very much. I appreciate the time as always.
Ms. Jost, do you want to elevate your witnesses or get them to visualize themselves?
Yes, thank you, Chair. Okay, MDS Energy team, if we could have everyone come on screen. I see Ms. Gross, Mr. Jacobson. Okay, Ms. Mercer, we have everyone.
Thank you very much. I'll go ahead and get the panel sworn in. I'll go one at a time and ask you each to raise your right hand, state your name, and that you swear to tell the truth. And let's begin with Ms. Gross.
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Mr. Jacobson?
My name is Jim Jacobson, and I swear to tell the truth.
Thank you. Mr. Sade?
My name is Richard Sade, and I swear to tell the truth.
Thank you. Mr. Dunn?
My name is Justin Dunn, and I swear to tell the truth.
Thank you. Mr. Duncan?
My name is Neil Duncan, and I swear to tell the truth.
Thank you. And finally, Mr. Kondaki.
My name is Emrecan Kutkondakçı, and I swear to tell the truth.
Thank you.
Chair, if I may start sharing my screen.
Yes, please go ahead and get started.
Chair, are you able to see that?
Yes.
Okay, wonderful. Thank you very much. Well, good afternoon, Chair, Commissioners, staff, and members of the public. My name is Jamie Jost, and I, along with Kelsey Wazelinki, represent MDS Energy Development, LLC, in this MDS Energy 8-59 Oil and Gas Development Plan in docket number 2311-00348. Thank you for the opportunity to present to you this afternoon, and I will echo Kelsey in the prior hearing. Commissioner Oath, welcome, and we look forward to practicing in front of you. Before we dive into the substantive portion of MDS's OGDP presentation, I would like to introduce Mr. Richard Sade of MDS Energy Development and ask him to provide an overview of MDS Energy Development LLC to this commission. While this is MDS Energy's first OGDP in the state of Colorado, the company has drilled and operated wells in the state for several years. Mr. Sade, I will go ahead and turn it over to you for an introduction to MDS Energy.
Good afternoon, Commissioners. I'd like to start by thanking you and the Commission staff for their work and effort spent on this MDS application. MDS appreciates the guidance and expertise from the staff as we navigated our first OGDP in Colorado. Since this is our first hearing in front of the commission, we thought it may be helpful to provide some background on MDS. MDS Energy Development is an oil and gas operator going back to 2006 in Pennsylvania. In 2022, we began operations in Colorado. Also, earlier this year, we started up operations and began drilling in Wyoming. Since we started operations in Colorado, we've drilled, completed, and put on production 4 Niobrara horizontal wells on a pad in Weld County. We also started drilling operations on a second pad. In addition, we're working on permitting 2 more pads in Weld County, including this one we're discussing today. I wanted to confirm upfront that MDS has agreed to the 2 conditions of approval set forth in the director's recommendation and believe these are beneficial COAs that we welcome on our permit for this location. The COAs are, number 1, after topsoil pits have been dug and documented, operator will submit soil test pit data to ECMC via Form 4 sundry and allow for the sundry to be approved prior to commencement of construction. And number 2, an increase to the allowable noise level at the location pursuant to Rule 423D will require the operator to submit an updated noise mitigation plan that includes the ambient noise monitoring results of the southeast direction from the WPS via Form 4 sundry. Operator shall allow for the sundry to be approved prior to commencement of construction. Thanks for taking a little bit of time with me, and I'll hand it back to Ms. Jost.
Great. Thank you so much, Mr. Suddy. The MDS Energy 8-59 Oil and Gas Development Plan requests approval of a 1,391.27 acre oil and gas development plan and corresponding drilling and spacing unit, and to allow for the development of up to 7 new horizontal wells from 1 new oil and gas location within the OGDP boundary. Here you can see the application lands include sections 35 and 36, Township 8 North, Range 59 West, and a portion of Section 31, Township 8 North, Range 58 West. The proposed surface location will have approximately 11 acres of surface disturbance, and it will be located on lands owned by MDS Energy in the southeast quarter, southwest quarter of Section 31, Township 8 North, Range 58 West in Weld County, Colorado. The proposed surface location is not within 2,000 feet of a school, school facility, high occupancy building unit, or child care center, and is not within a disproportionately impacted community or a cumulatively impacted community. The proposed surface location is within 2,000 feet of 1 residential building unit owner, and that owner has provided valid and effective informed consent to MDS Energy and the ECMC. And as you heard from Mr. Maxey, MDS has obtained an approved WOGLA for Weld County. The MDS Energy application has met the criteria and requirements of an approvable OGDP and Form 2A permit. As you can see, MDS Energy submitted each of the required Rule 303, 304, and 308 documents, and such submission was confirmed by the Director's Form 2C Certificate of Completeness. The MDS OGDP is subject to Rule 604B1 because it has obtained a valid and effective informed consent from the 1 RBU owner located within 2,000 feet of the working pad surface of the oil and gas location. This informed consent was submitted with the original filing of the MDS Energy 8-59 application. MDS Energy recognizes that the ECMC staff posed questions to MDS regarding the informed consent submitted. However, MDS submits that the informed consent executed by the residential building unit owner was based on the ECMC's informed consent template, a template which this commission, staff, and operators understand to be an example of the informed consent document, but not a required specific document to be utilized per Rule 604B1 or the corresponding provision of the statement of basis and purpose. Based upon a private contractual agreement with the surface owner and the informed consent provided, MDS Energy has obtained the, quote, explicit written agreement to the proposed location, end quote, from the 1 RBU owner, which satisfies Rule 604B1. The MDS Energy 8-59 OGDP application has been progressing through the ECMC hearing system for several months. Prior to the filings of the OGDP application, MDS Energy did obtain informed consent from the surface owner on March 10th, 2023. On November 10th, 2023, the original OGDP application was filed with the Commission. On May 2nd, 2024, the Form 2C OGDP Certification of Completeness was approved. And on May 7th, 2024, the 7-day completeness letter, OGDP application, and notice of hearing was mailed to 236 interested parties. MDS received no public comments on the Form 2A, or no petitions were received. On July 10th, MDS received a director's recommendation for conditional approval of the OGDP application based upon the 2 conditions of approval referenced by Mr. Sadi and accepted by MDS Energy. The director's recommendation provided a thorough analysis of the ECMC staff and director's review of the MDS Energy 8-59 OGDP and recommended condition of approval of the OGDP application. The condition of approval of the OGDP application is based on MDS Energy's agreement to the 2 conditions of approval confirmed earlier in this presentation and as listed here on this slide for your review. With that, I would like to go ahead and turn the presentation over to Mr. Justin Dunn of Morning Gun Exploration, MDS Energy Development's land consultant, and Ms. Andrea Gross of Upstream Petroleum, starting with Mr. Dunn. Good afternoon, Mr. Dunn. Can you hear me okay?
I can.
Wonderful. Can you please provide a short background on the informed consent obtained for the location of the MDS Energy 8-59 oil and gas location that's subject to this application?
Yes. As noted earlier, MDS obtained informed consent with a single RBU owner within 2,000 feet of the MDS 859 oil and gas location working pad on March 10th, 2023. The informed consent is based off of the ECMC template that is published on the ECMC website, but not mandated. MDS did make modification to the informed consent template based on our confidential agreement with the RBU owner regarding the oil and gas location and the surface owner's RBU on adjacent lands. MDS has continued to meet with the RBU owner prior to and after signing the informed consent multiple times to discuss operations, provide information on potential impacts to the RBU owner, including noise and light impacts. Those communications will be ongoing before and during development as well. I'd like to turn the presentation over to Ms. Gross.
Thank you, Justin. Good afternoon, commissioners. As Ms. Jost detailed earlier, our proposed location is in Section 31, Township 8 North, Range 58 in Weld County. Because there is an RBU within 2,000 feet of our working pad surface, an alternative location analysis was required. MDS submitted a thorough ALA with 6 alternative locations. I'd like to begin with our proposed location. Advantages to our proposed location include the surface owner is also the applicant. The surface is zoned for agriculture. It is close to a county road and the location is not being sited in the middle of a section. And there is also an existing 2-track road that will be utilized. The disadvantages to this location are the RBU that we have already discussed, and it is in the non-attainment zone. A couple of details to note prior to moving forward. The location was not able to be moved outside of the 2,000 feet from that RBU in order to keep it on the parcel, as well as not to encroach on the no surface occupancy of the creek just north of the location. When initially the siting and permitting this location, it was not within any high priority habitats. However, after submittal of the OGDP, the 2024 high priority habitat layers went into effect, and the location is now within the mule deer severe winter range and winter concentration area. I'd also like to note that there's no alternative location that can reach the DSU that is outside the non-attainment zone. I'll start with the next alternative location. This location is just southwest of our proposed location in Section 1, 7 North, 59 West. The main advantage to this location is there was no RBUs within 2,000 feet of the location. The main disadvantages to this location is an existing pond and pipeline that made the siting of the location somewhat difficult. This location is also now within the 2024 HPH layers. Alternative location number 2 is just west of our proposed location in the adjacent parcel. Advantages include this location also is greater than 2,000 feet from an RBU. It's zoned for agriculture. But the disadvantage to this location is the surface owner was not interested in entering an SUA with MDS or having any oil and gas on their location or their parcel. Alternative number 3 is northwest of our proposed location. Advantages to this location is this is also zoned for agriculture and there are no RBUs within 2,000 feet. However, this location was discouraged because a portion of the location is within not only HPH, but it's an NSO for the Aquatic Native Species Conservation Waters. If we were to choose this location, the shortest access road would require a creek crossing across that NSO. If we were to avoid the shortest access, it would require a very long access road. MDS also looked at locations on the opposite end of the DSU that is now being proposed. The next 3 locations fall into this category. Alternative location number 4 is in section 34, 8 North, 59 West. The advantages to these locations are these are not within HPH, even the 2024 layers, and it is zoned for agriculture. However, when talking to this surface owner, there is an RBU. It is the surface owner's RBU is within 2,000 feet of her house, as well as she has a significant horse operation on her property, which she was not interested in entering an SUA with the operator. Alternative location number 5 is also in section 34. Advantages to this location are there are no RBUs within 2,000 feet. It's zoned for agriculture and not within any HPH or a floodplain. The disadvantage to this location would require a very long access road that would go through multiple parcels and require SUAs or access agreements with many different surface owners. Ultimately, the surface owner of this parcel was not interested in an SUA. And our last alternative location is in section 35. Like the other ones, it's zoned for agriculture. There are no RBUs within 2,000 feet, and it's not within any HPH. The disadvantages to this location included a very significant access road that would be required. There are some mapped intermittent drainages, which proposed with the proposed location, which made it difficult. And ultimately, this surface owner was unresponsive to MDS's multiple attempts at contact for an SUA. I'd like to go over their intended operational schedule. MDS would like to begin construction at the end of this year in the 4th quarter of 2024. They intend to drill all wells in one occupation, which would put the wells into production in the 2nd quarter of 2025. This schedule will keep drilling and completions outside of the non-attainment zone months. Regarding the local disposition, I'd like to discuss something that Mr. Maxey said regarding a saltwater disposal well to clear up any confusion. When we first submitted the WOGLA, MDS had the thought at possibly permitting a saltwater disposal well on the location in sometime in the future. However, after talking to Weld County and looking at the regulations, MDS no longer plans to include a saltwater disposal well on this location. Therefore, none of the ECMC documents showed that well. Like Mr. Maxey discussed, we began the process with a pre-application meeting on August 16th, 2023. The WOGLA was approved on March 14th and recorded on May 6th of 2024, giving them a vested right under Weld County Code and Colorado law. MDS participated in several other consultations, including CPW and CDPHE. MDS recognized that the location was under the 2024 HPH layers. Therefore, we reached out to CPW, and on October 25th, 2023, us and CPW met on site in the field to discuss mitigation and minimization measures for the sensitive habitat. Additional correspondence continued after the on-site to confirm our operational timeline, as well as best management practices. MDS cannot commit to the timing stipulations for the Mule Deer Winter Range to prioritize not operating in the non-attainment zone months. Additionally, we consulted with CDPHE on May 22nd. I'll discuss the BMPs that we committed to later on in the presentation. During the WOGLA process, WOGLA notices were sent to all surface owners within 2,000 feet of the proposed disturbance, CPW, BLM, ECMC, and first responders on September 19th, 2023. No protests or public comments were received prior to or during the WOGLA hearing. MDS recognizes that a public comment was received during through the e-filing system. This public commenter is a mineral owner in an adjacent lands in a different DSU. No impacts to his surface or minerals will be affected for this OGDP. I'd like to highlight several important BMPs that show MDS's commitment to mitigating and minimizing impacts to public health, welfare, and the environment. MDS is committed to a pipeline takeaway of all produced fluids and natural gas. However, you'll see that we are permitting 2 oil tanks and 5 water tanks. This is to ensure capacity in the event of an upset with the pipeline, as well as to ensure that any remaining gas can be separated prior to entering that pipeline. MDS intends to use Group 3 drilling mud. Continuing on with the discussion of BMPs, the next several slides will show the 31 BMPs that MDS committed to during the CDPHE consultation. While I won't read all of them, I do want to highlight a couple of them. MDS will electrify their production facility. At this time, they will be using a dual fuel rig if a Tier 4 or equivalent is not available. At this time, they are unable to commit to a Tier 4 or equivalent due to the fact that it may delay their schedule and push them into drilling and operating during the non-attainment zone months. MDS will incorporate options for recycling produced gas on site during a pipeline downtime, and it will cover trucks that are transporting their drill cuttings. As you can see on this slide, they are committed to the ozone mitigation BMPs. They will use an MLVT, which will help to reduce truck traffic, and they will not use fracturing fluids with PFAS, and will also assist the fire departments in transitioning away from that. As I've mentioned in previous slides, MDS did consult with CPW and acknowledge the new HPH layers that they are now under. While they cannot commit to the timing stipulation, they are committed to other wildlife BMPs, including they will establish company guidelines to minimize wildlife mortality from vehicle collisions, as well as all open vent exhaust stacks on production equipment will be designed to prevent entry of birds and bats and to discourage nesting or perching. MDS has a robust stormwater management plan that is largely dictated by Weld County's strict drainage requirements that Mr. Maxey mentioned. During the Weld County process, we obtained an approved preliminary drainage report that includes but is not limited to a sediment basin with a spillway and riprap apron outlet. MDS is committed to many waste management BMPs that are included in their waste management plan. The operator will conduct site inspections throughout all operational phases to ensure waste is being properly stored and emptied as needed. He will only use permitted disposal facilities. Additionally, PVT alarms, automation, and other sensory monitoring devices will be used to monitor active tank levels at all times. Above ground flow lines will be visually inspected on a weekly basis, and daily visual inspections will be performed on all equipment, hoses, valving to ensure integrity of fluid containment. Site-specific BMPs will be in place during each operational phase. On the screen, you can see a couple of examples for each phase. These measures have been effective in preventing spills on other MDS sites. Dust mitigation BMPs include graveling all working surfaces and performing interim reclamation in 6 months after drilling and completion. They will use fresh water during construction on an as-needed basis, as well as regular road maintenance. Light mitigation BMPs include no nighttime work is anticipated during construction, only daylight work. During drilling and completion, lights will be shielded with a photometric diffusion fabric or membrane tint to prevent direct or reflected light from leaving the site. MDS is committed to continuous noise monitoring. Per a sound study, a sound wall of at least 24 feet high will be installed during the completion phase in an L shape on the south side of the location, which will help to mitigate noise as well as light during this phase. We've already discussed a majority of these BMPs, but I would like to highlight again their commitment to using Group 3 drilling mud and non-emitting pneumatic controllers. Odor control will include, but is not limited to, using ECDs, and drill cuttings will be temporarily stored in metal bins and covered to minimize any odors. The next 3 slides cover BMPs that could be used during interim reclamation. Diversion dishes will be installed around the well pad, directing water to the stormwater detention detention pond. Earthen berms will be constructed around the entire well pad to control sediment migration. To help mitigate the contrast of recontoured slopes, reclamation will include measures to feather cleared lines of vegetation and save and redistribute any cleared trees, debris, and rock over the recontoured cut-fill slopes. And finally, an intensive weed monitoring and control program will be implemented beginning the first growing season, and any noxious weeds that are identified during monitoring will be promptly treated and controlled. And with that, I'd like to pass it back to Ms. Jost.
Great. Thank you, Ms. Gross. Commissioners, along with the requested relief to approve the MDS Energy 8-59 OGDP application, MDS also requests approval of the corresponding drilling and spacing unit application attached as Exhibit C. MDS is seeking a 1,391 acre drilling and spacing unit for the Niobrara, Fort Hays, Sharon Springs, Codell, and Carlisle formations, and MDS plans to develop up to 7 new horizontal wells in this unit. MDS holds 90.1% interest in the drilling and spacing unit, and the Colorado State Land Board owns and has leased the minerals underlying Section 36 of the application lands to MDS. We've reached the end of our presentation today and are grateful for your consideration of this application. The MDS Energy 8-59 OGDP application is approvable and is in compliance with Commission rules. No petitions or public comments on the Form 2A were formally filed. MDS holds a WOGLA permit for the location. MDS focused on consolidating operations on one well pad to prevent unnecessary surface disturbance. And the MDS Energy 8-59 OGDP provides protections for public health, safety, welfare, the environment, and wildlife resources. So to conclude, MDS Energy is requesting that this commission approve the MDS Energy 8-59 OGDP for the development of up to 7 horizontal wells within 1,397.27 acre drilling and spacing unit for the application lands. Ask that this commission provide that the 7 wells will be located on the MDS Energy 8-59 oil and gas location. Find that the MDS Energy 8-59 OGDP will protect and minimize adverse impacts to the public health, safety, welfare, environment, and wildlife resources, and will protect against adverse environmental impacts in any air, water, soil, or biological resource in compliance with Statute 3460-106.2.5A, and approve the requested relief in the corresponding drilling and spacing unit application attached as Exhibit C. That wraps up our presentation, and we do have a panel of subject matter experts who will join us for any commissioner questions that you may have. If I could ask them to turn on their cameras, that would be great. Thank you, Chair.
Very good. Thank you for the presentation. Commissioners, the panel is open for questions. Commissioner Cross.
Thank you, Mr. Chair, and thank you for this presentation. I wanted to try and understand better a few of the proposals that you have for this project. You indicated that you're agreeing to piping for oil, gas, and produced water takeaway. You're also piping water in for completion purposes, but trucking water in for drilling purposes. Can you go into a little bit of explanation as to why you're not piping water in for the drilling purposes as well?
Ms. Gross, go ahead.
Thank you, Commissioner Cross. I'll start, and if I can't finish that, I'm sure Mr. Jacobson may be able to help. The water that will be used for drilling will be trucked in. However, the completion water will be coming in via a lay flat line. So it won't be the same pipeline that will take the produced water away. This is very common up there. The water will be then stored in an MLVT.
Are they coming from different sources and that's why it's a separate pipeline? I'm just curious as to why you didn't use lay flat pipeline for the drilling, but did for the MLVT.
I would say, Mr. Jacobson, could you answer that question, please? Or
right.
Student.
Yeah, I can answer that. So the drilling water would only be really for the surface drilling phase, and it's a very minimal amount of water, a couple thousand barrels, not very much. And it's more efficient just to truck it in as opposed to laying a line and then removing it later on. And then coming back a couple months later and putting another line in for the completion phase. It's just more efficient to do it with a truck for the surface drilling phase. As you know, the production hole is done with a Group 3 drilling fluid, which is oil-based mud or a synthetic oil-based mud. So it's mostly oil with a little bit of water. So all of that is most efficiently run with the truck.
Okay, and is it coming from the same source as what's being used for the completions?
No, I believe it'll be municipal water for our drilling use.
Okay, that's helpful to understand too. But the difference is, one of the things that comes up a lot is the number of tanks, particularly where you do have oil, gas, and produced water takeaway. And fully understanding you're proposing 2 oil tanks here, understanding that oftentimes you have to get to spec for the midstream operator as you're taking the oil away. But you have 5 produced water tanks proposed. And I'm curious as to why you're proposing that number of produced water tanks if you're having produced water takeaway.
Thank you, Commissioner Cross. Ms. Gross, would you like to take this?
Yeah, I'll give it a try. Like I said, they need enough storage capacity to begin with. At the beginning of these wells, more produced water will be encountered. However, that will go down with time. They calculate the number of tanks that they need with the anticipated barrels of water that may be produced. There is a possibility that down the line, they will not need that many water tanks. However, up front, at the beginning of drilling, they may need those 5 water tanks in order to hold the capacity in the event of a downturn, as well as separate all the gas. And I think that somebody else on the panel may be able to provide some extra clarification or detail if needed.
Mr. Jacobson?
Yeah, I can help. Andrea mentioned drilling. It's actually during production and after flowback ends. When we are producing water, water and oil and gas, as you know, we need some tankage to get the oil in spec. The separators that we use are not perfect, and we do pull some vapors off the water, and we do have to get the water into some spec before it goes down the pipeline. So the tankage is used for some of that as well. We do pull vapors off the tank. The other side of that is we designed the tankage to withstand approximately 24 hours of pipeline downtime. And the idea here is that if the pipeline was to go down, we could still keep the facility up and running for up to 24 hours before we would have to shut it in. And that was a number that we as a team decided would be an adequate number and keep everything running. And Andrea is correct. As the facility continues to produce, the water production goes down and the water tankage required would go down accordingly.
And would you propose, once that water usage declines or water production declines, I apologize, to remove some of the superfluous number of tanks?
Yes, we could do that. We would have probably likely if Rich has other projects, we could move those to other projects as needed.
And then the couple other questions I had, one was with respect to the public comment, and I know it was talked about that this was somebody, mineral interest owner. Was there additional conversations with this public commenter? Obviously you said it wasn't going to impact his minerals, but kind of curious how this came into place if it wasn't somebody that was going to be impacted, and kind of, is he okay with kind of what's happening now? It was sort of a random comment, and that's why I just am hoping to understand a little bit more.
Yeah, Commissioner Cross, I might be able to help on this one. The comment that came in is from a mineral interest owner in an adjacent drilling and spacing unit that MDS is developing. MDS did have a conversation, I believe still is in conversations with that public commenter about the mineral development in the adjoining drilling and spacing unit. I believe in the director's recommendation, it also stated that, you know, the ECMC noted that this was not a mineral interest owner that would be affected by this OGDP. And so they kind of closed the loop on their end as well, they meaning ECMC staff. But because it's a mineral owner in an MDS DSU, they will continue conversations if there's any further to be had.
So they sort of saw this coming up there, didn't put together that it's a different application altogether, that this is.
Correct.
Okay. Okay, that's helpful to get a little more clarity on that. And then finally, I just wanted to touch on another question to confirm with respect to the drill rig that's being used. You said it's going to be a dual fuel drill rig is what you're committing to?
Correct.
Okay. I believe those are my questions for now. I think
Other
everything.
commissioners with questions? Commissioner Ackerman?
Thank you. Just a couple of questions not touched on. Well, one of them touched on by Commissioner Cross. When you say dual fuel, are you talking a dual fuel natural gas battery backup, or can you be a little more specific?
Well, it'll be a natural gas diesel dual fuel.
Gotcha. Thank you. And then if someone could address a little bit, you know, when we mentioned during the last OGDP that high priority habitat maps do change sometimes in the midst of an application process. In this case, high priority habitat maps changed so that the project now has a nexus with high priority habitat. As per the Administrative Procedure Act, the regulations that are in place at the time of the application are the regulations that apply to the application. My understanding is that CPW did contact you, and I believe from your testimony you had conversations with them, but were unable to commit to any avoidance of the winter timing stipulations as a voluntary measure. Can you elaborate a little on that as to, you mentioned that it was in order to stay out of the ozone season, but will you be drilling the entire time outside of high priority habitat timing stipulations, or can you talk a little bit about how you might work to partially comply with that? Lots of times CPW will say, you know, the end of the high priority habitat timing stipulations are most critical if we can get partial compliance. Did you have those discussions? Could you talk a little bit more about how that developed?
Yes, thank you, Commissioner. I'd be happy to take that. I had most of the conversations with Brandon Moret and Lexi with CPW. Like I said, we did contact CPW. They were in attendance for our Weld County pre-application meeting, so they were well aware of this location. We did meet on site with them. Brandon and Lexi walked the perimeter of the pad. At that time, we discussed the timing stipulations. It was still pretty early in the process, so we didn't commit to anything then. However, as the time got kept going on. I had multiple conversations with Brandon, and our last conversation was to confirm MDS's operational timeline. And unfortunately, MDS was not able to commit to any of the timing stipulations. As you saw in our timeline, they would like to begin construction. It was like the fourth quarter of this year. So there is a chance that the construction period would be outside of those months. And that was something that Brandon and I talked about. But because of scheduling and rig availability, MDS just was not able to commit to those timing stipulations.
Thank you for that response. So just one clarification follow-up. I think you might have clarified at the end that because of rig timing, rig availability, that they were unable to commit, but you also mentioned that they would like to begin construction in the fourth quarter. And I understand, desires. My question was about, is there wiggle room? Are there any capabilities to work with CPW on this issue? Or is it that you're drilling the entirety of the period that's outside timing stipulations? Thanks.
I believe the timing will be in those sensitive time periods. We can discuss with the operator further, but at this point, the last conversation I had was they wanted to have a little bit of open timing in order to get the rig, and was uncomfortable committing to those timing stipulations.
Thank you, Ms. Gross. And I want to be clear that those would be voluntary timing stipulations and voluntary measures, and is not something that this commission is, at least this commissioner would require. That said, what I'm trying to get to was, it was the conversation more along the lines of, no, we don't got to do it, so we're not gonna? Or
No.
did you take a look at the schedule, and are there specific reasons why you felt like you were rendered unable to comply despite your best efforts to do so?
Right. No, it was a thorough discussion between myself and Brandon, and then I brought it back to the MDS group. They were looking at their other schedules, their operational schedules. I went back to Brandon a couple times to discuss the timing stipulations. We understand that it's voluntary, and MDS would have liked to be able to commit to those. However, we felt that being able to commit a little bit closer to not operating in the non-attainment zone months may be a little bit more important. Our location, while it is in high priority habitat, it is off a very major, a main county road, which is already established. So we weren't able to commit to those.
Thank you for the further discussion.
Further questions? All right, I'm not seeing further questions. That moves us to deliberation stage. Does anybody care to initiate deliberations? Commissioner Messner?
Thanks, Mr. Chair. I got a couple of different thoughts on this one, but I think the first thought I have revolves around what we're reviewing this, what rule we're reviewing this under. There's two different options here. We've got 604B1 or 604B4. And I think a determination needs to be made as to whether or not the applicant has actually met the burden of proof to show that they've provided adequate informed consent in order to be able to determine that we can review this under 604B1 rather than 604B4. And so I reviewed the informed consent that was provided. I reviewed the statement of basis and purpose as it relates to informed consent. I actually went back and reviewed the mission change rulemaking that discussed this, because this was a really big topic during the mission change rulemaking, the quality of informed consent and the necessary information to be provided in informed consent in order to be able to have a person who is within 2,000 feet to be able to adequately determine whether they wanted to sign informed consent. The informed consent letter that I read was exactly what I think a lot of stakeholders in the mission change rulemaking were worried that would happen as part of consent. And so I want to read the statement of basis and purpose as it relates to informed consent. And so under 604B4, which is where, or B1, I mean, which is where informed consent lies, it indicates that, provides that oil and gas facilities may be located 500 to 2,000 feet from an RBU if an operator obtains explicit written agreement to the proposed location from every building, unit owner, and tenant within 2,000 feet of the working pad surface. Rule 604B1 carries the same concepts forward from 604A4 and requires informed consent. So if you go to 604A4, the first couple of sections in that isn't directly applicable to 604B1, but the fourth section is directly applicable to this. And that's that the commission clarified that any written agreement consenting to a proposed oil and gas location within, this says 500 feet because it's from 604A rather than 604B, must be based on informed consent. Over the course of the 200 to 600 mission change rulemaking, the commission heard from numerous stakeholders that owners or tenants may not understand the effect of agreeing to a proposed oil and gas location within, in this case, 500 to 2,000 feet. The commission concluded that it was consistent with the intent of Rule 604, in this instance B1, to provide protections to public health and welfare, to require that any person be informed as to potential impacts prior to agreeing to a proposed oil and gas location within 500 to 2,000 feet. Because the oil and gas development may vary widely in size and activity, the commission also concluded it was not appropriate to define informed consent, but that it was appropriate to provide direction as to what information an operator must provide to an owner or tenant in order for the operator to obtain informed consent. Case law in Colorado and elsewhere holds that informed consent requires that a person have a reasonable understanding of both risks and alternatives to any proposed action. The commission therefore intends that in order to obtain informed consent, an operator must provide a person with sufficient information so that the person has a reasonable understanding of the anticipated size, duration, and intensity of all phases of the proposed oil and gas operations at the proposed oil and gas location, of the potential impacts resulting from those oil and gas operations, and of the alternatives to not agreeing to a working pad surface within 500 to 2,000 feet. This list of information is to be provided to an owner or tenant, is not exclusive, and only reflects the commission's intent at the time of the 200 to 600 mission change rulemaking. Depending on the circumstances, the commission may find that more or less information is required to obtain informed consent. For example, if the tenant has significant experience with oil and gas operations, the operator may not need to provide the same amount of information as would be required to obtain informed consent from a person who has no experience with oil and gas operations. Additionally, an operator may be required to provide information in a language other than English to an owner or tenant who is not fluent in English. So I read that, I apply the rule, I look at the informed consent that at least was provided to us in this application, and in this commissioner's opinion, the informed consent that was provided to us in this application does not meet the rules or the standards associated with informed consent, and may very well be what the stakeholders were most worried about when we talked about informed consent during the mission change rulemaking. So it's my opinion in this particular application that we need to review this under 604B4 rather than 604B1.
Ms. Jost, would you like to respond to the point being made by one commissioner, Commissioner Messner?
Sure, I'm happy to. And Commissioner Messner, thank you for your thoughts on this. There's a couple points on this. The informed consent that was sent and signed by the residential building unit owner is the ECMC template. I'm happy to pull it up if we need to pull that up. But that informed consent is subject to 604B1. The template utilized by the state is an example and a template, which is exactly that, to be utilized. MDS had numerous conversations with the residential building unit, both before and after the informed consent was signed. And as we stated, there is also a separate private contractual agreement between MDS and the residential building unit owner that, again, it's private. We can't talk about it here unless we went into executive session. But the informed consent did do exactly what this commission relies upon operators to do under 604B1. The informed consent was provided to the RBU owner. MDS had numerous conversations with the RBU owner. The RBU owner signed the informed consent, provided it back to MDS, and MDS submitted that with its application. Again, basing that informed consent on the ECMC template that was put in place after the 2021 mission change rules were in place. So MDS does believe this should be under 604B1 and not under 604B4. Because MDS has met the letter of basically the law as well as the regulations that require informed consent with an explicit written agreement with the residential building unit owner, which is what was provided with the permit. So thank you for the opportunity, Chair.
We perhaps bring up someone from staff to provide some perspective on this issue.
Give me one moment to locate the correct specialist.
Let's do this. Let's hold this question in abeyance. See if there's other questions that we could utilize the time while we try to identify staff. Other questions? Commissioner Oath?
Well, it's on the same topic, but I don't think it's for staff. I'm wondering if it's appropriate to ask if we can get a little bit more information. While we can't get information about the private agreement, it sounds like there were a number of verbal conversations that took place that perhaps elaborated on the type of information that Commissioner Messner is pointing out. The statement of basis and purpose and regulation intended to be provided. Are you able to provide some more information about the nature of that?
Chair, if I may.
Yes, please.
Great, thank you, Commissioner Oath. Mr. Dunn, can you please come on video? Thank you.
Yes, I'm here.
Mr. Dunn, did you hear Commissioner Oath's question about more information about the communications you've had with the residential building unit owner, both seeking the informed consent as well as recently?
Yes, I have met, I think my initial conversations with the landowner started in February of 2023. I've had several phone calls and have met in person with him and walked the location of our proposed pad location at least twice, and met with him twice kind of out on his property. So I've kind of been in constant contact with him since we signed the informed consent and afterwards.
And Mr. Dunn, during your conversations with the residential building unit owner, did you provide information about MDS's development plans, timing of development, as well as kind of the impacts in the area?
Yes, I did. I talked about the proposed haul route, and that was going to all stay to the west of his property. I also suggested that he could drive out to our other locations that were just a couple miles to the south of this location. He could get an idea of what, our pad size and drilling atmosphere looked like. So yes, we did talk about the potential impacts and noise that could result from the development.
Thank you, Mr. Dunn. And did you talk about timing of operations with the residential building unit owner that provided informed consent?
I did, yes. And I did make it clear that it was subject to approval of our permits and that they weren't defined, but same type of time frame that we're discussing now.
Thank you, Mr. Dunn. Commissioner Oath, I hope that helps, and I'm sorry to ask a couple questions in there. I appreciate the leniency.
Commissioner Oath, any follow-up?
No, thank you for that.
I'd recognize Amanda Petzold from ECMC, who's joined us. Hi there. The commission is having some questions with the applicant concerning the adequacy, efficacy of the informed consent letter. I look at the director's recommendation and it looked like you guys initially on December 22nd had some concerns about it. It indicated that there would be a new informed consent letter obtained. Do you have any perspective on any of this?
Hi, good afternoon, Chair. Can you hear me?
Yes.
Great. I'm happy to elaborate. Initially in my review, I asked for a revised informed consent letter, indicating my concern of the lack of information provided in the one that was submitted with the application. Then upon the resubmittal, they provided comment on their spreadsheet addressing my concerns that they were working to acquire a new one. And then in discussion with staff, we determined as submitted or resubmitted, it was not a complete application without that revised informed consent letter. And then that's when operator responded back, stating that legal counsel advised that it was an explicit agreement and that it was sufficient. So staff determined to move the application forward, reviewing the additional revisions as submitted.
I'm sorry, legal counsel, you mean your lawyer or the
No,
lawyer for the operator?
Operator's legal counsel.
And the operator's legal counsel said it was deficient or that it was efficient or okay?
No, their legal counsel advised that it was an explicit agreement between a private agreement between the operator and the RVU owner.
Okay, so then you just went forward with your analysis without further sort of debating the merits of whether this informed consent met our requirements or not.
Correct. It was determined it was best to review it and bring it in discussion with the DR and bring it to your guys' attention.
Okay, now go ahead.
Since then, we never received a revised informed consent letter.
Okay, Commissioner Messner.
So so I'm clear, Ms. Petzold. I'm looking at an informed consent letter from February 21st, 2023. Is that the informed consent letter I should be looking at?
Yes, sir.
Thank you.
Any further questions of Ms. Petzold, Mr. Cross?
Thank you, Mr. Chair, and thank you for helping us out on this. And maybe I'm looking at the wrong one here. I see the February 21st, but it was signed in March of 2023. Is that correct? I just want to make sure now that I'm looking at the right one.
Give me 1 second and I could pull that up for you. I can advise I only received one informed consent letter, one version. So no other version has been attached to a Form 2A since the initial submittal.
Just so we're all crystal clear, why don't you pull it up and share your screen?
And I guess maybe that would be.
It's the same one I'm looking at, Commissioner Crop. So
okay, and that's just what I wanted to make sure.
I'm happy to share my screen. I do have my notes all over, highlights and such, but would you still like me to share my screen?
Sure, we'll disregard the notes unless you have concern about your notes.
It's all in the DR.
Ms. Mercer?
Mr. Chair, I would suggest that perhaps if Commissioner Cross or Messner has a version that doesn't have internal deliberative notes, it would be better to view that instead.
I knew you were
Forgive
going
me
to
for
say
being
that.
an overcautious lawyer.
I'm looking at the one that's in the application packet on the website. So I mean, this is the one we have.
I hope everybody can see this and it looks like the correct one.
Okay.
But and again, my point of clarification was just I do see the February 21st, 2023 at the top, but it appears to be signed in March of 2023.
All right, thanks. I think you could probably stop the screen share. Ms. Petzold, we appreciate you being with us. We can let you go now. Further questions? Having raised the issue, Commissioner Messner, do you want to, I mean, as a threshold matter, do we want to take a vote on whether we think this can proceed under informed consent?
Yeah, I think that's appropriate, Mr. Chair. And, I note that, in the director's recommendation, it indicates that the, informed consent letter did not provide a contact person for MDS Energy. The IC letter referenced the OGDP as MDS 31 instead of MDS Energy 8-59 OGDP. The IC letter referenced the location name as MDS number 31 instead of MDS Energy 8-59. The IAC letter did not provide the local government permit type, name, number, and status information. The IC well did not indicate the number of wells, type of equipment, or on and off infrastructure related to the proposed development. The IC letter did not provide a description of each operational phase and its associated timeline of operations. The IC letter did not discuss site-specific BMPs planned for the proposed development. The IC letter did not provide an instructional information regarding ECMC and Weld County websites and how to access permit documentation. I also note, as I earlier indicated in the statement of basis and purpose, it's explicit in there how essential it is that people understand the potential impacts that they're agreeing to, and the necessary information needs to be provided in the form consent letter in a level of detail so that the person can actually determine whether or not they've have willingly provided informed consent. And I just don't find that level of information in here, as did the director in her recommendation indicated it wasn't there. So, from my opinion, the efficacy of these informed consents and the contents associated with them are an essential part of reviewing this under 604B1 and essentially the exemptions allowed by that versus reviewing it under 604B4 to ensure its protection of public health, safety, welfare, the environment, and wildlife resources. And so to that, I'm happy to make a motion that we review this under 604B4 rather than 604B1 due to the inadequacy of the informed consent and unwillingness of the operator to provide additional information.
All right, we've got a motion on the table. Do we have a second?
I will second that, Mr. Chair.
Do we have discussion on the motion? Commissioner Cross?
Thank you, Mr. Chair. And I agree this is appropriate to talk about. I do want to highlight a couple comments on this. When reviewing the informed consent letter, I do see contact people, and I apologize on the first name. I believe it's CG Chaparro with the phone number, and Jim Jacobson, who's on the hearing today, are the primary MDS contacts. So I do see that. I see part of the information, and I think this is helpful to talk about. It does indicate that Will County Oil and Gas Energy Department is the appropriate local government, which was one of the concerns. However, I don't see the WOLA permit type name or number for that. I believe it does mention the 7 wells. But not all of the equipment. And then just try to compare this to some of Ms. Petzold's comments as well. And again, I don't fully see each description of each operation phase and timeline. But I thought it would be appropriate to at least point out some of those issues. Some of what is included and some of what is still missing.
All right. Now, I appreciate that, Commissioner Cross. And I would point out that we've never had this issue come up. As I read our rule, it says that the owner has to explicitly agree with informed consent. The list of things that are in our SBP is not the rule, but more guidance. So I think this is, in my opinion, sort of cutting hairs one way or another. It's obviously easier if we just get the form template done. But I do know that some folks don't like to be bothered by oil and gas over and over again. So it makes it difficult for all of us. Commissioner Oath, did you want to weigh in?
Well, I think actually what you were just saying, Mr. Chair, is helpful. And actually, I was going to say help me out with you all's experience on this from the past, but it sounds like this is the first time it has come up. But I was thinking along those same lines. So the rule itself, the regulatory language is quite broad and vague. I think the statement of basis and purpose language that you read, Commissioner Messner, is helpful. And so it sounds like the items enumerated in the director's recommendation to be missing, is it really like a side-by-side comparison of the items that were in the SBP? And so are we sort of looking at this as therefore those are requirements, or can you help me understand how you're looking at that?
Yeah, my understanding is that the items that were enumerated are from the SBP, and sort of best practices, you would have those sorts of things. But again, the rule doesn't explicitly require them. And I think we also need to look at the evidence and testimony from the applicant in terms of what discussions were had, how often they were had, et cetera, to help frame our understanding of whether we can use 601B1 here or not. Commissioner Messner?
So appreciate this. The guidance documents that were developed and the template that was developed utilizing the information provided in the statement of basis. And so the template that was developed and the requirements or the elements that are associated with that template are tied to the statement of basis and purpose. The statement of basis and purpose fleshed out the intent of the rule, and the rule is vague, and we did all of this on purpose during the mission change rulemaking. It's not guidance, the statement of basis and purpose. It actually provides intent to the rules, and the rule and the statement of basis and purpose need to work together to collectively interpret and determine what rules and how rules get applied. And so, I mean, listen, I don't want to have this conversation. This is the only time we've ever had this conversation, and the operator certainly had an opportunity to resolve this situation prior to it coming to hearing and chose not to. And so I don't feel like I have any choice but to apply the rules as I think are properly applied and make a determination of what rule to review this under. I'm not trying to use this as any type of penalty or anything like that, but I have to be able to apply certain rules appropriately and consistently. So that's why I'm doing it.
Well, and I agree with that. I also would note this commissioner looks at the language of the rule as being controlling, and looking at the language of the rule as well as the evidence presented by the applicant, I think helps inform. I think the better practice, obviously, is to do all of the bells and whistles. But I think I guess my concern is I don't want to create a new rule today by having a vote on something that says, herefore out, you can't do informed consent unless you do everything within the SBP. I think our rule is more fluid than that. Commissioner Ackerman, then Commissioner Messner.
Thank you. And I don't mean to interrupt the conversation here, Mr. Chair. And I think you made all the points that I was going to make. I think that, I mean, if we wanted to go down that road and actually talk about a vote, I do think it would be prudent to hear from AAG Mercer on the interpretation of this issue. I also lean towards the direct interpretation of the rules as informed by the basis and purpose statement, but not necessarily mandated by the statement of basis and purpose statement, as you've talked about, Mr. Chair.
All right, we've got a motion, and I believe we had a second. We're in the discussion stage of that motion. Is there any further discussing that folks want to do? Commissioner Oath.
Well, yeah, unless I misunderstood, I was interested in what Commissioner Ackerman just suggested as well, of getting some interpretation from AG Mercer. AG
Mercer, do you want to provide us interpretation here or in an executive session or both?
You've read my mind, Mr. Chair. I think that would be an appropriate conversation for executive session. And I'm happy to read us into one if that's the commission's desire.
Read away.
All right. Pursuant to the open meetings law, the commission is entitled to enter into executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statute Section 2464023A2. The topic of the executive session will be interpretation of the 604B1 informed consent requirement. And with that, Mr. Chair Robbins, I invite you to encourage a motion to enter into executive session for that purpose.
I not only encourage it, I so move.
Second.
Motion and a second to go into executive session. All those in favor signify by saying aye.
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 Aye. Any opposed? All right, I'm going to give my spiel here, but first I'm going to tell Hearings Manager Thomas or Hearings Manager Amaro, send us an e-session link ASAP, please. With that, folks, we're going to go into executive session as noted by AAG Mercer. We're allowed to do this. We're going to receive legal advice on this issue. We will not make any decisions in executive session. After, we'll go to a different Zoom link for the e-session. Once we're done, we'll come back here. I can't imagine this is going to take more than 10, 15, 20 minutes, something like that. So just stick around on this Zoom call and we'll be back here as soon as we can. Thanks. All right, this is the Colorado Energy and Carbon Management Commission. It is Wednesday, August 7th. It's 3:41. We are still operating under docket 231100348. We just attended an executive session. I would call upon AAG Mercer for whatever script she needs to play out now.
Thank you, Mr. Chair. As you noted, we are returning from executive session. During executive session, the commission received legal advice on the standard for informed consent under Rule 604B1. No decisions were made and no votes were taken. So I would invite you, Mr. Chair, to encourage a motion to exit executive session.
I so move.
Second.
Motion and a second to exit executive session. All those in favor signify by saying aye. Aye. Any opposed? We are back in the main session. Do you need to do anything further, AAG Mercer, or can I just move on? All right. Procedurally, we are at a point in this hearing in which we have a motion on the table, which motion, if I understand it correctly, is a motion to make a finding that the informed consent letter is insufficient, and therefore that we should be considering this under 604B4 substantial equivalence. Commissioner Messner, did I reiterate your motion correctly?
That's correct, Mr. Chair.
And we have a second from Commissioner Ackerman. Is there further discussion on the motion? All right, Commissioner Cross?
Thank you, Mr. Chair. I'll just quickly say I did look up and find the template that we have online, and I do believe it is the template that was provided online, with the one exception, it doesn't include the WOVA permit name and number.
The template online or the letter that we're debating?
The letter we're debating does not have the WOVA permit name and number, and that's the only difference between the template online and the letter we received.
Right, and I looked at the letter as I was zooming back and forth between Zoom sessions, and I too believe the letter is not as deficient as I initially understood based upon my review of the director's rec, but it's not perfect. So I think it's a close call. Further deliberation, Commissioner Oath?
I think I've come to the opposite conclusion. I feel like the rule requires informed consent. It is up to us to decide what that means. I do think that the statement of basis and purpose is very helpful to provide some intent about how to interpret that. And I find that it does not meet the requirements to provide informed consent from my perspective. However, I'm a bit uncomfortable with the second part of Commissioner Messner's motion about the conclusion as a result of that. So just would state that then it means that we would be considering the matter under 604B4.
Okay, and I too will err on the side of caution and will likely be voting in favor of the motion. I would suggest to commissioners that if the motion remains with the and review it under 604B4, that the appropriate next step would probably be a motion to stay consideration of the application to give the applicant an opportunity to prepare a 604B4 case, because the applicant prepared a 604B1 case. But that's maybe getting ahead of ourselves before we vote on the motion. Commissioner Oath?
Well, I was going to suggest another potential outcome is asking the applicant to just provide an updated informed consent.
I think the applicant would have the opportunity to do either. So yes, I mean, that 604B1 remains an option. B2, B3, and B4 all remain options. It's up to the applicant to determine. Commissioner Ackerman, did you want to weigh in?
I do. Thank you, Mr. Chair. Since we are sharing a few thoughts on this, I find that the applicant likely did follow informed consent. I'm a bit of a dissenter, it sounds like, so far. I base that mostly on the fact that they did follow our template that we've published online almost entirely, and that the deficient information from the director's recommendation was information from the basis and purpose statement, which by my understanding is not technically required by the regulation itself. So while I do believe that it should include all of this information, I believe that there was technical compliance and will likely be a no vote on this motion.
Further discussion? All right. AG Mercer, are you visualizing to take a roll call?
I can do that. I also wanted to just clarify the motion to make sure it's clear on the record if I could.
Please do.
And so from my understanding, this is a motion to stay consideration of the application to allow the applicant time to either provide an updated informed consent letter to continue seeking approval under 604B1 or prepare their case to seek approval under 604B4 substantial equivalency.
Don't know that's the motion on the table, but I like that motion a whole lot better if you want to have some friendly amendments to what actually is on the table.
Was it? I'm sorry. It was.
I will modify my motion to comply with what AAG Mercer indicated, unless it's more appropriate to do two motions. But if we wanted to combine it in one motion, I think that's appropriate.
All right, so friendly amended. Commissioner Ackerman, do you friendly second that amendment?
Yes, second.
All right, let's do a roll call. AAG Mercer?
Thank you, Mr. Chair. Commissioner Ackerman?
No.
Commissioner Cross?
No.
Commissioner Messner?
Yes.
Commissioner Oath?
Yes.
Commissioner Robbins?
Yes.
By a vote of
Motion.
3-2, the motion to stay has passed.
All right, Ms. Jost, are you may not be happy with the result, but do you understand where we're at with regard to this matter? That it has been, that the informed consent letter has been determined to be deficient, that you have and your client have opportunities to take the different paths that are available, 604B1, 2, 3, and 4, and we will allow this matter to be stayed, and we will reconvene this matter at an agenda once you and your client have had a chance to determine your next steps.
Yeah, thank you, Chair. Yes, we understand the direction, or I should say the directive here with respect to the outcome of the motion. Just for clarification, this would be a presentation to the commission based upon either 601V1 with another informed consent, or 604B1 or 604B4 with another presentation. And if that's the case, we would like to try to do this in the next 2 to 3 weeks so we can try to keep MDS on its development schedule for this year.
AAG Mercer, at times back when I was a local government lawyer, we would continue something to a date certain. If we don't do that, can we just put it on the next available agenda once MDS determines its place it wants to go, or is it better to kick this to, say, a certain hearing date?
I would actually refer that question to Hearings Manager Thomas, as he's got a better handle on the commission's calendar than I do.
Hearings Manager Thomas.
I believe we can accommodate this in the next couple of weeks if the applicant is prepared to do so.
What are some dates?
Even next week, the 14th or the 21st, and probably the 28th as well. I think we would have time for this on each of those dates. After that is the cumulative impacts rulemaking.
Yeah, we want
more
to
difficult.
Ms. Jost, do you want to pick a date, or do you want to get with staff at a later time?
Chair, I think August 21st, if we could hold that date, that would be great.
All right.
Thank you.
Do we need to do another motion on that, AAG Mercer, or can the record just reflect it? I think we've already stated, but we didn't pick a date.
I think the record can reflect the date that was just selected.
All right. With that, we will dismiss docket 231100348 until this August 21st. We'll put it first on the agenda that day so that we can finalize consideration of this docket. All right, we're now going to move to docket 240300062, an oil and gas development plan involving Desert Eagle Operating LLC. If we could raise Ryan McKee as attorney. Good afternoon, Mr. McGee.
Good afternoon. How are you?
Tired? How are you?
Yes, long day.
Let me provide some context for this application. We've all reviewed it. We've all reviewed the application. I'm not prejudging it, but it seems to be a pretty straightforward addition of some wells to an already existing helium pad. I would suggest that do whatever you do need to make your record, but it's not necessary for this to be in my opinion, a lengthy dialogue on all this.
Understood.
Having said that, Ms. Mercer, can you swear in the two witnesses?
Thank you, Mr. Chair, and good afternoon to the panel. I'll just ask you each one at a time to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Brodsky.
I swear to tell the truth.
Thank you. And your name for the record?
Gwen Brodsky.
Thank you. And Ms. Callahan? Or O'Callahan? Oh, you're on mute.
I was trying to be quiet. It's Deidre O'Callahan. I do promise to tell the truth.
Thank you.
All right, you're recognized, Mr. McKee.
All right, Jill, can you go ahead and start the presentation? All right. Well, good afternoon, commissioners, staff, and members of the public. My name is Ryan McKee, and I'm a shareholder at Beatty & Wozniak, and I'm here today on behalf of Desert Eagle Operating LLC and docket number 240-3000062, which is an application for the Second Amendment to the existing Red Rocks oil and gas development plan. Through this application, Desert Eagle proposes to add 5 new oil and gas locations and 5 new vertical wells for helium development from the Lions Formation in the Precambrian crystalline basement. Next slide, please. With me here today is a panel of experts from Desert Eagle who will be available to answer any questions the commission may have following our presentation. Desert Eagle is currently operating 6 helium wells in Colorado pursuant to the initial and then the first amended Red Rocks OGDP. The initial Red Rocks OGDP was unanimously approved by the Commission on November 17th, 2021. The Red Rocks OGDP was and will continue to be comprised of 880 acres of unspaced rural fee lands owned by a single surface owner in Los Animas County, Colorado. Pursuant to the initial Red Rocks OGDP, 2 oil and gas locations were approved and constructed. 2 wells were authorized to be drilled within the OGDP, with 1 well at each approved location. These wells have been drilled and are currently producing helium. After the successful production from the 2 initial Red Rocks helium wells, Desert Eagle filed an application to develop 4 additional vertical helium wells for 4 new oil and gas locations within the 880-acre Red Rocks OGDP. The First Amendment of the Red Rocks OGDP was unanimously approved by the Commission on April 19th, 2023. And 4 additional wells authorized within the amended OGDP have been successfully drilled. As a result, there are currently 6 wells producing helium within the Red Rocks OGDP from 6 oil and gas locations. This application for the Second Amendment to the Red Rocks OGDP was filed on March 7th, 2024, following pre-application consultations with Commission staff. Desert Eagle appreciates all of the Commission staff's time and effort in processing and reviewing this application. The application before you today requests approval of 5 additional locations and the associated Form 2As within the Red Rocks OGDP for a total of 11 oil and gas locations within the Red Rocks OGDP. The 5 additional locations are the Red Rocks 1-09, the Red Rocks 1-15, the Red Rocks 35-01, the Red Rocks 35-08A, and the Red Rocks 35-10. The application also requests authorization to drill a single well at each new location for development of helium from the Lions and the Precambrian crystalline basement. The Red Rock OGDP complies with all substantive and procedural requirements of the ECMC rules. Notice was provided to all interested parties as required by the rules, and no comments or protests were received. Next slide, please. The Red Rocks OGDP will continue to consist of approximately 880 acres of land in portions of Section 1, Township 30 South, Range 55 West, and Section 35, Township 29 South, Range 55 West. The Red Rocks OGDP lands are comprised of fee mineral interest, which are covered by leases owned by Desert Eagle. As with the prior developments within the Red Rocks OGDP, there is no request to space the lands, as each well will be drilled on a lease basis within the Lions in the Precambrian crystalline basement in compliance with Rule 401B well location requirements. Each of the 5 proposed locations is located on fee surface, which is owned by a single surface owner and subject to an SUA between the owner and Desert Eagle. Each of these locations will cover approximately 1.1 acres during well drilling and will then be reduced to approximately 0.2 of an acre after interim reclamation. With that overview, I will now pass the presentation over to Gwen Brodsky to provide you with a full overview of the application, locations, and the proposed best management practices to avoid and minimize impacts from the proposed operations.
Thank you, Ryan. It'll be full, but it'll be very brief. I think I can give a flavor of the locations in 4 minutes or less. The Red Rock setting is very rural and isolated rangeland. Nonetheless, Desert Eagle conducted a full environmental field survey in November 2023, looking at land uses, residences, water resources, wildlife, vegetation, and soil pits. And the nearest house is approximately 3 miles away. There is no high priority habitat. There is no immediately down gradient surface water. The area doesn't meet any criteria for alternative location analysis. And on the next slide, we illustrate that each location will have 1 well. It will be a conventional vertical well up to 1,900 feet deep, drilled with a water well sized drill rig like this photograph. Desert Eagle will drill with air rather than mud. There will be no hydraulic fracturing or stimulation. And the currently producing wells continue to demonstrate there are no hydrocarbons or produced water in these wells, so there will be no tanks on the locations. And in the next slide, we show that durations will be brief. It's a matter of days to prepare the well pad, drill and complete, and by complete, we mean cement casing. This will be followed by interim reclamation, and then the wells are expected to produce for 10 years. And during production, each location will have just a wellhead inside of livestock fencing. And then Desert Eagle will add new segments of buried 8-inch off-location flow line to its current gathering system. And helium gas will flow from the wellhead to that helium processing unit that's already in operation. It's located just south of well site 113, and it's owned by Desert Eagle. There, at the helium unit, helium gas is concentrated, it's compressed, and loaded onto tube trailers to transport by truck. And currently, transport is once about every 2 to 3 days. And then regarding involvement from others on the next slide, Desert Eagle works closely with the surface owner on its development plans, new locations, and their timing. All notices were provided to mineral owners. There were no public comments or petitions filed. Los Animas County doesn't regulate siting for the locations, but it does require oil and gas locations and bonding. The county uses a copy of the Form 2A for its 14-day administrative review of locations. And Desert Eagle submitted the applications to Los Animas County on July 24th. The county approved all the locations on August 5th with no conditions. And in this last slide that I have, just on best management practices, we already described a few things to avoid and minimize impacts like air emissions, but some other highlights are that each location during production will have approximately just 8 round trips per month using a pickup truck. Spills will be avoided during drilling using a liner under the drill rig motor, a double-walled fuel tank on the drill rig, and a tank to contain drill cuttings. During production, the locations are tankless. The wells need fresh water only for cement and a water mist system for dust suppression during drilling. Each pad footprint is small at approximately 1 acre. And at this point in Red Rock's development, Desert Eagle is just adding spurs using the Red Rocks access roads and gathering system. Drilling will occur during daylight hours. Locations are not lit during production, and there are no nearby houses to be impacted by noise. So I will turn this back to you, Ryan, to conclude the request for approval.
Thank you, Gwen. Based on the information we presented today and that presented in the application for the Second Amendment to the Red Rocks OGDP, and in accordance with the director's recommendation, Desert Eagle would like to request that the commission approve the Second Amendment to the Red Rocks OGDP following your deliberations. And in order to keep this brief, we'll go ahead and conclude our presentation today, and we thank you again for your time.
Appreciate the presentation. Questions to the panel from commissioners? Seeing no questions, we move into deliberations. Does any commissioner desire to initiate deliberations? Commissioner Messner?
Mr. Chair, I'll move approval of the application as presented.
Motion and a second. Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you very much.
Thank
And
you.
thanks
Thank
to
you,
staff for their work on this as well. All right. That concludes the agenda of the Colorado Energy and Carbon Management Commission for Wednesday, August 7th. Do we have a motion to adjourn?
So moved.
Second.
Motion and the second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We're adjourned. Thanks, everybody. Good work.